Pam, are we ready to go as far as you're
Yes,
concerned?
sir.
Okay, I'll just wait a minute here till my watch hits 9 o'clock, which it just did. So uh, let's go on the record at this point.
Okay.
The first order of business this morning is to have the translators give translation instructions in both English and Spanish. So if they would proceed at this point to do that, please.
Thank you, Rosa Maria. Ms. Corral, you can take down the welcome slide now.
The welcome slide is still on my screen. I'm waiting for it to be removed to start.
Okay, thank you. Yeah, there you go.
Okay, thank you. This is the second day of a public hearing in Environmental Improvement Board case number 21-48 in the matter of the petition for hearing on air quality permit number 8585, Earth Care New Mexico, and Linda Marianello petitioners versus the New Mexico Environment Department and Associated Asphalt and Materials. My name is Richard Virtue. I'm the hearing officer. We are going to start with technical testimony from the Environment Department. And then we will proceed to at least start with rebuttal if we have time today. We will have public comment at approximately 1 o'clock and approximately 5 o'clock. If members of the public wish to testify during those sessions, they can send the host a chat message and you will be included in the list. Please specify which session at which you would speak. You can also email the host at pamela.jones.nm.us. Did I get that right, Pam? Okay, pamela.jones.nm.us. There is one preliminary matter, excuse me, I'd like to address if folks are ready, and that is we had 2 exhibits submitted by the Environment Department this morning. Those are NMED exhibits 27, I guess it's NMED EIB exhibits 27 and 28. Have the petitioners had a chance to review those?
We have, Mr. Hearing Officer.
Do you have any objection?
No, Mr. Hearing Officer.
Okay. Does anyone else have an objection to admission of NMED EIB exhibits 27 and 28? Okay. Hearing and seeing none, those are admitted. So we will now turn to presentation of the Environment Department's technical testimony. Mr. V. Hill, please proceed.
Thank you, Mr. Hearing Officer. I have one preliminary matter that I wanted to raise, and I haven't discussed this because it was late. I didn't want to bother anyone. But I have, uh, in response to a member Trujillo Davis's question, we have an additional witness that will not, we're offering an additional witness that will not touch on any matters in this hearing properly. Excuse me, my phone is ringing, and it's too far away from me to turn it off. Anyways, so um, this witness will just be addressing the member's question, and I think it's appropriate to give the petitioners an opportunity to weigh in on whether or not that's acceptable.
Do the petitioners have any objection to proceeding in that way?
Mr. Hearing Officer, members of the board, I'm kind of curious as to the scope of Mr. Feather's testimony. My understanding is that I think it was member Trujillo Davis who asked the question about AVO monitoring, which to my understanding isn't implicated in this proceeding, that only method 9 of visual and method 22 of visual visual tests of opacity are involved. So I'm kind of curious as to if we could get at least some idea of the scope of Mr. Feather's testimony.
Hey, Mr. Vigil?
Yeah, it's going to be only limited to answering the question. It's not going to touch on any of the substantive matters, and Mr. Feather, who's the witness, will not opine on any of the, anything that's on the table, in this hearing. So he is not he's not a technical witness, and he's only being offered as a fact witness just for this. And I expect his testimony to, on my end, to last maybe 30 seconds to a minute. And then if any of the members have questions strictly related to his, very, very brief direct examination, and you can always, cross-examine him and voir dire him as well. So this is strictly just to answer a question, and I understand your concerns, and anyways, I'll leave it at that.
I don't think that we have an objection to that.
Okay, then we will allow Mr. Feather to testify within the scope described by Mr. Vigil. Mr. Vigil, you can proceed with your technical witnesses.
Thank you very much. Mr. Hearing Officer, Madam Chair, members of the board, the Air Quality Bureau is here today to provide direct technical and rebuttal testimony in support of the recommendation that the board uphold the department's decision to issue permit 8585, which was issued in accordance with the Air Quality Control Act and associated state and federal regulations for issuing air quality construction permits. The challengers that petitioners are bringing in this matter do not provide a reasonable basis for the reversal of the department in this matter. In this hearing, we've heard a lot of testimony by the petitioner's witnesses, all of which is designed not to bring substantive challenges to the permit, but rather to muddy the water and create doubt in the hearing officers and the board members' minds. None of the testimony presented yesterday by the petitioner's witnesses provide any reasonable basis on which the board could reasonably reverse the department's decision, nor has any of that testimony revealed any violation of any state or federal statute or regulation. Petitioners originally brought 3 challenges in their petition. First, petitioners allege that the department's decision approves a definition of ambient air that's contrary to law. However, the exact opposite is true. As the department explained to the board in its answer to the petition, and as our witnesses will testify to today, the definition of ambient air used by the department mirrors that of the United States Environmental Protection Agency, and the rules promulgated by this very board. The petitioners have not shown otherwise. Second, petitioners allege that the air dispersion modeling relied upon in issuing permit 8585 was deficient. This is not the case. However, to create doubt in the hearing officer and the board's members' minds, the petitioners offered testimony that was academic and divorced from the practical reality of environmental protection. The testimony attempted to create a simplistic, idealized view of statutory and regulatory requirements that ignore the law and the very real considerations that go into crafting a permit that is protective of human health and the environment. The reason why petitioners' witnesses painted an unrealistic and academic view of air dispersion modeling is because petitioners are asking this board in this hearing to engage in an unlawful rulemaking, to change the air quality standards just for one permit, permit 8585. Yesterday, we heard Dr. Clark admit that the emissions in the permit do not exceed the air quality standards. What Dr. Clark is asking, and he asked this in his testimony, is that the board reverse the department because the facility could hypothetically exceed the standards in the future, or exceed the standards. Let me put this, or that the permit would be in non-compliance if in the future there were some rulemaking that lowered the air quality standards. Under Dr. Clark's view, no permit could ever be issued because a hypothetical future exceedance will always be possible. And the board should decline to adopt this precedent. Dr. Sahu admitted that AP 42 is commonly used across the United States as a source of emission factors. And he also admitted that the department's definition of ambient air is more restrictive than the EPA definition, and that the department's allowance of the removal of non-ambient air from the modeling was in accordance with the EPA guidance. Mr. Schneider acknowledged that this permit is much more protective than the currently existing permits held by the permittee. In other words, Mr. Schneider's testimony confirms the department's testimony that was given at the administrative hearing, that this permit is the most protective asphalt plant permit that the department has ever issued. There was a third challenge brought in this petition, a federal civil rights challenge in which the petitioners were asking this board to unlawfully reverse the department under federal law. In fact, in their statement of intent, petitioners brought a second civil rights claim. As the board members may be aware, the hearing officer has rightly ordered that these federal claims will be excluded from this hearing because the petitioners offered no legal basis for the board to exercise jurisdiction over federal claims. But petitioners request that the board unlawfully adjudicate a civil rights claim that should be instructive, and the board should keep this in mind when listening to petitioners and considering petitioners' expert witness testimony. Because taken as a whole, petitioner's entire case can be summarized like this. Yes, we know that the permit was issued in accordance with the law, but we just wish it was different. They want the board to reverse the department over a preference, not over the law, over a preference. They prefer that the permit was different. Petitioners are well aware that permit 8585 was issued in accordance with the law. They just disagree with the law. They want the standards to be lowered, and they're asking the EIB to do that here. Despite all the academic hypothesizing, the reality is that the petitioner must prove by a preponderance of the evidence that they're entitled to the relief sought in the petition. They've not done so. Instead, they've chosen to ask the EIB to lower air quality standards so that permit 8585 can be denied. Just as the petitioner would have this board unlawfully adjudicate civil rights claims, they're asking that this board engage in unlawful rulemaking. The board should not do so. In this matter, the department will offer witnesses whose testimony will show that the Air Quality Bureau gave a thorough and complete administrative and technical review for permit 8585, and that the technical review ensured that the permit meets all the legal and technical requirements under the Air Quality Control Act and associated regulations, and is protective of human health and the environment. The Air Quality Bureau has a serious statutory and regulatory responsibility to protect the environment and human health. That's their job. It is not an academic or platonic exercise. And the Bureau's testimony in this matter will show that they take this role seriously. The department respectfully requests that the board pay close attention to what the petitioners are attempting to do, to listen carefully to the department's witnesses and uphold the department's decision to issue Permit 8585. Thank you. And with that, the department calls its first witness, Kathy Prim.
Good morning.
Can we have Ms. Prim sworn in, please? You swear to tell the truth, the whole truth, and nothing but the truth, Ms. Prim?
I do.
Can you state your name for the record?
Yes, it's Kathleen Prim.
And where are you currently employed?
I'm employed by the Air Quality Bureau of the New Mexico Environment Department.
What is your job title?
I'm a supervisor in the minor source unit of the permitting section.
And what are your job responsibilities as a supervisor?
I manage assigned staff in the minor source permitting unit in regulatory and technical activities, including their review of air quality permit applications and their development of enforceable air quality permits. I also coordinate with various stakeholders, including the public, industry, consultants, other agencies across the nation, and internal colleagues here at the Air Quality Bureau.
And how long have you worked in the permitting section?
I have worked in the permitting section since June of 2008. Prior to becoming a supervisor last April, I was a permit writer at the Bureau for about 13 years. I reviewed air quality permit applications for administrative and technical completeness and accuracy, and coordinated with the public, industry, consultants, Air Quality Bureau staff, and other regulatory agencies to provide quality customer service during the permitting process. If a proposed facility met air quality regulations and standards, I issued a legally enforceable permit that specified all applicable state and federal regulations, as well as the emission limits that applied to the facility.
In your time with the Bureau, how many air quality permitting actions have you worked on?
I have worked on over 600 permitting actions.
Could you briefly describe your educational background?
Yes, I have a Bachelor of Science degree from New Mexico State University.
I want to bring your attention to NMED EIB Exhibit 1. Is this a copy of your latest resume?
Yes,
And did you submit pre-filed direct written testimony for this hearing?
yes, it is NMED EIB Exhibit 1A.
Do you have any corrections or additions to your testimony that you'd like to make at this time?
No, thank you.
Do you adopt your written testimony in its entirety?
Yes.
Could you provide a brief overview of your testimony?
Yes, my technical testimony begins with my qualifications and a summary of Permit 8585 for Associated Asphalt and Materials, or AAM's, Santa Fe facility. My testimony then describes the review of Application 8585. This review is presented in two parts. The first part is the administrative review, which was the initial review that confirmed all the required parts of the application were present. The second part is the technical review, which included verifying emissions calculations and determining which federal and state regulations applied to the facility. In my testimony, I describe the public outreach done for this hearing before the EIB and provide overviews of construction permits, EPA's AP42 emission factors, and the basis for permit conditions. My testimony explains that for the March 2021 public hearing for the Santa Fe facility, Bureau staff created outreach documents and notices of hearing in English and Spanish and designed the March 2021 public hearing to facilitate full participation of individuals with limited English proficiency, or LEP, community members.
Okay, thank you. And Mr. Hearing Officer, I offer Ms. Prim as a technical witness in this matter, subject to the petitioner's comment.
Okay, her written testimony will be admitted. That would be Exhibit 1, and her qualifications in 1A are her pre-filed direct testimony.
Mr. Hearing Officer, can I ask Mr. V. Hill to qualify Ms. Prim as a particular kind of technical expert? In other words, areas of expertise?
I think we just did that. If Mr. Jantz wants to voir dire the witness, I think that's fair.
No. I'm not, Mr. Hearing Officer, I'm not asking to necessarily voir dire the witness. She was just offered as a technical witness, and I'm curious as to what the Environment Department sees as her sphere of technical expertise.
Well, it's my recollection that about 25 seconds ago, she went through her education. She said she had done over 600 permitting actions, gave her educational and experiential requirements. I'm not sure what else you want, but like I said, if you have more questions, you can voir dire her.
So, Mr. Hearing Officer, that being the case, we object to this witness on the basis that we don't have any sense of what her areas of expertise are being offered for.
I've already admitted, well, I will reaffirm the admission of her testimony. I think her qualifications speak for themselves.
Thank you. Ms. Prim, what is the function of an air quality construction permit?
An air quality construction permit places restrictions on what construction is allowed, what air emission limits must be met, and how a facility can be operated. A permit is an enforceable legal document that an industrial facility must comply with. To assure that a facility complies with the permit's emission limits, a permit contains monitoring, record keeping, reporting, and testing requirements. If Air Quality Bureau staff determines upon reviewing a permit application and air quality analysis that a facility will not meet the requirements of air quality regulations and standards, a permit will not be issued.
What was the purpose of the permit application in this matter submitted by Associated Asphalt?
Application 8585 was received by the Bureau on November 26, 2019. I began receiving phone calls about this application in December of 2019. And while speaking with concerned citizens on the phone, I realized many thought the proposed Santa Fe facility in application 8585 would be moving into a location that did not already have an active asphalt facility. 86 Paseo de River is the location for the Santa Fe facility. This location is in an area zoned for industrial facilities, and it already had an existing hot mix asphalt plant operating there since 1997. That existing hot mix asphalt plant is called HMA number 5 in the application and permit. It had already been at this location for more than 20 years when application 8585 was submitted. AAM's crushing and screening plant was already operating just west of this site. With application 8585, AAM was requesting to move equipment operating at 2 other sites in Santa Fe to 86 Paseo de River to reduce its number of sites, consolidate its operations, and close 2 existing permits upon startup under this new permit. AAM's HMA number 2 facility already had an air quality permit to operate nearby at 3810 Oliver Drive since 1974. The consolidation of AAM's facilities would be moving HMA number 2 farther from existing neighborhoods. Because line power would be available at 86 Paseo de River, some existing generators at AAM's Oliver Drive location would be eliminated, reducing noise and combustion emissions. The new permit would replace old permits and add more stringent conditions with updated requirements for monitoring, testing, record keeping, and reporting. At the March 2021 public hearing, Bureau staff testified that the new AAM permit would be an improvement over the two old AAM permits for existing asphalt facilities HMA number 5 and HMA number 2.
Can you give a brief overview of the new permit, permit 8585?
Yes, permit 8585 consolidates 4 existing facilities into one permit. Under the old permits, 1 asphalt plant on Oliver Drive.
Ms. Prim, sorry to interrupt you. I just want to make it clear. How many permits are consolidated into this new permit 8585?
Well, there are 4 facilities that are being consolidated into 8585. 3 of them had existing permits. 1 was a little scalping screen that did not have a permit already prior to 8585. It's a very small facility on its own.
Okay, sorry for interrupting you twice. Proceed.
That's okay. Let's see. So as I was saying, under the old permits, 1 asphalt plant on Oliver Drive was operating closer to homes. Moving this asphalt plant across the highway to the new location on Paseo de River alleviates the impact of HMA2 on the community in near Oliver Drive. Excuse me. Permit 8585 authorizes 1.3 million tons of annual throughput compared to the 2.3 million tons of annual throughput allowed in the old permits. This equals a 44% reduction in annual throughput and a commensurate decrease in emissions. The old permits for both hot mix asphalt plants are decades old and have fewer requirements. Permit 8585 has more stringent requirements for monitoring, testing, record keeping, and reporting. It includes conditions for initial compliance tests for the drum dryers and mixers, mineral filler silos, and the crusher screen plant generator. Permit 8585 includes requirements for data loggers to continuously record the temperature of the asphalt mix in each asphalt silo and the asphalt cement in each asphalt cement storage tank. Permit 8585 includes a requirement for each drum dryer and mixer bag house to be equipped with a differential pressure gauge with a data logger to continuously record each gauge's differential pressure and an automatic audible alarm alerting the operator if the differential pressure is out of range. These initial tests and ongoing records are a few examples of ways AAM must demonstrate it is operating in accordance with the representations in application 8585 and following the requirements of permit 8585 to stay within the established emission limits.
Can you explain what emission factors are?
Yes, emission factors are used in calculating emissions. They are representative values that relate the quantity of a pollutant released to the atmosphere with the associated activity that releases that pollutant. These factors are usually expressed as the weight of pollutant divided by a unit of weight, volume, or distance, or a duration of activity. So the general equation for estimating emissions is the activity rate multiplied by the emission factor. The emission factors used in application 8585 calculations are from the EPA's AP42 compilation of air pollutant emissions factors, as well as EPA Tier 1 emission factors and EPA Tier 4I emission factors. The emission factors used in the calculations are appropriate for this source type and are approved by the department. The approved calculated emission rates were used as inputs into the Bureau's air dispersion modeling analysis.
Page 3 of the appeal petition describes petitioners' concerns about the use of AP 42 emission factors. Can you tell us a little bit more about AP 42 emission factors specifically?
Yes. So EPA's AP 42 compilation of air pollutant emission factors has been published since 1972 as the primary compilation of EPA's emission factor information. The emissions factors have been developed and compiled from source test data, material balance studies, and engineering estimates. AP 42 emission factors are widely accepted by many agencies in the United States. The department's answer to the appeal petition filed on September 24th, 2021 explains Bureau staff confirmed that along with New Mexico, the city of Albuquerque, which is its own entity, and the states of Arizona, Hawaii, Idaho, Iowa, Minnesota, Nevada, Oklahoma, Oregon, Texas, Utah, Washington, and Wyoming use AP 42 as a source for calculating emissions. Evidence is provided as NMED Attachment 1 in the department's answer to the appeal petition. Additionally, the department's statement of intent provides emailed responses the Bureau received from air experts at Albuquerque Bernalillo County Air Quality Program, Arizona Department of Environmental Quality, Colorado Department of Public Health and Environment, and Utah Division of Air Quality, confirming their acceptance of initial emissions calculations based on emission factors and methodologies from each of the AP 42 sections used to calculate emissions in application 8585. These emails are NMED EIB Exhibit 15.
How does permit 8585 ensure that the emissions from the Santa Fe facility do not exceed the emission levels represented in the application and application updates?
First, AAM is required to operate the facility as represented in the application and application updates. The failure to operate the facility as represented in the application and updates would be considered a violation of the permit and would be referred to the enforcement section of the Air Quality Bureau. Second, Permit 8585 contains operating, monitoring, and record-keeping conditions to ensure ongoing compliance with the emission rates in the permit. If AAM violates a permit condition or regulation, AQB will follow up with formal enforcement action. If emission limits based on initial calculations using AP 42 emission factors are inaccurate, a permit revision may be required.
Can you describe how Associated Asphalt's Santa Fe facility meets all the applicable regulatory requirements?
Yes. The facility, as represented in the application and application updates, demonstrates compliance with all applicable federal and state regulations. AAM's application 8585 met the requirements of 20.2.72 of the New Mexico Administrative Code, or NMAC. Also, according to 20.2.72.210 NMAC, the conditions in Permit 8585 are based on the contents of the application and application updates. Compliance with all applicable state and federal regulations is demonstrated by AAM following the requirements specified in the conditions in Permit 8585.
What steps did the Bureau take to facilitate public and stakeholder input leading up to the March 2021 public hearing for application 8585?
The Bureau wanted to explain the application review process and inform the public about this proposed facility. So we went beyond the notification requirements in our regulations. The Bureau created frequently asked questions, or FAQs, with answers, a fact sheet, and an introduction to permitting, each in English and Spanish. I shared these outreach documents via email and on a Bureau webpage maintained for application 8585, so people could access information as it became available. Bureau staff updated that webpage frequently to provide helpful information all in one place. When it was safe and practicable during a pandemic, I posted notices of hearing, FAQs, the fact sheet, and the introduction to permitting, each in English and Spanish, in public places near the proposed facility. I also sent requests for public service announcements in Spanish to run on Spanish radio stations broadcast in Santa Fe.
Can you explain a little bit more your role in the Bureau's review of the application for the Santa Fe facility?
Sure. So I was assigned to process application 8585 for AAM Santa Fe facility. I was the permit specialist responsible for completing the administrative review and technical review of application 8585. I was the contact for citizens who called or submitted comments about this application. Recognizing the potential for public interest early on, the Bureau on December 3rd of 2019 posted a copy of application 8585 on the Bureau's webpage for permit applications with public interest. As I've already said, I continued to provide updates on that webpage as more information became available. I worked with AAM's staff and their consultants to understand the proposed facility and to obtain necessary updates for this application. I attended the public meeting held by AAM in February of 2020. I took the public comments I received and used them to generate a list of FAQs. AQB staff wrote answers to the FAQs and provided this information to citizens on the webpage for applications with public interest and via emails that included a link to the webpage with information about this permit application. I also made a fact sheet and an introduction to air permitting document to inform the public about this application, the permitting process, and how citizens could participate in the process. I wrote the legal notice and the notices of hearing and sent those out in accordance with the regulatory requirements. I wrote the statement of basis and database summary, which summarized the department's analysis for this permitting action. I wrote the original draft permit and worked with Bureau staff to update it over time. I also compiled the administrative record and administrative record index for this permitting action.
We don't need to speak about policy 711, so let's just move on to your prep for the March 2021 public hearing. Could you tell us a little bit about that?
Let's see. So staff wrote a notice of hearing per requirements in 20.1.2 NMAC. The notice of hearing was translated into Spanish by Ana Maria McDonald, the translation program manager for NMED. I reached out to the Office of Public Facilitation, or OPF, to obtain a list of the citizens who submitted comments to OPF or participated in the public hearing for AAM's application 8585 in March 2021. I'm sorry, Mr. Behill, I think that I skipped down to answer how I prepared for this hearing today.
I get it.
But I want to backtrack and answer how I prepared for the March 2021 hearing.
Got it.
Does that make sense?
Yeah, it does.
Okay, I apologize, Mr. Hearing Officer and Madam Chair and members of the board.
And Mr. Hearing Officer, Madam Chair, members of the board, the reason why is because there were some matters that were excluded from this, and in fairness, we don't want to present testimony on that. So there are some sections we have to skip. Go ahead, Ms. Prim.
Okay, thank you. So the Bureau complied. Let's see. The original legal notice published by the Bureau in December 2019, when the application was ruled administratively complete, contained a paragraph in Spanish regarding how to speak with someone in the Bureau about the proposed project. The Bureau provided notices of hearing and vital documents in Spanish translated by Ana Maria McDonald, the translation program manager for the department. Ms. McDonald also translated a PSA about the public hearing so it could be read on the radio in Spanish. The Bureau acquired certified Spanish interpreters for the March 2021 public hearing so LEP community members could fully participate in the hearing.
And did any Spanish-speaking members of the public participate in the March 2021 public hearing?
Yes, Spanish-speaking citizens attended the hearing, and as I just mentioned, interpreters were present to interpret from English to Spanish and from Spanish to English. Spanish-speaking citizens gave public comment. I was also cross-examined by a Spanish-speaking citizen on the second day of the hearing. We were able to communicate with each other through the interpreters.
Can you tell us how the department gave formal notice of yesterday, today's, and maybe tomorrow's public hearing as required by the regulation?
Yes. AQB staff wrote a notice of hearing per requirements in 20.1.2 and MAC. The notice of hearing was translated into Spanish by Ana Maria McDonald, the translation program manager for NMED. I reached out to the Office of Public Facilitation, OPF, to obtain a list of the citizens who submitted comments to OPF or participated in the public hearing for AAM's application 8585 in March of 2021. I printed hard copies of the notice of hearing in English and Spanish and prepared envelopes with labels to be mailed by postal service to citizens who submitted only written comments to the Bureau by postal service or walk-ins prior to the March 2021 public hearing, or left only a physical mailing address on comments submitted to OPF regarding the March 2021 public hearing. I sent the notices of hearing in English and in Spanish to OPF, and they posted the notices in English and Spanish on the department's Docketed Matters website under the Environmental Improvement Board dropdown in the section for EIB 21-48, Appeal Petition, Permit Number 8585, Associated Asphalt and Materials, LLC. The Bureau also posted the notices of hearing in English and Spanish on the department's Public Notices website under the Santa Fe County dropdown in the section for Associated Asphalt and Materials, LLC. The post included text about the appeal petition to the EIB and the public hearing scheduled to begin on February 23rd, 2022, with a link to the department's Docketed Matters website for associated documents and more information. The notice of hearing was published in English and in Spanish in the Albuquerque Journal on January 15th, 2022. The notice of hearing was published in English and in Spanish in the Santa Fe New Mexican on January 17th, 2022. On January 14th, 2022, I sent out emails with the notices of hearing in English and Spanish attached. The email messages announced the date for the public hearing before the EIB and provided the link to the department's Docketed Matters website under the Environmental Improvement Board dropdown in the section for EIB 21-48 for more information. These emails with notices in English and Spanish attached were sent to the same email lists used for sending out the notices of hearing for the March 2021 public hearing. There were 3 citizen groups. The first group was the citizens who had submitted written comments regarding application 8585 via email and received the initial citizen letter and second citizen letter on January 28th, 2020. The second group was the citizens who submitted written comments regarding application 8585 after the 30-day comment period was over and received the February 17th, 2020 email that they would be notified of the date, time, and place of the public hearing once it was set. And the third group was the list of email addresses obtained by both the AQB clipboard and the AAM clipboard at the public meeting hosted by AAM on February 7th, 2020. Like the notices of hearing for the March 2021 public hearing, I also sent the January 14th, 2022 emails with attached notices of hearing in English and Spanish to the group of citizens and their representatives established by Linda Marianello in an inquiry she sent to me via email on November 11th, 2020. Emails with attached notices in English and Spanish also again went to the director of the 8 Northern Indian Pueblo Council, Bernalillo County AQCB, EPA Region 6, Erica Ledoux at EPA, Elizabeth Layton at EPA, Bandelier Wilderness Area, Pecos Wilderness Area, Santa Fe County, Sandoval County, City of Santa Fe, Pueblo of Cochiti, Pueblo of Tesuque, and Quechua Pueblo on January 14th, 2022. I checked the contact information on the updated tribal leaders directory maintained by the department and found some contact information had been updated since the March 2021 public hearing. I sent emails with attached notices of hearing in English and Spanish to new contacts at Pueblo of Cochiti, Pueblo of Tesuque, and Quechua Pueblo. I also sent emails with attached notices of hearing in English and Spanish to the email addresses provided by citizens who submitted comments to OPF or participated in the March 2021 hearing and were not already on AQB's email lists for sending out notices of hearing for the March 2021 public hearing. AQB staff wrote a PSA. The PSA was translated into Spanish by Ana Maria McDonald. AQB sent an email to Michael Brasher at 89.1 KANW-FM on January 25th, 2022 to request that the Spanish PSA be read on air.
Thank you for all that. That's a lot of detail. Thank you. How does the Air Quality Bureau regulate issues such as noise, vehicle traffic on public roads, degradation of natural beauty, threats to wildlife, threats to historic structures, to tourism, water quality, water conservation, and to property values?
The Clean Air Act and state air quality regulations are health-based regulations and do not provide the Air Quality Bureau legal authority to regulate impacts that are not specifically related to air quality. Primary national ambient air quality standards provide public health protection. Secondary national ambient air quality standards provide public welfare protection, including protection against decreased visibility and damage to animals, crops, vegetation, and buildings. The Air Quality Bureau cannot deny any applicant an air quality permit based on issues such as noise, odor, truck traffic on public roads, and property values.
And what is the department's recommendation regarding this petition? Excuse me. What is the Bureau's recommendation regarding the appeal on the table in this matter?
Reversing the final order that approved issuance of Permit 8585 would not result in AAM's facilities ceasing operation. It would result in them continuing to operate under old permits that are less stringent and not as protective. The Bureau recommends that the board uphold the final order approving issuance of Permit 8585.
Thank you, Ms. Prim. I have no further questions. Mr. Hearing Officer, I'll pass this witness.
Okay, Mr. Jantz or Ms. Locke can proceed with cross at this time.
Good morning, Mr. Hearing Officer, members of the board. I'll be conducting Ms. Prim's cross-examination. Good morning, Ms. Prim. It's good
Morning,
to see.
Mr. Jantz.
Good to see you again. I hope that this will be quick and painless. Let's see. So I wanted to, before we start talking about some of the substance of your testimony, I wanted to establish a couple of things from your resume, your CV, and hope to clarify a couple of issues. One, I think I heard you say during your direct examination, as well as in your written direct that part of your job, probably I guess the main part of your job is familiarity with the laws, regulations, and guidance involving air quality permitting. Is that right?
That's correct.
Okay. So in your resume and in your oral testimony, you indicated that your part of your job involves uh, ensuring quality customer service, and I thought that was an interesting choice of words. In this case, do you consider Associated Asphalt a customer?
Well, we have external customers and internal customers. Internal customers would be fellow Bureau staff. External customers is anyone outside of the Bureau that I deal with professionally. So I do consider the public as well as industry to be external customers.
Okay. And in the section of your resume entitled Environmental Scientist and Specialist Operational, you indicate that you helped develop a new general construction permit that provided industry with a quote unquote cost-effective option for obtaining permits. Is cost to industry one of the considerations that you take into account when processing and evaluating permits?
No, but I can say that the mission of the department overall, I have the mission statement right here. So the mission statement of the department is, our mission is to protect and restore the environment and to foster a healthy and prosperous New Mexico for present and future generations. So that word prosperous is important. That means that we can thrive as functional members of the community. So I am held to the regulatory requirements and I follow those. But we also, it's a balance. The department is not here to keep industry from operating. We're here to provide regulatory, we're here to provide ways that the applicants and permittees can demonstrate compliance with the regulations while they operate their facilities.
Okay, so it sounds like, so is it your position then that cost is not an issue when at all when processing?
Objection, that question's been asked and answered.
Well, it was asked. I'm not sure it was answered. I'm sorry, Mr. Hearing Officer, you're on mute.
I'm sorry. I'm sorry about that. I think it's appropriate for Mr. Jantz to continue to probe to get the answer he's looking for here. And if it develops that she is answering or we're getting repetitive, then you can object again.
Thank you, Mr. Hearing Officer. So again, Ms. Prim, is it your position that cost to the applicant is not a factor at all when evaluating permit applications?
When I evaluated this permit application 8585, cost was not something that I looked at. It's not in the regulations. So no, for this action, that was not a factor.
Okay, thank you. All right, so let's talk about your written testimony. You adopted that today in your oral testimony, right?
Yes.
Okay, so could you look at Exhibit 1A, which is your written testimony, page 5?
Okay.
And please let me know when you have that. And Ms. Jones, can I have sharing privileges, please?
Let's
Thank
see. I
you.
had to turn off my VPN because the connection was bad, but I believe I have it printed here someplace. Give me just one moment.
Okay.
Okay, so, sorry, Mr. Jantz, you said page 5?
Page 5, yes, ma'am.
Okay,
So on page 5, you say that there is hold on a minute. You say that there's the new permit will result in a 44% decrease in throughput from the old permits and a commensurate reduction in emissions. Do you see where you said that?
yes,
And do you still stand by that?
I do. That's in the testimony provided by Mr. Schooley in the March 2021 hearing.
Okay. Okay, great. So I am looking at the administrative record Bates number 000438, which is the table of emissions and their percentages of the NACs. And this is from the air dispersion modeling summary. You're familiar with that document, are you not, Ms. Prim?
I am.
Okay, great. So if you look down here, and we talked about this some yesterday, PM 2.5 annual emissions in permit 8585 is 99.3% of the NACs. Do you see where that is?
I do.
Okay. So I'm not an expert in math, but I did some simple multiplication and addition. And it seems to me that there's
Objection, Mr. Hearing Officer. Ms. Prim is not the modeler. We have another witness that will testify as to modeling. I would like to hear Mr. Jantz tell us why this is relevant to the throughput issue.
this goes to the emissions that the Environment Department's ability to control emissions, 1, whether they're doing so now, 2. 3, Ms. Prim was qualified as a wide open expert. So this is part of the permit application, part of the permit that she approved. This ought to be fair game.
I don't know where you got this phrase "wide open witness." That was not part of her qualifications. It's very clear she's not a modeler, but I'll leave it at that and leave it to you, Mr. Hearing Officer.
And if I may, Mr. Hearing Officer, I'm not going to
Sure.
examine her about the details of modeling.
Yeah. She said she was familiar with the document, so we'll proceed with this questioning. If a question gets asked that gets deeper into modeling than she is familiar with, she can defer it to the modeling witness.
Thank you.
Okay, Ms. Prim. So doing some simple multiplication and addition. This is the cumulative concentration, right? This is how much the plant will emit plus the background emissions plus other emissions. Is that right?
Yes, I believe so.
Okay.
I'm not a modeler, but that is the standard. That
Yes.
is the concentration in the modeling report.
Okay, and so this 11.912 is 99.3% of the NACs of 12. Is that right for annual PM 2.5?
Yes.
Okay, so if you increase this number 11.912 by 44%, in other words, multiplying it by 0.44, you get 5.24, which is a 44% increase. You add that to the total emissions, you get 17.152 micrograms per meter squared. Does that sound right? And please feel free to check my arithmetic.
Well, that is arithmetic, but that's not what my testimony is about the throughputs, the annual throughputs.
Right, but you also say commensurate, which means proportionate decrease in emissions. So we're looking at that decrease in emissions.
Objection. There's many people that work in the Bureau, and these applications and permits go to the appropriate parties to take care of these things. So To the extent that Mr. Jantz wants to get into how the throughput relates to the modeling, I think that's a better question and a fair question for our modeling witness.
Except for Mr. Hearing Officer, Ms. Prim testified that there was a 44% reductions in emissions from the current plant. And I would like to know whether or not the current plant is in compliance for the NAAQS. It appears not, but I'd like to check that with Ms. Prim.
Ms. Prim, please answer the question if you can. If you can't, you can defer it to the modeling witness.
That's more of a compliance enforcement question, it seems to me. I'm not in compliance and enforcement either. So as it stands right now, these facilities are not consolidated. And consolidating them, there is a difference in some of the equipment, some of the throughput, some of the operating requirements. So it's really not apples to apples. It's kind of apples to oranges. This is more complex than just a straight multiplication like you've demonstrated here.
So that 44% reduction in emissions is not really accurate, is it?
Well, it's a comparison of the throughput and a commensurate decrease. That is accurate.
So you're comparing the emissions from the existing operation, and saying it's 44% decrease. But what I'm doing is not accurate. Is that what you're saying?
Well, you're looking at the model. The model is more than just the emissions calculations or the throughput. It also considers other factors that are not just the emissions calculations. So that's, again, that's more complex than you're making it look here.
So, all right, well, if that's the case, you can't really say that a 44% reduction, if modeling is more complex than just a 1-to-1 ratio for throughput, you can't really say that there's a 44% reduction in emissions if there's a 40% reduction in throughput, can you?
If you would rather I just say a decrease in emissions, I'm okay with that.
All right, fair enough, Ms. Prim. Thank you. All right. So, are you aware of AAM, Associated Asphalt Materials, under any current enforcement orders for NAAQS violations?
I'm not able to comment or speak to the department's enforcement actions, and those are pursued separately outside of permitting actions.
Are you familiar with Community EIB Exhibit 23?
I am. I saw you submitted that yesterday.
Okay. Does this refresh your recollection about the enforcement actions against AAM?
Yes, that was from 2 years ago.
Okay. So it doesn't look like at that point there were any NAAQS violations, enforcement actions against AAM. Is that right?
I don't know. I see some reference to potential violations that were still being investigated.
Okay. And those are what? Failure to conduct monitoring, is that right?
Yes, that's on the screen there.
Failure to keep records. Right here.
I see that.
And failure to notify the Bureau of updated inventory.
I see that.
Okay, so no NAAQS issues.
NAAQS are not mentioned in this email.
Great, thank you. Okay, so let's go to AP 42 standards. You mentioned that in your testimony that a lot of other states use AP 42 standards, and in fact you reached out to other states to verify that. Is that correct?
That's correct.
Okay. When you did that outreach, did you ask those other state agencies whether they used AP 42 factors where there's an existing project that could provide real emissions data? Did you ask that question?
I think that you saw in my email in the exhibit what I asked. And what I asked was whether they accepted initial emissions calculations based on emission factors and methodologies. And then I gave a list. And that
Okay.
list is the chapters and sections that were used in this
Okay.
application.
So again, I'll ask the question, and please, it's really a simple yes or no. Did you ask whether the other states used AP 42 factors where there's an existing project that could provide real emissions data?
No,
Okay. Did you ask the other state agencies whether they relied exclusively on AP 42 standards?
no,
Okay. Did you ask the other state agencies whether they were using A or B rated AP 40 standards or other rated standards?
well, I asked them specific chapters and
Okay.
sections, and that had a range of ratings. So indirectly, that question was asked.
But not directly about A or B standards?
No, but the list included A or B as well as other ratings.
Did you ask the other state administrative agencies whether they preferred using A or B standards versus lower rated standards?
No,
Okay. Did you ask whether the other state agencies made any adjustment to their calculations to account for AP 42 uncertainty?
no,
Okay. Did you ask the other states whether they required applicants to provide emissions data from similar sources?
no,
Did you ask the other states whether they used AP 42 factors even when permitting asphalt plants in low-income communities and communities of color?
no.
Okay. All right. So one other question about the other states. These other states, they have their own guidance, right? Presumably.
They have
Objection. Ms. Prim is not here to testify about what other states do outside of her contact with regard to AP 42. So if this is a direct question about other states' use of AP 42, that's acceptable. But if this has anything to do with states in any other capacity, it's out of bounds. It's not relevant.
Mr. Hearing Officer, if I may, this goes to, well, first of all, NMED opened the door to line of questioning on AP 42. All I want to establish is whether Ms. Prim knows if other states have, like New Mexico, guidance about AP 42 use.
I believe the question is within the scope of relevance of the proceeding. She can answer if she knows the answers.
none of the other states' responses spoke to any restrictions on their use of AP 42. They all verified that they did accept AP 42 for initial emissions calculations.
Okay, that wasn't my question. Do you know whether those other states have their own state guidance like New Mexico does with respect to how to use AP 42 standards?
I don't know.
Okay. Let's assume they do. Okay. Assuming they do, does the Bureau follow other state guidance on use of AP 42 standards?
Objection. He's asking the witness to speculate.
She is an expert, Mr. Hearing Officer. I'm allowed to ask her hypotheticals. I'm sorry, Mr. Hearing Officer, you're on mute.
Sorry, I accidentally muted myself rather than unmute. I think the question is appropriate. You can proceed.
Thank you, Mr. Hearing Officer. So assume other states have guidance regarding their use of AP 42. Does the Bureau follow other state guidance?
The Bureau follows New Mexico's guidance.
Okay, and EPA guidance, is that right?
We follow regulatory requirements.
So you ignore EPA guidance?
No, EPA guidance is considered for sure, but not all EPA guidance is mandated.
Okay.
So this alert is not mandated. It's guidance, it's a reminder. And there's more to the alert than what has been.
Well, we'll talk about the alert here in a second, but
Okay.
I just want to establish that you are that you don't in fact follow guidance from other states.
Correct.
Okay. All right. So we've already dug into the enforcement alert a little bit. Let's take a look at it a little bit more. So we're looking at the AP 42 enforcement alert community exhibit, rebuttal exhibit 1 from the March of 2021 hearing. We went through this quite a bit. We'll go through it a little bit more. So this enforcement alert, as you said, Ms. Prim, is a reminder about the appropriate use of AP 42 standards. Is that right?
Yes.
Okay. And you'll recall, and I have it on the screen right here, the EPA's warning that AP 42 emissions factors should only be used as a last resort. Is that correct?
That's on the screen. Yes, that's correct.
Okay. And that's because those AP 42 factors are fairly unreliable, correct?
I don't agree that they are unreliable. EPA hasn't established other emission factors for this source type. So these are the factors that are available. They're based on data assessed by EPA. If you could scroll back down, I'd like to give more context.
Where do you want me to go, Ms. Prim?
To the bottom of page 3, where you just wear that gray box.
Okay.
So, thank you, Mr. Jantz. So within that same bullet that's got the emission factors header there, where you just read to me, it also says when source-specific emissions or other more reliable approaches are unavailable, AP 42 emission factors may be the only way to estimate emissions.
So we'll get to that in a minute.
Reiterate that.
Yes, I understand that. We'll get to that in a minute.
Okay.
But what I wanted to ask you about again is AP 42 standards are used as a last resort because they're not reliable.
I don't see where it says they are not reliable.
Okay, well, let's take a look at this then. Can we look at the quote here? Use of, and this is actually a quote from the AP 42 manual. Is that right?
I can't say for sure, but I believe you if that's what you're saying. I don't have the manual in front of me.
Okay. Yeah, it's cited as AP 42 fifth edition compilation for air pollutant emission volume factors, volume 1.
Okay.
All right. So because these emission factors essentially represent an average range of emission rates, approximately half of the subject sources will have emission rates greater than the emission factor, and the other half will have emission rates less than the emission factor. That's 50-50, isn't it?
It's an average, and
So half above,
it's
half below, right?
it's the best available data that we have.
Yeah, that wasn't the question. Half above, half below. Is that what EPA is saying?
That's what an average is.
Yes, okay. And so that's basically a flip of the coin. Heads compliance, tails non-compliance, right?
No, compliance is based on passing modeling as well. Emission rates are a piece of the modeling, but there are other factors that are involved with the overall demonstration of compliance with the NACs.
Okay,
The emission rates are a piece of that.
let me be more precise then. With respect to the model input of the AP42 emissions factor, it's a flip of the coin. Half of those might be above the emission factor, half might be below, right? Flip of the coin.
Well, again, that's oversimplifying it. Even the emission rate itself is based on an equation, like I mentioned in my testimony. The general equation for the emission rate is the capacity, or the, how that piece of equipment is operating at what capacity times the emission factor. So the emission factor is part of the equation, but not the entire equation.
But again, we'll go into the emission factor. I would just like an answer based on what the EPA is saying, half above, half below. That's 50-50.
I think I said yes to that already. The average
Okay.
is
Do
half.
you know, Ms. Prim, whether AAM, associated asphalt materials, falls above or below?
There are dozens of factors involved in this application. So some are rated differently than others. You've spoken to that yourself. I really feel like you're oversimplifying the half above, half below idea here. It is an average. These are based on tests. They're based on data that EPA has accumulated. It's the best data that we have sometimes, and when it's the only reliable data that we have, we use it. It's very common. Asphalt facilities, a lot of their emissions are fugitive emissions that don't have stacks. In this case, the application, the equipment table in the application has, I think, 48 pieces of equipment, and only 8 of those pieces of equipment have stacks in table 2H of the application. So sometimes with fugitive emissions, especially, AP42 is the way to calculate initial emissions.
Sure, understood. Just point of clarification, most of the emissions from this facility come from stacks. Is that not true? Is that not true?
The equipment with stacks is the highest emitting equipment, but I don't have a breakdown in front of me of the comparison of exactly the ratio of pollutants per piece of equipment.
We can figure that out from the record. In any event, you mentioned that AP42 standards are based on data, right?
Right.
When you were, and Dr. Sahu testified to this yesterday, and you were here for Dr. Sahu's testimony, were you not?
I was.
Okay. And Dr. Sahu talked about some of those data in a general sense, right? That that there were a range of data that went into creating the emissions factor itself, right?
Right.
And some of those data are on, sort of the low end of emissions, some are on the high end. Is that right?
Yes.
Okay. Did you look at those actual data when you were evaluating the associated asphalt permit?
I looked at every emission factor used in this application.
Okay, so but did you look at the data behind each emissions factor?
I looked at AP 42, I looked at the tables. I didn't read during this permitting action every single page of AP 42.
Okay, so it's fair to say that you didn't look at all the data and all the reports that went into those factors. You just looked at the factors. Is that right?
I looked at the factors. I didn't read the hundreds of pages of AP 42 for this permitting action.
Okay, thank you. All right, so let's take a look at the sentence here. Are you looking at this sentence, Ms. Prem?
It looks like a few sentences, but yes, I see what you've highlighted.
Okay. And the gist of that is, and please correct me if I'm wrong, is that AP 42 emissions don't account for short-term variation in emissions because they're intended for long-term emission, developing long-term emissions for area-wide annual or triannual inventories. Is that right?
AP 42 emission factors do not account for short-term variation in emissions intended for use in developing annual I think I'm seeing what you're reading there, yes.
Okay. The Environment Department, the Bureau, I'm sorry, the Bureau used AP 42 to calculate 1 hour emissions of oxides of nitrogen. Is that right?
I'm sorry, can you repeat that question?
Yeah. The Bureau used AP 42 standards, emissions factors rather, to calculate 1 hour, the 1 hour PTE for oxides of nitrogen. Is that right?
We used AP 42 to calculate pound per hour emissions.
Okay. So the 1 hour NO2s?
Well, there's a 1 hour standard and then there's a pound per hour. So I'm trying to clarify that we used AP 42 emission factors to calculate the pound per hour emission rates.
Okay. And you use them to calculate the 24 hours for NO2?
Again, that's more of a modeling term. The emission calculations are pound per hour and ton per year. Modeling incorporates emission rates to determine compliance with the standards.
Sure. Sure. But you used AP 42 to calculate those 24 hours, 24 hour emission rates?
I used AP 42 to calculate the pound per hour emission rates.
Okay. You used AP 42 to calculate the PM10 pound per hour,
Yes,
and that was used to as an input for 24-hour PM10 NAC compliance, right?
the pound per hour rates were used in modeling. Yes,
Okay. And you use AP 42 to calculate pound per hour for PM 2.5?
yes, I think we already talked about that.
Right, which was in turn used to model 24-hour PM 2.5 emissions, right?
The PM pound per hour was used to model concentrations, yes, to demonstrate compliance with concentrations.
Okay. All right. So if you would look at page 8 of your EIB written testimony, that's Exhibit 1A. And I'm looking at the bottom line 31 and 32.
Page 8.
Yes, lines 31 and 32. And I'm particularly interested in that website.
Okay.
You cited that website to support your assertion about some of your assertions about emissions factors, right?
Let's see. Yes, air emission factors and quantification website.
Yes, that's the one. And I have it up on the screen right now. And you quoted from about emissions factors, is that right?
I'm still seeing the alert on my screen.
Oh, okay. Let's see. Let's see if I can make this work. I'm going to stop sharing and then reshare. Please bear with me with the technical issues.
No, I understand. No problem.
I think we got it figured out. Can you see what I'm looking at right now, Ms. Prim?
Yes,
Okay, so this is the EPA website that you cited to on page 8. Is that right?
that looks correct. Yes.
Okay. And looking at your emissions, it looks like you quoted from this portion of the website about emissions factors. Looks like it's this paragraph here. Does that seem right to you?
That seems correct.
Okay. Did you happen to scroll down when you were looking at this to the section that says emissions factors uncertainty?
I did see that.
Okay. Did you explore it further? In other words, did you go to this page that talks about emissions factors, uncertainty, and related documents? Actually, this is not the right one. I'm sorry. The emission factor uncertainty assessment?
I did not go to that page.
Okay. I'm wondering, are you familiar with the emissions factor uncertainty assessment from 2007 that the EPA issued?
I'm familiar with the alert and the information in the alert. I've not looked at this specific document.
Okay, fair enough. All right, then let's take a look then. At the, let's see. I want to go back to the enforcement alert briefly. So we're back on the enforcement alert. And on the enforcement alert, we have the EPA's recommended hierarchy of data. And you alluded to this earlier, Ms. Prim, when you said that AP42 emissions factors can be used when there are no other available data. So let's talk a little bit about what the preferred data sources are and what associated asphalt provided. So according to this enforcement alert, continuous emission monitoring system seems to be the preferred source of data for emissions. Is that right?
Well, you're using the word preferred.
More
Uh,
accurate.
the word is accuracy in this document. So it does say these techniques in order of accuracy are, but
Okay.
it doesn't necessarily, it doesn't use the word prefer.
Okay. Well, let's talk about the accuracy though. Then continuous emission monitoring system is the most accurate, right?
On this list, according to
Yes.
EPA, yes.
Did AAM provide any SEMS data?
No,
Did you ask for any?
no,
Um, Stack testing is the next most accurate. Did AAM provide any stack testing data?
no,
Did you ask for any?
no,
Vendor guarantees and stack test data from similar facilities are also are the next most accurate. Did you ask for vendor guarantees or stack test data from similar facilities from AAM?
no,
Did they provide any?
no,
Material balance calculations are the next most accurate. Did AAM provide material balance calculations?
no,
Did you ask for any?
no,
Optical remote sensing is the next most accurate. Did AAM provide any optical remote sensing data?
no,
Did the Bureau ask for any?
no.
Okay. Um, One last thing before we go to Exhibit 19 is that how many sources from from the Associated Asphalt operation emit particulate matter? Do you have a sense of that?
So you're asking for a number of pieces of equipment?
Yeah, ballpark.
Um, let me look at the permit. I think earlier I said there were about 48 pieces of equipment.
Something like that, yeah.
So let me look. I'm looking at table 106A, allowable emissions in the permit. It's on page 9 of the permit 8585, starts at page 9.
Is that A9?
Yes, page A9.
Okay.
So it looks like probably about 45, something like that, just ballpark.
Okay. All right. And do you know, Ms. Prim, how many of those? And you use the emissions factors to calculate emissions from all of those, is that right?
Yes,
Do you know how many of those 45 were A or B rated?
I don't know off the top
Okay.
of my head, no.
Okay. So one of the issues that you have talked about is the correspondence with other state agencies. And on Exhibit 19, NMED EIB Exhibit 19, which is the answer plus all the permit information that was attached. You're familiar with that, right? You referenced it in your direct testimony?
Yes, I didn't know the exhibit number, but I am familiar with the department's answer to the appeal.
Okay. So I'm going to share with you, and I hope you can see this. page 354 of the PDF, page 354,
Okay.
which is the Hawaii permit. And I'm looking at 11 of 25 pages. Says, this is talking about things that requirements that Hawaii had on their permit application. And they looked at a receptor grid with receptor spacing of 25 meters extended approximately 200 meters away from the fence line. That wasn't a requirement for AAM, was it?
That's a modeling question.
Okay. All right.
I did not do the modeling analysis.
All right. We'll save those for Mr. Peterson. All right. One last line of questioning for you, Ms. Prim. You talked some about the, I'll stop sharing. You talked some about the permit conditions monitoring that would ensure compliance with the NACs. None of those permit conditions require actual SEMS or stack monitoring, do they?
Well, there are initial compliance tests that are required in the permit. There's also testing required by a federal regulation, subpart I, 40 CFR 60, subpart I.
Mhm.
So there are tests in those conditions.
And what are those? I understand the initial tests. What are the federal requirements?
It points to subpart I, which I believe includes method 5 and method 9 testing.
Mhm.
So they have to abide by the requirements of that federal regulation.
But that's only initial testing, isn't it?
No, that's separate from the initial compliance test. So initial compliance tests are conditions A402B and A403B, and subpart I requirements are for A402C and A403C.
Okay, and those just tell an applicant how to do monitoring, right?
No, they have test methods and procedures in subpart I that they have to follow.
Okay, that's the procedure, right? It tells them how to do it.
It tells them they have to do it, and it tells them they have what they do to determine concentrations and opacity.
Does it tell them how often do they have to do it?
I'd have to look at method 5 and 9. The subpart I points to those methods. So the frequency and duration. Subpart I is a 2-page document, but it points to other regulations with more specifics.
So you don't know if method 5 or method 9 requires yearly, bi-monthly, every 6-month testing?
I don't know the frequency and duration specified by subpart I, but the condition tells them they have to follow the requirements in subpart I.
Okay.
Which points to other places, like I'm saying.
Right, and the operation right now has to follow that because it's federal regulation. Is that right?
Yes.
Do you know how often they've done stack testing pursuant to method 5 or method 9 associated asphalt?
I'm not in the reports section, so I haven't seen those reports. I'm in the permitting section.
Okay. All right. So putting aside section method 5 and method 9, the primary, it seems to me, methods of ensuring compliance are opacity monitoring and operational pressures. Is that fair to say?
So you said say that again. Opacity and
Operational pressure, so baghouse pressure. I guess it's mostly baghouse pressures.
yeah, it's a bit of a subjective question as far as what the primary methods are. The permit really is all things combined, following the requirements of the entire permit demonstrates compliance with the standards.
Well, let me ask it this way. One of the compliance methods is opacity testing. Is that right?
That's correct.
Okay. Can you extrapolate opacity to micrograms per cubic meter? In other words, if you see 20% opacity, can you extrapolate that into a number of micrograms per meter squared or cube?
I personally cannot. I don't conduct method 9 tests.
Okay. So I assume you also don't know if it could be extrapolated to pounds per hour or tons per year?
Method 9 is an opacity measurement that is a percent. So it's based on how opaque the fugitives are, like blocking your visual ability. So it's not related in pounds per hour, it's related in a percentage.
Okay. And what about operational pressures, baghouse pressures? So can you say a 15% decrease in baghouse pressure results in a increase of 5 micrograms per meter squared, 10 micrograms per meter squared?
I don't believe there's a direct correlation like that, but
Okay.
again,
Okay.
I'm not a method 9 expert.
Okay. Great. Thank you, Ms. Prim. I think that's all I have for this witness.
Thank you, Mr. Chance.
Are there any questions from members of the public of Ms. Prim? Okay, hearing and seeing none, we'll go to questions from board members. We have questions of Ms. Prim from board members. Yes, Mr. Cates.
Yeah, Ms. Prim, thanks for your testimony here today. I'm sort of familiar with that part of town, and I wanted to clarify that's it's zoned industrial, correct?
That's correct.
So can you just explain real quickly, give us a little rundown on zoning tiers? I mean, I know you got residential, various kinds of residential, you got various kinds of retail, and then you have various kinds of industrial. Is there some subcategory here on the industrial zoning end of this? Or is it just industrial?
It's zoned industrial in the Sustainable Land Development Code. I reference it in my testimony that was in the March 2021 public hearing. But I'm not an expert in zoning, so I can't speak to the different categories that you're asking about.
Yeah, so I want to make sure that I have sort of the context right here. So that's out, and I'm looking at it on Google Maps here. So to the south, directly to the south of that, we have a cluster of a lot of body shops. For instance, there's Crago Block, which I think is a stone company. There's Vulcan Materials, which is also a stone company, I believe. There's the airport is the end of the airport is or the end of the runway is right down that way. To the west, you've got Santa Fe wastewater, the wastewater treatment plant. Just to the north, you have the public works, the county's public works complex, which is, trucks and buses and such. And just to the south of that, you have the wastewater treatment plant. And not until you get back across the highway do you get into anything that could be described as residential. So, I mean, it seems ensconced firmly, the site seems very ensconced in an area that is largely industrial. Do I have that more or less right?
You do. I agree. Like I said in my testimony, the HMA #2 plant that's currently operating at Oliver Drive is on the other side of the highway, like you're
Yeah.
talking about. So moving it to the Paseo de River location actually moves it away from those mobile homes. There are residential areas that are directly next to that facility, unlike the Paseo de River facility that you're
Right. And then for additional context, I think it's fair to say that that is kind of out in the country too, right? That's toward the south end or the southwest part of town where there's a lot of open space to the north and the west, right?
There is open space to the north and to the west.
Has anybody ever looked at which way the wind blows out there? That is, I mean, we're in Mexico, so it blows every way. But what do you know what the prevailing wind pattern is?
I don't, but perhaps Mr. Peters could speak to that. He's our modeling witness that will be testifying. That would be part of the modeling analysis.
Oh, okay. All right. Thanks. So,
Sure.
if I mean, assuming that we need assuming that we need asphalt in our everyday lives, and that we all use it to one degree or another, pretty much every day. Um, is there a more ideal location for this plant in Santa Fe?
I don't know, but I can say that my work is based on the regulations and our authority, and the Bureau doesn't have authority to tell an applicant where to locate. We do have the job to review their application, which includes their location, and be sure that they are demonstrating compliance with the standards at that location, and that's what we've done.
Yeah. So you wouldn't be able to say, there's a better place for this plant and say where that is.
No,
That's beyond the scope of your
I
work.
mean,
Yeah.
yeah, that's not, as a professional, that's not, my job is bound by the regulations.
Right. Well, thanks again for the testimony. I realize it's something of an endurance test, and so thank you.
Thank you, Member Cates.
Are there any other board members with questions? Mr.
Yes,
Honker?
sir.
Yeah, Ms. Prim, just one question. Is there anything in the department's rules or guidance or EPA's rules or guidance that would require a human health risk assessment as part of the issuance permit process for a permit like this?
Not for this specific permitting action.
Okay, I thought that was probably the case. Just wanted to make sure. Thank you.
Thank you, Member Honker.
Other board members?
Yes, sir. Can you hear me?
Ms. Davis?
This is
I'm sorry.
this is
Oh,
this is board member
we
Bitzer.
have- okay, Member Bitzer, go ahead and proceed, and then we move on to Ms. Davis and Ms. Garcia.
Sorry, I didn't mean to cut in line, but I'm in transit at the moment, so I'm not sure when to push buttons.
Okay.
Just a quick question, Ms. Prim. You had talked about the 4 current locations. The third one didn't have a permit, and it did, and then I didn't catch the word. What function or functions that had at that location? The one that on the list
Yeah.
and didn't have its own permit.
Thank you, Member Bitzer. That's a little scalping screen. So it's not currently permitted. The 3 that do have permits are the 2 asphalt plants and the crushing screening plant.
Scalping screen means sifting rock from sand kind of thing?
Yeah, that's the basic idea. It's a fairly small facility, so it doesn't currently have a permit.
I guess it doesn't need one then?
Um, I'm not totally sure about that.
All right. We'll circle back to that later. Thank you.
Okay.
Okay, Ms. Davis.
Thank you, and I'm gonna apologize for any background noise ahead of time. I have a child home with pink eye, so if that made any of you cringe, that's how. So my questions, I want to make sure I'm clear about the questions being asked of the board here. And so first, Ms. Prim, thank you for your testimony. I understand this has been a lengthy process, and so I just want to thank you for that ahead of time. So one of the questions being asked of us is this permit, this permit have been issued? And I want to be clear in my understanding that AM currently has 3 permits that they can operate under. And this permit that we're discussing is a consolidated permit. Am I correct in my understanding of that?
Yes, that's correct, Vice Chair Davis. You got it exactly right.
Okay, so even if we reverse this decision, they would continue to operate?
That's correct. And they'd be operating under old permits that are less protective and less stringent than the current permit 8585.
Okay, which actually leads me to my next question. I believe you testified at length about the decrease in emissions. And again, from my understanding here, I believe what you were saying is that as 4 separate permits, or possibly there's 3 permits, but 1 facility isn't permitted yet, but as individual permits, there is an increase of emissions versus a consolidated permit.
Right. So the consolidation actually involves a reduction in the throughput, meaning that how much material they process. There's a table that I have. It's in a few places in the administrative record. So trying to figure out the best way to point you to it. It's in the statement of basis. So maybe that's the best way to direct you. I'll have to look up that citation, but it's in the statement of basis, which is fairly early on in the administrative record. It's the department's analysis. So it shows that, for example, HMA number 5, which is currently at Paseo de River already, under its old permit, it's authorized to operate at 450 tons per hour. And under the new permit, that HMA number 5 operates at 300 tons per hour. Under the old permit, it operates at 864,000 tons per year. Under the new permit, it operates at 750,000 tons per year. HMA number 2, which is the one on Oliver Drive, it's currently authorized to operate at 200 tons per hour. And under the new permit, it's authorized to operate at 150 tons per hour. Under the old permit, it's authorized to operate 345,600 tons per year. And under the new permit, it's authorized to operate 190,000 tons per year. The crusher screener plant, which is currently kind of at the corner of the 86 Paseo de River facility, it's currently authorized to operate under a GCP, a general construction permit. So it can currently operate up to 250 tons per hour. And with the new permit, it'd be authorized to operate 200 tons per hour. Under the current GCP, it can operate up to 1,095,000 tons per year. And under the new permit, it'd be authorized to operate 400,000 tons per year. So for each of those, so it's like I was saying, it's kind of an apples to oranges comparison, because not every facility drops or rises the same exact amount in throughput. That comparison is kind of putting all of those together and giving you just an overall simplified view of the overall reduction in emissions just based on the reduction in throughput that's authorized under the old permits versus the new permit 8585.
Thank you for that, and thank you for the going into detail on that. For the benefit of the board, can you explain the difference between fugitive and measured emissions, and kind of how they calculate into this permit?
Okay, yeah, that's a great question. So fugitives are emissions that are not coming from a stack. So they can be measured with the human eye. They can be measured. So we have a couple different types of testing for fugitives within the permit 8585. There's a method 22 test, which is a test for visible emissions. It's basically, do you see emissions, yes or no? And we use method 22 as sort of a screening test. If the answer is yes, then they'd be required to do a method 9 opacity test, which is a quantified. So method 22 is kind of a qualitative screening test. Method 9 is a quantified opacity test, which is assessed by someone who's trained and certified to do a method 9 test, where they're actually assessing the percentage of opacity from the fugitives. So you have to get like a certain angle from the sun, and there are very specific requirements to do a method 9 test. So a certified operator has to do it. So fugitives they're tricky to quantify. They can be quantified through opacity, and subpart I does have requirements for testing particulate matter, which is one type of fugitive. And there are subpart I requirements that the facility has to abide by, because that's a federal regulation.
Are there any federal regulations that require an asphalt facility to quantify their emissions?
Just
like
that sub
you or equivalent?
Just the subpart I, 40 CFR 60 subpart I. And we also have a state regulation. So it's in condition, it's the last specific condition of the permit. Give you the citation here. So on page A34 of permit 8585, there's condition A405A, which is a state regulation for asphalt equipment. It's 20.2.11 NMAC. So there's some fugitive dust control system requirements that are specified in that regulation as well.
And of these two that you mentioned, do they require a facility to quantify their emissions or just estimate emissions?
Yeah, subpart I, it has test methods and procedures at 40 CFR 60.93, and that pulls in, like I was explaining to Mr. Jantz, that pulls in a determination of particulate matter concentration. So it points to method 5 and method 9, which are both EPA tests.
Okay, and thank you for explaining that again. And then my last questions are actually more about your public meetings. When you conducted the public meetings, I'm curious if there was any other attempts to engage the community in either mediation for their issues, or any attempts outside of issuing frequently asked questions back to the community.
So AAM did host the public meeting in February of 2020. The department reached out to Associated Asphalt and let them know that there was significant public interest and that we felt like some of the information was not being relayed clearly to them, and that we wanted them to have a better understanding of what this application was about. So Associated Asphalt decided to then host this public meeting in February of 2020, and several staff from the department attended that meeting. So it gets a little tricky because, of course, the timing, COVID came around in March. Everything kind of shut down as far as in-person interactions. Originally, our public meeting was slated for May of 2020, and we were actively seeking a venue and trying to get everything in place to hold that meeting, that public hearing. But then COVID-19 postponed that, and it got pushed out until October of 2020, and then it got postponed twice more. So it finally happened March of 2021. So I think that COVID played a bit of a role in this process as far as delaying things. But we did participate in that public meeting. We did respond to inquiries. We did try to answer questions. I spoke on the phone with several citizens. So there was an effort. I want to be transparent. I want people to understand the process. The introduction to air permitting that I put together is just kind of an overview of how the process works and how you can participate. So we did create that to try to let people know how they could participate, not just say, yes, you can participate, but go further and say, this is how. Provide comments, attend this hearing on this date, at this time, at this link. We welcome their input. We got some relevant and helpful feedback from expert witnesses from the community that submitted requests for changes to the permit in their statement of intent for the March 2021 hearing. And we did make improvements based on those suggestions from the citizen experts. And we reviewed those improvements at the March 2021 hearing, and the final permit 8585 includes those improvements. That's the permit that we spoke about at the March 2021 hearing. That's the permit that was signed. It's the same version that was proposed as an improved version at the 2021 March public hearing. So we did welcome input. We did try to communicate as well as possible, provide information as much as possible.
Were any issues with AP 42 raised during the public hearings or the feedback from the community?
That's a good question. The first concern raised regarding AP 42 was raised at the hearing. During the hearing, Mr. Jantz, during my cross-examination, he pulled up that alert that we've been looking at today. And that was submitted as an exhibit during the hearing, not prior to the hearing.
Thank you for that. I have a ton of notes here, and it takes me a second to scan through them, but
I understand.
I thank you for answering those questions for me. And I'm done. Thank you.
Thank you, Vice Chair Davis.
Okay, Ms. Garcia. I think you need to unmute, Ms. Garcia.
Can you hear me?
Yes.
Yes.
Okay. Thank you, Mr. Hearing Officer, and thank you, Ms. Prim, for your testimony. I have a question similar to what Vice Chair Trujillo Davis was getting at, I think, but I'm going to go a little further. And that is, let's say, considering the consequence of what the board decides. Let's say that the application, let's say the application did not meet requirements. Let's say the modeler, right now, the modeling showed that they just barely came within the standard of the NEX. So let's say the modeler did their work and it showed that it was over the NEX. What does the department do in that case with the permittee?
We would not issue a permit if the modeling did not demonstrate compliance with the NACs.
So then presumably the permittee would have to go back to the drawing board and figure out what they needed to do to reduce emissions so that they could then resubmit an application that met requirements. Would that be right?
Correct. Reducing emissions would be perhaps one factor, but the modeling encompasses several factors. So there are different refinements that can be made to the modeling, and there are different factors within the modeling. I think some applicants don't do the extra work. I'm not a modeler, so Mr. Peters can speak to this more, but in general, some applicants submit modeling that shows they pass modeling, they demonstrate compliance with the NACs. Once they've done that, they don't do the further work of refining the model more and more to show not only is it meeting the standards, but it's at a lower percentage or a lower concentration than the given standards. So just passing the modeling, it's kind of a black and white. Yes, you pass, or no, you don't. And then there's the refinement within the modeling that isn't always done because it's not required. They've shown they've passed the modeling, then they don't do the refinement.
Okay, thank you. So if the board, so what I'm getting at is, if the board were to say, yes, we think this permit needs to be revoked, it shouldn't have been issued. Let's say the board did that. You said that the company would then go back to their old permits, they use their old permits that are currently in place, and they are less restrictive, less safe for the public, let's say. But wouldn't they be out of compliance at that point? Would the Bureau need to take some other action if the board were to revoke this permit? What would happen after that?
Well, they're actually currently operating under their old permits. Because of this appeal, they've opted to not begin disassembling and moving and relocating and consolidating. So they're currently operating under their old permits. So I use the word old. It's their existing active permits. So they are held to what was required when they did the modeling for those permits, and they're required to meet the requirements of those permits and demonstrate compliance based on those permits. If they came in to make a significant change to equipment, that could that could require a significant revision to those permits, which would then require modeling and other, it'd be a permitting process. But they could also just continue to operate under those old permits as they are. So it's either they operate under permit 8585 and consolidate everything and follow this permit, or if that is not allowed by the board, then they operate under their existing permits as they are right now.
And so therefore they wouldn't move and consolidate.
Correct. They would just stay at HMA 5 would stay where it is, which is 86 Paseo de River, and HMA 2 would stay at the Oliver Drive location.
Thank you. That helps give me a clearer picture about the consequences of our decision. Thank you very much.
Yeah.
I think that's all my questions for now. Thank you.
Okay. Thank you, Member Garcia.
Do we have any more questions from board members? Okay, Mr. Vigil, are you going to have redirect for Ms. Prim?
Yes, I have a couple of questions on redirect.
Okay, let's go ahead and recess now for 10 minutes. We'll come back at 11:20 and you can do your redirect at that point in time, and then we'll go to the next witness.
Okay, that sounds good.
Okay, thank you. Is Mr. Vigil on?
I am.
Okay, we're back on the record. Mr. Vigil, you can proceed with your redirect.
Okay, Ms. Prim, I just have a couple questions for you. The department's use and approval of AP 42, in your view, does that have any relationship to the economy of New Mexico and its budgetary constraints?
Objection beyond the scope across.
Mr. Vigil, do you have a response to that?
I didn't hear what he said.
I'm sorry, Mr. Vigil. That question is beyond the scope of cross.
The scope across is AP 42 and why the department uses it.
I think it falls within the scope of cross-examination. There are a lot of questions asked about AP 42, and I think she's entitled to respond to why they use it.
As I said earlier, I read the mission statement for the department, and it does include fostering a healthy and prosperous New Mexico. As a permit writer, I look at the regulations and I review an application for its administrative completeness and its technical accuracy, and I write the permit so that the permittee demonstrates compliance with the standards and operates in accordance with what's represented in their application.
Okay, thank you. I have one other question. There was a question that a board member had brought up about a facility, a portion of the current facility that is not permitted. Will that portion be incorporated into the new facility if the facility is built?
Yes.
Okay, thank you very much. I have no further questions.
Thank you, Mr. Vigil.
Okay, we will turn to the next technical witness for the department. Ms. Prim, you're excused for purposes of your direct examination, your direct testimony, excuse me.
Thank you. And thank you, Ms. Prim. Thank you, Mr. Hearing Officer, Madam Chair, members of the board. The department now calls its next witness, Mr. Eric Peters.
Hi,
Okay, Mr. Peters, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Could you please state your name for the record?
My name is Eric Peters, ERICPETERS.
Could you briefly describe your educational background?
I have Bachelor of Science degrees in Mechanical Engineering and Biology from the University of Illinois and a Master of Science degree in Environmental Engineering from the University of Kansas.
Could you briefly describe your current employment?
I work for the Air Quality Bureau of the New Mexico Environment Department, which I will call the department, as an air dispersion modeler. I have worked in the modeling section for over 24 years. One of my primary duties is the review of air dispersion modeling for new source review permit applications to determine if they will comply with air quality standards and other modeling related requirements.
And you submitted your resume as NMED Exhibit 18?
Yes,
NMED EIB Exhibit 18, I'm sorry.
yes, that is correct.
And you submitted written testimony?
Yes, my written testimony is NMED EIB Exhibit 17.
Do you have any corrections you'd like to make to your written testimony at this time?
Yes, the words "are compiled" were left out of the quote on page 5, line 20. The quote from EPA's guideline on air quality models should read, "Emission factors for a variety of source types are compiled in an EPA publication commonly known as AP42. Also, page 9, line 18 had an error in the hearing date and should say 3/22/21 instead of 3/22/31.
Thank you. Along with your corrections that you just cited, do you adopt your testimony in its entirety?
Yes.
Okay, I offer Mr. Peters as a witness in this matter, subject to comments of the petitioners.
We have no objection, Mr. Hearing Officer.
Okay, I believe everything's been admitted except the correction, so we'll admit the two exhibits, Exhibit 17 and 18, with the corrections he just made.
Thank you so much. Mr. Peters, what's the relevance of air dispersion modeling on these permits?
Associated Asphalt and Materials LLC, which I'll call the applicant, applied for permit 8585, which is known as Santa Fe Facility, which I'll call the facility, under 20.2.72 New Mexico Administrative Code. The permit application process requires the application to contain an analysis demonstrating that emissions from routine operations will not violate New Mexico or national ambient air quality standards or prevention of significant deterioration, PSD, increment.
Could you briefly describe these standards that are modeled?
National ambient air quality standards are maximum concentrations of pollution allowed in the air. These standards are periodically reviewed by the Environmental Protection Agency and are designed to protect the most sensitive individuals from exposure to pollutants. PSD increments are limits to the increase of pollutant concentrations in an area and are designed to maintain the air quality of pristine areas.
How does the applicant know what options to choose when conducting modeling?
The department maintains the New Mexico modeling guidelines to provide a basis for acceptable modeling analyses. These guidelines incorporate and interpret the most recent versions of EPA's guideline on air quality models, which we'll refer to many times as the guideline. This was published in the Federal Register, Volume 82, Number 10. New Mexico modeling guidelines also incorporate other information and guidance, such as EPA memorandums.
Did the department review the modeling submitted by the applicant for application and then later the permit 8585?
Yes, the department reviewed the modeling submitted by the applicant for this permit.
The department verified that the applicant followed appropriate modeling practices. Details of the modeling are described in the modeling review report, which is at AR6, Bates 000430 through 000439.
And when you say AR, just to clarify, you can continue to say AR, but when you say AR, you're referring to the administrative record, correct?
That is correct.
Thank you. What are the conclusions from your review of the modeling analysis?
Santa Fe facility modeling was performed in accordance with the New Mexico modeling guidelines. If the facility operates in compliance with the terms and conditions of the draft permit, then it will not cause or contribute to any concentrations above state or federal ambient air quality standards or PSD increments. The facility has satisfied all modeling requirements and the permit may be issued. Well, the permit was issued and is being appealed.
This is a question about the definition of ambient air. Petitioners argue on page 3 of the petition that the department was, quote, inappropriately expanding that definition to allow for the applicant to exclude national ambient air quality standards exceedances found at nearby properties. Could you address that claim?
The EPA defines ambient air as that portion of the atmosphere external to buildings to which the general public has access in 40 CFR section 50.1. The EPA guidance presented as NMED Exhibit 13 in the original hearing clearly illustrates how EPA applies this definition at surrounding facilities. The exhibit is short and clear. It describes that the contribution of a facility can be excluded when calculating total concentrations within that own facility's non-ambient air. This is the application of ambient air that the department used in the evaluation of this facility and is the application it uses whenever it is appropriate in a modeling review. The department modeling uses ambient air only in ways that are consistent with the ambient air definition and the EPA guidance. The EPA itself has defined ambient air, the EIB itself has defined ambient air at 20.2.72.7D as the outdoor atmosphere, but does not include the area entirely within the boundaries of the industrial or manufacturing property within which the air contaminants are or may be emitted and public access is restricted within such boundaries.
The petitioners expressed concern on page 3 of the petition regarding whether the applicant's operation will, quote, comply with the NAAQS because the applicant's air dispersion modeling relies on the use of AP42 emission factors to determine expected emissions from the proposed source instead of actual source-specific and real-time emission data coming from the already existing operations. Could you address that concern?
EPA's guideline on air quality models indicates that the use of AP42 is an acceptable option for calculating emissions for modeling inputs. The guideline describes 3 acceptable approaches to determining emission factors and states that emission factors for a variety of source types are compiled in an EPA publication commonly known as AP42. AP42 also provides an indication of the quality and amount of data on which many of the factors are based, end quote. That's in Federal Register, 82 Federal Register, page 5218, January 17, 2017. Permit conditions require the facility to demonstrate that they do not exceed the requested emission rates. Permit condition A304C requires the testing of engines to verify compliance with the requested emission rates for NOx and CO. Permit condition.
Mr. Peters, just really quickly for the benefit of the public, just this one time, could you tell us what NOx and CO are?
NOx are oxides of nitrogen, and NO2, nitrogen dioxide, is the fraction of NOx that are regulated by air quality standards. CO is carbon monoxide, and yeah, no further explanation is needed for that one.
Thank you. Sorry to interrupt. Thank you.
I think I was saying that permit condition A401C requires the continuous monitoring of the temperature of the asphalt and asphalt cement. Higher temperatures result in more emissions, as documented in the emission calculation equations in AP42 table 11.1 through 14. Predictive emission factor equations for loadout and silo filling operations. This is in section 7 of the application. AR1 Bates 00180. Permit condition A402B requires the testing of baghouses to verify compliance with the requested emission rates for PM 2.5, PM 10, NOx, and CO. Baghouses collect the emissions from the drum dryers and mixers. The vast majority of the particulate matter released to the atmosphere comes from the baghouses, as seen in Table 2 of the Modeling Review Report. This is at AR number 6 at Bates 00431. Permit condition A402A ensures that baghouses remain in compliance with the tested values. The emission rates are from an acceptable source, and compliance with the requested rates is verified by testing required by permit conditions. Therefore, the modeling is valid with respect to emission rates. The goal of modeling is to find the maximum possible concentration, so decreases in emission rates do not need to be modeled. The department only requests revisions to the modeling when emissions at an emission source increase. The modeling combines worst-case meteorological conditions with worst-case background concentrations and maximum calculated emission rates. The modeling submitted by the applicant shows that if all these worst-case conditions were to happen at the same time, there would be no violations of air quality standards.
I just want to drill down just one more question on this point. Could you describe again the conditions that would need to be present in order for an exceedance under the permit?
Yes, the three worst case conditions that would happen at the same time is the maximum monitored background concentration would have to happen at the exact same time as the maximum emission rates, and the worst case meteorological data. We use 8,760 different hours per year of meteorological conditions to make sure that every possible condition is accounted for. And so we take the worst case hour of that, or well, 24 hours if you're talking about PM 2.5, and those would all have to occur at the same time to for a violation under the current modeling.
So just one more question on this. This scenario that you are describing, in which all the facilities are operating at maximum capacity, and at the same time, the wind rates are at their very lowest. How likely do you think that scenario is?
Very unlikely.
Thank you. Let's move on to the substance of your testimony again. The petitioners argue on page 3 of the petition that the use of AP 42 emission factors, quote, demonstrates that the proposed operation will operate less than 1% of the PM 2.5 NACs And even in using these emission factors, the operation creates PM2 NAAQS exceedances in at least 7 locations. Could you address that? Could you respond to that statement, please?
The basis to deny a permit has the following language in 20.2.72.208D New Mexico Administrative Code. The construction, modification, or permit revision will cause or contribute to air contaminant levels in excess of national ambient air quality standards or New Mexico ambient air quality standard. This means that there is no basis to deny a permit if it will operate within 1% of the PM 2.5 NAAQS, because that value does not exceed the NAAQS. The statement about the exceedances at the NAAQS appear to come from the petitioner's incomplete understanding of ambient air. When EPA guidance, NMED Exhibit 13, is correctly applied, no exceedances of NAAQS were seen in modeling submitted by the applicant and reviewed by NMED. The department cannot deny the permit on these grounds.
Petitioners argue on page 3 of the petition that the applicant, quote, likely did not have an accurate expected emissions calculation because the background PM 2.5 emission concentration data provided by the department was based on an incomplete 3-year average. Could you respond to that allegation?
The EPA's guideline on air quality models says the following about developing background concentrations in 82 Federal Register 5220 at January 17, 2017. Here's the quote. The monitoring network used for developing background concentrations is expected to conform to the same quality assurance and other requirements as those networks established for PSD purposes, end quote. The reference for that sentence indicates that the methods are documented in the EPA publication Ambient Monitoring Guidelines for Prevention of Significant Deterioration, PSD. This document, which is NMED EIB Exhibit 27, says on page 23 that the monitoring for background concentrations is required to be, quote, conducted for at least 1 year prior to submission of the application to construct, end quote. If this facility were a PSD major source, the use of at least 1 year of background monitoring would be sufficient. Because the facility is a minor source and contributions of a minor source are less than that of a major source, the use of at least 1 year of monitoring data is in accordance with EPA's guideline. In this case, the department used a 2-year average of monitoring data for the years 2013 and 2014, which is more than is required under the EPA monitoring guidelines. And there's a reference in the transcript 3/22/21, day 1, transcript 250:20. The reason why the department relied on a 2-year average is because EPA shut down the Runnels Building Monitor in June 2014 due to historically low pollutant levels, leaving only the years 2013 and 2014 to create an average.
And we don't need to include the citations here. Thank you.
Okay. The use of a 2-year average is not necessarily less informative than a 3-year average, because a 3-year average could reduce peaks in concentration. The department's use of a 2-year average background concentration was reasonable. The 2-year average is more than is required by EPA guidelines.
I don't have any further questions. Thank you, Mr. Peters.
Thank you.
Okay, Mr. Chance, are you going to cross-examine this witness?
I am, Mr. Hearing Officer.
Oh, I'm sorry. Okay. Go ahead, Ms. Locke.
Okay. Thank you,
for,
Mr. Hearing Officer. Hi, Mr. Peters. I'm Madeline Locke. I'm a staff attorney with the Law Center. I know we've met before, but it's good to see you.
I definitely remember you. Good to see you.
How you been? All right, so let's just dive right in. In your job at the department, you reviewed AAM's air dispersion modeling, right? And you do this to verify that that operation won't cause or contribute to violations of applicable air quality standards, and that includes PSD increment, right?
That is correct.
And then to make this determination after calculating the facility's emissions using AP42 and figuring out neighboring facilities' emissions that are applicable, to determine whether associated asphalt will violate the air quality standards, you add the background concentration to that modeled amount after you have the facility's emissions, right?
For PM 2.5, yes, that is correct.
Yes, okay. And the department supplies that background concentration data used in the modeling. It comes from your modeling guidelines.
Yes, the value that was in the modeling guidelines at the time was used.
Okay. And we talked about this last year, but I want to talk about it again, that the guidelines are incorrect, right? It notes that background concentration data to be a 3-year average when really it's not.
Yes, that is an error in the footnote. It should say that it's based on 2 years rather than 3 years.
Okay. And you refer to this as 2 years, but it's actually not even 2 years. Is that correct?
Yes, in this case, the 2 years is from 2 years, but it's more like a year and a half.
And that's because it was data from 2013 and then 2014 until June, right?
That is correct.
And it's your position that even if it was only 1 year, that would be fine because the monitoring, according to EPA's ambient air monitoring guidelines for PSD, allows for that, right? For major sources, it allows for that.
Yes, that is correct.
And did you require AAM to do any modeling about significant impact levels for any pollutant?
Could you say that again?
Yep. Associated Asphalt, were they required to do any modeling to determine whether or not their emissions met the significant impact levels for any pollutant? Not a NAAQS level, but an SIL.
The first part of the modeling is to find out if they are above or below significance levels, and if they're above, then they do cumulative modeling. So yes.
Okay. But is Associated Asphalt considered a major source such that PSD requirements would apply generally?
There's different significance levels. There's significant ambient concentrations and significant emission rates. The significant emission rates are for PSD source determination, and the significant ambient concentrations are to determine the next, if they need to do cumulative modeling. I was assuming you were asking about significant ambient concentrations, but I think it sounds like you're asking about significant emission rates.
So really what I'm asking, Mr. Peters, and I'm sorry if that's unclear, is Associated Asphalt considered a major source?
They're not considered a major source.
Okay, and PSD requirements generally apply to only major sources?
That is correct.
Okay. And so you cite Appendix W, right? You said that the monitoring networks used for developing background concentrations is expected to conform to the same quality assurance as other requirements as those networks established for PSD purposes, right? That's what you're saying about why 1 year is okay.
But yeah, so basically we assume that since PSD requirements are more rigorous than minor source requirements, that if they comply with PSD requirements, they will also comply with minor source permitting requirements.
Okay. So I want to go to the section that you reference in Appendix W, if I could share my screen. Thank you. All right. And can you see this, Mr. Peters? board members?
I see it.
Okay. And this is Appendix W, right? It's the whole
Yes.
Federal Register Volume 82.
This is
Okay.
This is the 2017. Yes.
Okay. And this is the section you're referring to that talks about background concentrations, right?
Yes.
And this is the sentence you said about the monitoring network just has to conform to the same requirements as the PSD purposes network, right?
That's correct.
Okay. And this next sentence here, do you agree that it says, accordingly, the air quality monitoring data should be of sufficient completeness and follow appropriate data validation procedures?
Yes.
Okay, and these data should be adequately representative of the area to inform calculation of design concentrations for comparison to the applicable NACs. Is that what that says?
That is correct.
Okay. All right. So then to further support this idea that 1 year of data or 1.5 years of data is applicable because PSD only requires 1 year, you also rely on NMED Exhibit 27, which is this ambient monitoring guidelines for PSD sources, right?
Yes.
Okay. And it's from 1987, right?
That is correct.
Okay. And do you know, is PM 2.5, the pollutant we're really talking about, discussed at all in this document anywhere?
Since it's from 1987, it would be very surprising if it was, because the PM 2.5 standards were not promulgated until later.
Okay. And let's just take a look at it. So on page 9 of the guidance, right? This is where you're also talking about 1 year of background data being sufficient, right?
Right.
Okay. And it says that if a source must monitor for pre-construction monitoring, which is the situation we have here, right?
Right.
That monitoring must be conducted for at least 1 year prior to construction, right?
Right.
Okay. So first of all, this is speaking to requirements to determine emissions if the source itself has to monitor, right? It says if the source must monitor. It says if a source.
Yes, it does say source. They are
Okay.
a source and
Yeah.
they need monitoring background data. So we do need some guidance.
Sure, if a source must monitor because representative air quality data are not available. So in that sentence, to me, tell me if I'm reading this right or wrong, but it says if a source has to monitor because representative air quality data are not available, meaning if like the department didn't provide representative air quality data, then a source would have to monitor. But is that incorrect?
So that's where it gets complicated, because we're talking about a minor source, but yeah, basically we would not be requiring a minor source to monitor. We would have to, if no data existed, we would have to look far away to get some data, because it's a big state. We don't have monitors everywhere, and we certainly don't require tiny sources, well, not tiny, but non-PSD major sources to do background monitoring. It's hard enough to get EPA to pay for background monitors.
Okay, so you didn't require Associated Asphalt to do any of this monitoring.
We did not require them to do their own monitoring.
Okay. And you just, well, we'll carry on with this. Okay, so this data that you supplied instead of the source, right? It has to include the maximum values of the pollutant in that area, right? That's what this says.
And yeah, the area is not defined here. Area is up to the judgment of the modeler.
Okay, but it has to use the maximum values collected over the short period of time, the 1 year, right?
let's see, so that highlighted part you're looking at right now talks about less than 1 year. So I don't know if it's relevant. As if the whole amount of monitoring is less than 1 year, then
Okay, well then let's go back up here where it's talking about the maximum of 1 year.
is there a question?
The data that is provided for 1 year background concentration should include the maximum values of that pollutant in the area, right?
Let's see, where are you?
I'm just asking you, when you are coming up with 1 year of background data, should that year of background data include the maximum values of that pollutant? that you're monitoring
It's an
for in the area?
entire year, so it contains everything in the whole year. So the maximum would be included in the year of data.
Okay. So the PM 2.5 background data that the department relies on for this year and a half, it came from a monitor called the Runnels building, right?
That's correct.
The Runnels monitor, okay. And that monitor site is at least 5 miles from the associated asphalt site.
Yeah, that's probably good. That most of the time we or wish we would have something that close. That would be fabulous for most of our monitoring.
Okay, but is there a monitor that's closer to the associated asphalt site?
There is.
Even better?
No,
No, it wouldn't be better?
not necessarily.
Okay, but there is a monitor closer to that site.
Yes,
Okay. And the Runnels building monitor was actually shut down in 2014, is that right?
yes,
And it was shut down due to historically low concentration readings, right?
yes.
And actually, NMED recommended the use of the airport monitor instead of the Runnels building to collect PM 2.5 data as early as 2013. Is that right?
I don't know when they first recommended it.
Okay. Well, what I'm showing you now is Community Exhibit 4, and it's the 2013-2014 Air Quality Bureau Network Review. Are you familiar with this document, Mr. Peters?
I think so, yeah.
And what this is an annual report that provides information concerning the operation of the ambient air monitoring network statewide by NMED. Is that right?
Yes.
Scroll down here. Page 2. Right here. This was published in 2014. This says discontinuing the PM 2.5 monitor. That's the monitor type, right? At Runnels will consolidate with Santa Fe area PM 2.5 monitoring, since there's been an overlap with the Santa Fe airport site in the monitoring of PM 2.5, right?
Yes, that's saying that that both monitors overlap, that they essentially have the same domain of monitoring.
Okay.
Ms. Locke, is this document in evidence?
Yes, it's part of the original record from the March 2021 hearing.
Community
that was
Exhibit
provided.
4, okay, from the record below. Okay,
Yes.
thank you for clarification.
All right, Mr. Peters. And so the airport monitor has been in existence and operating since at least 2016, right? Or 2013, I should say.
So yes and no. When
Okay,
they
and monitor
first,
has been at the airport since 2013.
a monitor has been at the airport since 2013, and up until 2017, it was not of quality that EPA would accept concentrations from it.
Okay. But in 2017, EPA, it transitioned right into the it's a federal equivalent method monitor, that EPA could reliably consider that PM 2.5 data for this purpose, right?
March 2017, the switchover occurred to the EPA approved monitor.
Okay, okay. And so I want to go back to this document. Yeah, Exhibit 27, okay? So there's this highlighted section here saying that 1 year is 1 year, right?
Yeah.
If you scroll up here further, we're going to talk about the currentness of the data. So even if 1 year is okay, this data has to be considered current. Is that correct?
It does not define current.
Well, actually it does, Mr. Peters. If you could just read this highlighted section, this would mean for the pre-construction phase that the data must have been collected in the 3-year period preceding the permit application. You see that?
Yes, I do see that.
Okay. And 2017 to 2019, when the Bureau received Associated Asphalt's permit application, that would be a 3-year period. Is that correct? At least a 1-year period.
Yeah, the full year of 2018 would have been available at that time.
Okay, but that was not the modeling or the monitoring data that was used to determine the background concentration?
That's correct. That was not used. And it also says generally there, it does not say that explicitly it will be a 3-year period. It says generally this would mean.
It would have been collected in the 3-year period, right?
Yeah, so in general, that would happen. If there's other considerations, then something outside of the generality that it talks about at the beginning of that sentence would be considered.
Okay. Well, and that's interesting that you say that, because NMED's own guidelines also require the use of recent monitoring data. Is that right? For background concentrations?
That is the intention and the language, yes.
Okay. And the language also says that that's because concentration trends are likely to change over time. You agree with that?
Yes, I think I wrote that.
Okay. And then last year, you might remember, you testified that recent would mean in the last 5 years. Is that correct?
I'm not ready to define what recent would be without doing further analysis.
Okay, Mr. Peters.
I mean, how it depends on how much growth there is in an area and how much change there is, what other factors. There's a lot of things that go into deciding what recent is as far as what's applicable for modeling.
Okay, but based on NMED EIB Exhibit 27, seems like EPA is saying recent would be data collected in the last 3 years, the 3-year period before the application.
Yeah, ideally it would be the last 3 years.
And Mr. Peters, isn't the point of background data to have it be complete enough and sufficient enough that it captures the variability of the area to accurately reflect background pollutant concentration at any given time in the modeling?
Any complete year would capture variation. So I don't see what your question is.
Well, the point is that the data needs to capture all possible scenarios, right?
If you're adding multiple years, then you can average out maximum peaks and lower concentrations. Is that what you're asking?
No, I'm just asking if the point of the data is to sufficiently describe every possible situation, every possible scenario, like you were talking about, the maximum background is combined with these other factors to demonstrate worst case scenarios, right?
Yeah, for the The monitoring does use the 98th percentile for the 24-hour average and does use the annual average. So those are the values that go into the modeling.
Okay. So let's talk about the guidelines themselves. And you actually said you wrote the portion of the guidelines that talks about background concentration modeling, right?
Probably.
Ms. Locke, it's, by my watch, it's about 5 after 12. I'd propose we break for lunch now and come back at 1, take public comment, and then allow you to continue your cross-examination. But I don't want to cut you off. If you want to continue for a few minutes to reach a stopping point from your perspective that's logical, you can do so.
Thank you, Mr. Hearing Officer. And actually, we were going to shift gears, so now would be a perfect time. So thank you.
Okay. That was my perception, but I wanted to check with you before we decided to break. We will now take a lunch break and we'll come back at 1 o'clock. We'll take any public comment and then we'll continue with the cross-examination. Thank you. If we have any public comment to receive at this time.
I have not been contacted by anyone who wishes to make public comment, sir.
Okay. There being no public comment, I want to take care of an administrative matter related to scheduling, and then we'll go back into cross-examination. It appears as if we have a good likelihood of being able to conclude the hearing today. We have Mr. Peters and one more brief witness that the department is going to present. And then we will have rebuttal, and rebuttal should be limited to matters that came up during the hearing, primarily during cross-examination, that the parties want to provide response to, and it should be focused. So I'm expecting that the rebuttal phase, if any, will be not be extensive. Can council give me an idea at this point of what you're thinking in terms of what you want to present, or how long your rebuttal will take, if any?
This is Chris Field, New Mexico Environment Department. I'm looking at our rebuttal testimony. Mr. Hearing Officer, give me about 30 seconds and I'll give you a very good idea of what we're going to do.
Okay.
Petitioners would only brief rebuttal, I think, limited to.
Excuse me, I'm sorry.
Oh,
Is
sorry.
that
Can
block?
you
You were
this
cutting
is
out.
Rosalind.
Okay.
Sorry. Is this better?
Yes.
Okay. The
You
petitioners would
proceed.
just. Sorry.
I was going to say, please proceed while Mr. Vigil is doing his review.
I can actually respond. We have extensive rebuttal prepared that is at least as long as our direct. That is, responding, in particular to the various 21 challenges that Mr. Snyder had brought, for example. I'm just letting you know that was our intention. So I'll just put that on the table, and that's where,
I'm sorry, Mr. Vigil, you were cutting out. Can you get closer?
Oh yeah, I'm sorry. Is this better?
It is.
Okay. The Bureau we have our rebuttal that we've prepared is just as extensive as the direct that we gave, if not longer, because of the various challenges that were brought up. Now, I'm not being argumentative. I'm just telling you what we prepared. And so that was our plan, was to put on our rebuttal, and it is pretty extensive at this point.
Okay. Ms. Locke?
The petitioners wouldn't have an extensive rebuttal. We would have 2 rebuttal witnesses. To present.
Okay, and I had understood the latest information I have is this Dr. Sahu is not available today.
That's right,
Is
Mr.
that-
Hearing Officer, but we don't intend to present him for rebuttal testimony.
Okay, he's not going to be a rebuttal witness.
No, Mr. Hearing Officer.
Don't worry about his schedule.
And Mr. Hearing Officer, I know everyone, has family and health and, sanity to preserve, but, on the department's end, we're willing to, to go the distance to finish tonight if everyone else is willing.
Okay, well, let's see how it goes. We'll finish up with the cross of Mr. Peters, and then we'll allow the petitioner's rebuttal, and then we'll see how much time's left, and we can have a discussion about whether we believe we can get through the NMED's rebuttal today or not. So let's proceed now with Ms. Locke's cross-examination of Mr. Peters.
All right. Thank you, Mr. Hearing Officer. Hi, Mr. Peters.
Hi.
All right, so I want to go back to this 1-year idea just briefly, right? Okay, so 1 year of data to determine an accurate background concentration number is sufficient in your position, right?
Yes, 1 year is sufficient, particularly for a monitor that isn't truly background. Background monitors shouldn't include a whole bunch of things. It's supposed to represent the background concentration without too much influence with human activity. In other words, you're not supposed to include the stuff that's in the explicitly modeled in the background monitor.
Right, because you model explicitly for certain sources and then you add background to that, right?
Yep, correct.
I understand that. Okay. So if 1 year is sufficient and you're saying the Runnels data would have been appropriate data to collect data for just 1 year, right?
Yes,
Okay. And 1 year, right, is sufficient because it captures everything, every possible scenario can be captured by just 1 year of data, right?
I mean, the purpose of monitoring is to get a full year of data and I mean, all the conditions in that year, yes.
Okay. So let's just look at that real quick. So I want to show this. Do you see my screen, Mr. Peters?
I do.
Mr. Hearing Officer and everyone? Okay. And so what I'm looking at is your air dispersion modeling summary for the permit. You
Yes.
familiar with this?
Yes,
Right? Okay. So when the modeling for PM 2.5 was done, right? You modeled to compare it to both a 24-hour standard and an annual standard, right?
correct.
Okay. And then if you scroll up here, maybe I'll just try to make this smaller so it all fits. Okay. You have to model the facility concentration, which is just the amount of that pollutant that is coming from the facility itself, right?
Correct.
And then you also have to model what that pollutant looks like everywhere in both the ambient and non-ambient air, and that's the modeled concentration, right?
Yeah, the modeled concentration is the total of all the modeled sources,
Okay.
including the surrounding
that-
sources.
Okay, and that includes, presumably space where public would be, right? That concentration amount.
Yes,
Okay. And so then you add this background concentration number right here, which came from the modeling guidelines that department supplies, right?
Correct.
You add this number, the 9.45 number, to 24.570 because that includes the ambient air pieces of this, right?
Correct.
And that gives you this 34.020 number, right?
That is correct.
Okay. And 34.020 is what we're saying here is 97.2% of this 35 micrograms per cubic meter standard, right?
Yes.
Okay, just want to make sure I understand that. So what I want to look at is if 1 year is adequate, what that might mean if you're looking at different years, okay? So if 1 year works, and we're going to use the Reynolds building, I want to ask you some questions about something. So what I've clicked on here is a report from Dr. Clark, and you were here for Dr. Clark's testimony yesterday, right?
Yes.
Okay. And he explained that he included monitor values from what he pulled from EPA, but these are actually numbers reported by the department, right?
Right.
Okay. So does this sort of chart look familiar to you at all? Is this what it looks like when you pull it from EPA's website?
Objection. I just want to be clear. Mr. Peters is not here to testify about Dr. Clark's testimony.
I'm not asking him to, I'm just asking him to look at this chart. Oh, you're muted, Mr. Hearing Officer.
Is this from Dr. Clark's testimony?
Yes, but if it would be better, I can pull it from EPA's website directly.
Yeah, let's do that.
Stop sharing my screen here. I apologize, Mr. Hearing Officer, if you could just give me a minute. I apologize, it's taking a second. Okay. So, Mr. Peters, can you see this?
I see it.
And it's this EPA monitor values report, right? Is
Yes.
that what you're looking at? Okay. Actually, let me just make sure this is.
Mr. Hearing Officer, you're muted.
I was asking Ms. Locke if she could identify the source of the document. In other words, where is it published?
Sure. So this is just
Is there a
online.
citation? Yeah, is there a cite? I see the title, but is there a citation to the document that we could
So
reference?
the chart itself is a part of Dr. Clark's testimony. It's been admitted as Dr. Clark's report, but the department preferred that I pull this same data directly from EPA.
Okay, this is the same. Can you identify where it appears in Dr. Clark's testimony?
Yes. It would be on page 56 of his full report with attachments. It's the PM 2.5 data concentration from EPA for the year 2013.
Okay, and it's identical to what appears on page 56 of Dr. Clark's testimony.
Yes, sir.
Okay, thank you.
Thank you. All right, Mr. Peters, so this is the data that NMED reported to EPA from the Reynolds building for 2013. Is that right?
I'm looking for the year. Oh, there it is.
Hmm.
Yes.
Okay, and you can see here it comes from the Reynolds building.
Yep.
Yeah. And I want to do a couple things with this. So the first is looking at this, you see this 98th percentile number.
Yes.
It says 12. That's the 98th percentile number that had your report modeling summary here. That would have been the number used for background concentration for the that would have been the number you added instead of 9.45. Is that correct? If it was just 2013?
Yeah, if it was just 2013, that is the number from that monitor for that year.
Okay. So if you only used that 1 year of data, 2013, which you say is appropriate, and you added 24.570 and 12, my math suggests that you would get 36.57. Does that seem right to you?
Without rerunning the model to adjust for things.
So, but when you added 9.45 to 24.57, you got 34.
This question has been asked and answered. It's not, Mr. Peters has indicated that Ms. Locke's overly simplistic. This is not elementary school math. He just told her that there are other calculations that have to be made. The question's been asked and answered. Ms. Locke's been doing this for about 20 minutes. I still haven't heard a question that's substantive to this hearing.
Ms. Locke,
Well, my question was going to be whether or not he made adjustments when he added 34 or when he added 24 and 9, because he didn't mention that when I originally asked him how he got to that 34.020 number.
yeah. Objections overruled. Proceed with your question.
Thank you, Mr. Hearing Officer. So, Mr. Peters, when you added this background number that you got as a 18-month average from EPA, 9.450, to 24.570, and you got 34.020, were any adjustments made in that math in running the model?
It demonstrated compliance, so there would be no reason to look for additional changes to make to the model.
Okay, but just with simple math, you got a number that was compliant with the NAAQS. I understand.
Yes.
So, and it sounds to me like what you're saying is if you got a number that was higher than 35, which you would have gotten if you added the background from just 2013, that then more modeling adjustments would have been made to demonstrate compliance or not. Am I hearing that right?
Most likely, yes.
Okay, but just using the number 12 plus 24.570, getting a number that would be 36.57, that without making modeling adjustments would violate the 35 micrograms per cubic meter NAAQS standard, right?
Yes.
Okay. And then the same thing for the annual concentration. So for the annual, just to make sure I get it right, you added the modeled concentration, 7.592, right?
Right.
To this background number that you got as this 18-month average from 4.320. You added them together and you got 11.912.
Right.
Which was just under this 12 NAAQS standard, right?
Correct.
Okay. So then if we go back to the EPA data, and that number is the annual average, right? That 4.95 number. Make sure I have that number right. This number that you added, this 4.32, that background concentration number? That
Yes.
would be this weighted annual mean, right?
Yes.
Okay. So if you added that number instead from just the year 2013 to 7.592, you would get 12.592 instead of 11.912. Does that sound right?
I'm going to accept your math without.
I mean, you can use a calculator and check
Yeah.
me if you would like.
Yeah, it would. Yeah, I agree. That would change the total of by using this this other year this year that was used differently than was represented in the application.
Okay. And 12.592 would be over the NAC standard, right?
Yes, the standard is 12.
Thank you, Mr. Peters. Okay. So you heard Dr. Clark talk about the meteorological data, right? That
I
was used
did.
in the modeling. And we've
Yes.
talked a little bit about the meteorological data. So it's the department's position that 1 year is acceptable, right?
Yes, the department selected the highest, the year that would, out of the available years that would produce the highest concentration, so we could save time by running only the worst case year instead of multiple years.
Okay, so 2016 is the worst case year,
Yes.
and you did that to save time.
Yes.
Okay. Do you know, Mr. Peters, if more than 1 year of Met data, more than 2016, was available to be used?
I seem to recall there were at least 4 years that had been processed.
Okay.
Normally, we only use 1 year for minor sources like this and choose the worst case data and use that.
Okay. Up one thing for you. All right. All right. Do you see that, Mr. Peters?
Yes.
And we've looked at this before. It's the Federal Register, right?
Yes, this is yeah, the guideline 2017 version.
Yeah. And it's the guideline you rely on.
This is the EPA guideline that we rely on for most things.
All right. And this is the section that covers meteorological input data, right?
That's correct.
Let's see, I want to go down to section E. Do you see this section right here, Mr. Peters?
I do see it.
And it says, and I understand it's your position that the Met data used was site specific, right?
Right.
Right. Okay. So this is talking about the use of meteorological data and what should be used, right? And it covers, well, first it says, should acquire enough meteorological data to ensure worst case conditions are adequately represented, which you agree with, right?
Yes.
And the use of 5 years of representative National Weather Service or comparable meteorological data could be used, right? That's what that says.
It's one option.
Mm-hmm. Another option is at least 1 year of site specific.
Correct.
And then another option is 3 years of prognostic meteorological data, which I understand is sort of looking forward, right?
Yeah, that's a modeled simulation of data.
Yeah. Okay. So this next sentence is what I kind of want to draw your attention to. So if 1 year or more, up to 5 years of site-specific data are available, these data are preferred in air quality analyses. You see that?
I see that. And
And you have at least 4 years of met data at the time.
the guideline applies to PSD major sources, as you'll see at the very top of the guidance. For most purposes, we use it, but this is a minor source, and we are not required to use that when we have a time-saving shortcut, like using the worst case year of meteorology instead of adding other years that reduce the concentration when you add those years to it.
So how are you sure that 2016 was worst case data?
I don't remember the numbers in the original hearing that discussed that, but this is the year that had the most slow wind speeds that tend to cause the highest concentrations at this type of facility.
But if more years would be more adequately representative of what was going on in the area,
No.
and EPA recommends using that, why not use it? Just to save time? Is that what you're saying?
Yes. Well, okay. So when more representative, there's two different things: more representative and more conservative. If you choose the more conservative option, you can run just 1 year and get done 5 times as fast. Or you can run the more representative version and get a lower concentration, and it takes 5 times as long to run the model. That option is available to people that submit applications for minor sources.
So when you say conservative, you actually mean sort of like operational efficiency, not necessarily protective or representative of the area.
By conservative, I mean maximum possible predicted concentration. So you'll predict a higher concentration using the more conservative method than you will on the other method, on the less conservative method.
But the more conservative method is using just 1 year instead of 5 years.
That is correct.
Okay. Do you know, Mr. Peters, if what you're saying, just using 1 year because it's more conservative, is consistent with what other states do?
I don't know.
And again, Mr. Peters, you're saying the point of modeling is to model all possibilities and that just 2016.
Asked and answered. She even said again. So she's going back to the same question she started with before lunch.
I'm not going back to the same question I started with. I have a different question. I was just trying to lead into the question in a way that made sense for Mr. Peters, the board members, and the public.
Okay, objection is overruled. You can proceed to ask your question.
Thank you, Mr. Hearing Officer. So, Mr. Peters, I just want to get a sense of if the year 2016 is supposed to reflect everything, is that the same as saying that any worst conditions in 2019 that maybe didn't happen in 2016, they're the same year based on the modeling, no matter what?
So the worst conditions are the slow, steady wind speeds that take the pollution straight from the facility to the fence line without any dispersion. And the year that has the most of those years, the most of those situations is the year that's going to produce the highest concentration, because that's just the way the modeling works and dispersion works. So if there was a year that had different situations, it would, well, if it's going to produce lower concentrations, because you've got the maximum considered for a different type of source. That might be something slightly different, but this is an asphalt plant. The emissions are emitted low to the ground. The worst case situation is when the wind is slow and steady and goes straight to the fence line and there's not turbulence. So basically 2016 is the year that would produce the highest concentrations for this type of facility out of the available years at that time.
Okay. Mr. Peters, I want to talk to you a little bit about the modeling grid that you used, if we could.
Okay.
So grid spacing, as we heard yesterday, is an input in the model. You have the receptors spaced at a certain distance. And that grid is supposed to be refined enough to demonstrate where the concentration of the pollutant is going to be the highest, right?
That's correct.
Okay. And the model that NMED approved had a 50-meter grid spacing at the fence line, correct?
Yes, they use the 50-meter spacing recommended in our modeling guidelines.
And it was your position last year at the hearing that further refinement at the fence line would be an abuse of the model, correct?
Correct. No evidence to show that the concentrations are more accurate by reducing the receptors spacing.
No evidence suggests that you should do that. Find the grid further at the fence line.
None that I have seen.
But you were here yesterday
I was here yesterday.
and you saw EPA's checklist that says you should refine it to 25 meters at the fence line.
I saw that document that is fake EPA guidance.
I'm sorry, fake EPA guidance.
Yeah, do you want to show the checklist? At the beginning of the checklist, it says this is not present new EPA guidance. And then it says there are references. If you go to the section for meteorology, it says go to the guideline to find out what, I think it was section 8.1 or 8.2. And it says that go there for the details on receptor spacing and domain setup. So if you go and check that reference, you'll find that it does not mention the parenthetical example that was mentioned by Dr. Clark et al. In that section that it is supposed to show it.
Okay. So I think we can come back to that, but I want to just be clear that the law, Appendix W, right, around receptor spacing, let's look at it. You see the Federal Register? Oh no, hold on. Can you see that, Mr. Peters?
I see, yes, I see Appendix W, the modeling guideline.
Okay. Oops. All right. So this section, design concentration and receptor sites, this whole section is talking about receptor sites and spacing, right?
Yes, that is different from what was referenced in the checklist, but that does say design concentration and receptor sites.
Okay. So this section in 9.2.2D, sure I get to the right place. All right. Says receptor sites for fine dispersion modeling should be located within the modeling domain, section 8.1. That's the section that I think you mentioned about the
Yes.
checklist, is it right? Okay. You see this in designing a receptor network, the emphasis should be placed on the receptor density and location, not total number of receptors, right? You see that?
Yeah, that is correct.
Okay. And then typically the density of receptor sites should be progressively more resolved near the new or modifying source, areas of interest, and areas with the highest concentrations. See that?
Yes, just like was done in the modeling submitted.
where you refined it to 50-meter spacing, right?
That is correct.
And the NMED guidelines say 50-meter spacing is recommended. Is that right?
Yes.
And as part of the answer document that the Environment Department filed, it put a ton of permits attached to that answer. Are you familiar with that?
No, but I know permits exist.
Okay, all right. So hypothetically, then, if a different state refined their modeling grid of the fence line to 25-meter grid spacing instead of 50, would that be going against some kind of guidance?
That would not go against, I mean, states have rights to determine their own receptor spacing requirements.
Okay, so that wouldn't be an abuse of the model as you originally said it would be.
So what number did you say the spacing was?
25 meters?
I did not say that 25 meters was abuse of the model.
Well, last March, you did say 25-meter spacing would be considered an abuse of the model.
I believe I was referring to the 10-meter spacing that Dr. Clark was using. I don't know, but in any case, we don't have evidence that you get more accurate concentrations by using lower than 50-meter spacing.
But doesn't EPA suggest that you should refine the model once you find exceedances to show more clearly where those exceedances might be?
If you start with 1,000 meters and refine it to 50, then you did just that.
But if you found exceedances at 50-meter spacing, which the modeling did show that, according to your modeling summary, should that have been refined further to make clear where those exceedances were?
I don't believe there's EPA guidance that says you refine it and refine it again and refine it again. It just says you start with something and then refine it to a reasonable amount.
A reasonable amount to demonstrate specificity, right?
Right.
And is refining it 3 times the same as refining it again and again and again? I think that was your abuse of the model problem last time.
It depends on what you started out with. What we say on our guidelines is that and we had to make a decision on some recommendation to make because people were finding ways to make everyone have to redo their model. We have to provide some guidelines, and so we researched EPA's historic use of receptor spacing and determined that 50 meters was an appropriate amount for a fine receptor grid. And we put that in our guideline for people to use so they can rely on the guidelines and get an acceptable analysis instead of needing to redo the models when we totally change the receptor spacing all the time to trick them out of whatever permit they thought they had applied for.
Okay, so you researched EPA's historic practices to come to that 50-meter spacing number?
I did not at the time, but someone else did. I looked at it more recently and confirmed that.
Okay. You didn't look at what other states might be doing in terms of refining a grid or anything like that? Or Albuquerque?
I did not look at other states or Albuquerque.
Let's see. All right, let's talk, Mr. Peters, a little bit about this definition of ambient air. Okay.
Okay.
we all, I think, can agree that the definition of ambient air is that includes the portion of the atmosphere external to buildings that the general public has access to, right?
Yes.
And in your modeling summary, you noted that NACS concentrations were predicted within the fence line of several facilities, but these exceedances were excluded from your assessment because the contribution of a facility to concentrations within its own fenced property should not be considered to affect ambient air, right?
That is correct.
Okay. So that means that in modeling AAM's pollution, you found exceedances within the fence line of different facilities, neighboring facilities, right?
Could you say that again?
Yeah, so that means that when the modeling was done for Associated Asphalt, you found an exceedance within the fence line of facility B.
Yes,
Okay. And facility B is not owned by Associated Asphalt.
that's correct. They have
It's not
their own permit.
controlled. Sorry?
They have their own permit.
They have their own
Yeah,
permit.
they're separate.
And it's not controlled by Associated Asphalt in any way, right?
That's correct.
So did you then determine what portion of facility B's own emissions contributed to sort of the overall pollution amount in that area?
Only within facility B's fence line did we
Right.
do that.
Yeah.
Yes,
Okay. And then you were able to take out facility B's own contribution from the total concentration, right?
that's correct.
Okay. And then that got rid of the NACS exceedance problem, right?
That's correct.
Okay. And that's because it's your position that EPA allows for exclusions of NACS exceedances or exclusion of emissions from property owned or controlled by other parties as long as it's non-ambient air from that own facility standpoint.
Yes, as seen in Exhibit 13, and I think it was Exhibit 25, the other,
Yeah.
EIB Exhibit 25.
Yep, that 1989 memo. Okay, so let's see. So I don't have to show it to you, but basically what it said was Mitsubishi was allowed to exclude exceedances at facility B, even though Mitsubishi did not control facility B, right?
That's right.
Okay. And were you here yesterday when Dr. Sahu was presenting his testimony?
I was here.
Okay. And you heard Mr. Sahu say that guidance evolves, right? You, I think, even said that guidance changes and that impacts the work that you do.
Guidance changes sometimes.
Sure, yeah. I want to pull up, and actually, Mr. Hearing Officer, I apologize. I have to run and let my dog in. She's ruining my door really quick. If we could just take like a 3-minute recess.
Okay, we'll take a 3-minute recess and come back
Thank
at
you. I'm sorry.
47.
Oh.
Okay, Ms. Luck, I see you're back. Are you ready to proceed?
I am, Mr. Hearing Officer. I apologize
Okay.
about that.
Okay, we'll reconvene. You can proceed.
So if I could show this to you, Mr. Peters. Can you see this?
I see it.
And it's this 2019 memo from Andrew Wheeler, the revised policy on exclusions from ambient air, right?
I see it.
Okay.
Hey, Ms. Locke, is this in evidence? And if so,
Yes,
could you
sir.
identify which exhibit it is? Okay.
Yes, Mr.
Community-
Hearing Officer, it was
Two, I
Community
see.
Rebuttal Exhibit 2 at the first hearing and NMED EIB Exhibit 26.
Okay, if you could
Also,
these documents by the exhibit number in this proceeding, that would be helpful. Sometimes, at least on my screen, the exhibit information doesn't show up. So I can't track it unless you provide it to me.
certainly, sorry, Mr. Hearing Officer. So it's NMED EIB Exhibit 26. And Mr. Peters, are you familiar with this document as well?
I'm confused. It says at the top it's Community Rebuttal Exhibit 2, and you just said EIB
That's
NMED. Wait,
It was also Community Rebuttal Exhibit 2 at the hearing last March. That's
Okay.
why it's labeled that way. But are you familiar with this document?
I'd have to review it to see.
Okay, but it was presented by the department yesterday.
Ms. Locke, could you scroll down? I think he would recognize it if you showed him the scenario you're talking about.
Okay, well, so I know you all used it for ambient air fence line definitions. And this
No,
isn't,
I agree with you, but you're asking him if he recognizes it. If you show him the Mitsubishi scenario, I think he'll recognize it. If this is
so
the same
this
document.
isn't the Mitsubishi memo, it's the
Oh, I'm sorry.
2019.
Okay, I'm sorry. I was trying to be helpful. I see I'm wrong. Sorry.
I appreciate that, no worries. So this is the updated policy guidance regarding ambient air that was discussed yesterday, Mr. Peters.
Is this the one that reduces that basically expands the guidance to not exclusively have fence lines, but also consider other equivalent methods?
Yes, that's this one. Mhm.
Yes. Yeah. Okay. I am familiar with this.
Okay, great. So I want to scroll down to a different part of this that wasn't talked about yesterday. All right. So, and you're right, that the main point of this whole document was to expand it to say it doesn't have to be an actual fence to be considered fence line, right? But there's some
Yes.
interesting stuff in here that I would like to show you. So do you see this sentence here, this first sentence that says, although the draft revised policy did not propose any change in this element of the ambient air policy, some commenters advocated that the EPA allow exclusions of property owned or controlled by other parties. You see that?
Yes.
And that's what, by what you just said, what NMED is doing, right?
Yes.
Okay. And these commenters argued that the regulatory definition of ambient air does not mandate that the source own or control the land from which the public is otherwise excluded. You see that sentence?
Yes.
And that's what NMED is doing?
Yes.
Okay. And really, this relies on sort of how the general public is defined, right? Because it's this idea that if the general public doesn't have access, regardless of who controls it, then it can be considered non-ambient air such that the NAAQS exceedances can be excluded. Is that right?
Could you repeat that?
Yeah. So the idea with ambient air being defined as the space that the general public has access to, right?
Right.
It means that non-ambient air would be a place that the general public does not have access to, right?
That sounds generally correct.
Okay. And actually, if we want, we can just read how EPA explained it. But EPA says, as discussed above, the EPA's policy allowing exclusion of some areas external to buildings is not based on language in the regulatory definition mandating exclusion or providing particular criteria for such an exclusion, but rather is inferred as the inverse of what is affirmatively covered by that definition of ambient air. They say, i.e., if ambient air is defined as that to which the general public has access to, then that to which the general public does not have access to is non-ambient air. Right?
Yes, I agree that it doesn't need to be in the definition. It's because they found a way to infer it.
Okay, all right. So let's see. And it goes on to say that the EPA's view is that the general public has legal access to areas that are owned and controlled by parties other than the owner or operator of a stationary source. You see that sentence?
Yes.
So that to me is the EPA saying that the general public has legal access to areas that are owned and controlled essentially by facility B if you're doing the modeling for AAM. Do you agree with that?
I don't want to, yeah, as one sentence taken out of context, I'm not sure if I know the answer to that.
Okay, well, we read all the whole preceding part of the paragraph, but we can keep going. So the EPA continues to view the general public to include any person other than those who are permitted access to the property as employees or business invitees of a specific stationary source, including trespassers. You see that sentence?
Yes.
Okay.
Mr. Hearing Officer, this seems like it's getting into property law, first year law school property law definitions of business invitee and all this other stuff. Mr. Peters is a modeler. He is not an attorney. He doesn't know property law. He doesn't know these terms. And so I'm not sure where Ms. Locke's going with this, but I wish she would get there.
Mr. Hearing Officer, this comes from an EPA document about the definition of ambient air. It has to do with who is considered the general public. And Mr. Peters wanted more context, so I could skip that sentence and carry on to make my point.
Yeah, this does, I don't think the question requires a legal conclusion. I believe it is just asking for Mr. Peters' understanding of this EPA document, which in fact relates to what he does every day. So I think it's appropriate to have him answer the question.
Thank you, Mr. Hearing Officer. All right, Mr. Peters. So it then says, although a landowner who owns a stationary source downwind of another landowner's separate stationary source may restrict public access onto his or her property, the owner and the individuals that are permitted access to that downwind property are, generally speaking, members of the general public relative to the upwind stationary source.
Objection, Mr. Hearing Officer. This depends on Mr. Peters' understanding what a business invitee is. I understand that this touches on regulatory policy. That is why the Environment Department has lawyers. That's why the EPA has lawyers. When these types of things come up, Mr. Peters is part of technical staff. They have to talk to an attorney. Mr. Peters has to define what a business invitee is in order to distinguish it from a member of the public. Members of the public are not business invitees. And the three of us know, or every attorney on this call or in this meeting knows why that is. Mr. Peters, I don't think knows why that is. So this is not in the scope of his expertise. And I'll ratchet down my tone, by the way. I apologize.
And actually, you're, Mr. Hearing Officer, I'd appreciate Mr. Vigil not speaking for me and what I do and do not know.
Okay, Ms. Locke.
Mr. Hearing Officer, I would say that the definition of ambient air is contingent upon what the general public is. And if Mr. Peters made the decision to be able to exclude a facility based on his assessment that the general public could not access that facility, then he would need to be able to understand how the EPA is defining general public, which includes pretty much all people at facility B based on this memo. So.
And that is a false statement, Because what they're talking, a business invitee is not a member of the public, strictly speaking. So I won't say anything more. We'll leave this for the Court of Appeals to decide.
Okay, again, I think this question goes to Mr. Peters' understanding of these EPA documents in his role, in his duties as a modeler. If he thinks the question is asking is beyond the scope of his ability to answer, he can state that. So let's proceed.
Thank you, Mr. Hearing Officer. And even going with whatever definition of general public that you have, Mr. Peters, this sentence says, although a landowner who owns a stationary source, for the purposes of this conversation, let's call that Associated Asphalt, they own one stationary source, downwind of another landowner's separate stationary source, facility B, or I guess flip those. So although a landowner who owns a stationary source, facility B, downwind of another landowner's separate stationary source like Associated Asphalt, may restrict public access to his or her private property. So facility B can restrict access. The owner and the individuals that are permitted access to his or her private property, facility B, are generally speaking members of the public relative to the upwind stationary source, Associated Asphalt.
Yes, so I agree that that means that the initial Associated Asphalt in this case, that their contributions and everyone else's contributions within this downwind source are considered as ambient air. It's only the downwind source itself that is in question.
So you have AAM modeled, right? And facility B. And from the perspective of Associated Asphalt, facility B is in the ambient air, right?
Right.
Okay. And then this last sentence, just want to read, says an alternative reading of the general public that excludes all persons on any private property to which access is restricted would expand the exclusion beyond reason and deny the protection of the NACs to a large number of people. You see that sentence?
Let me reread that just a second.
Okay. Sorry, I know there's a lot of highlighting.
Yeah. So this is not talking about, this talks about all excluded, all fenced areas. In our discussion with permitting, we're only talking about other facilities that have permits that require them to restrict access. Mm-hmm. So it doesn't look like that that applies here.
Okay. All right, Mr. Peters, I just have really one more question for you. You said earlier that the modeling is supposed to show, what would happen if sort of every bad thing happened at the same time, right? You had the maximum background plus the maximum emissions plus the worst case meteorological situation, and that might result in a NACS violation, right? Or may not. That's what the model is for.
So that is the starting point of the modeling, and it does that by default. That doesn't mean that it can't be refined to overpredict concentrations less than the starting point.
Okay. And you basically said that a scenario where everything bad happening was very unlikely that would happen, right? But the modeling has to be able to show that, right?
Right.
Okay. Is that impossible?
No, it's not impossible.
Okay.
I don't know if it's impossible.
Okay. And do you know, does the Clean Air Act allow you to consider likelihood when modeling air emissions?
We,
In that context, does it allow you to factor
so
in
what,
likelihood?
what we do is we demonstrate compliance with the air quality standards, and likelihood has nothing to do with it. It's just whether you can demonstrate compliance or not. So if you reduce the overprediction of the model, that might change the likelihood, but that is allowed.
And you keep saying over prediction. What are you talking about when you say over prediction of the model?
When I say overprediction, the model thinks that all the worst case situations are going to happen at the same time. And so if reality is that only 2 worst case situations happen at a time, or only 1 happens at a time, then you'll get much lower concentrations in actuality than you would have predicted in the model. The model is designed to protect everyone from air quality standard with the air quality standards, but it's not designed to be accurate. It's supposed to be the maximum potential possible concentration.
Okay, potential and possible though, so that doesn't mean impossible.
I would need to run an analysis to figure out what whether it's even possible to have all of the situations occur at the same time. If the high background is caused by high wind speed and the high modeled concentrations are caused by low wind speed, then high wind speed and low wind speed cannot occur at the same time. So I would have to study that to find out if it was even possible.
Okay. I have nothing for you. Nothing left for you, Mr. Peters. Thank you, Mr. Gang Officer. Thank you, Mr. Peters.
Thank you.
Okay, do we have any questions from members of the public? Any questions of Mr. Peters from members of the public? Okay, seeing and hearing none, we will go to,
There's
excuse me, yes, Ms. Marianello. Ms. Marianello? You're muted, I think.
Right, sorry about that. Yes, I've been muted all day. I do have just one question for Mr. Peters, and that is, where does he live?
I live southeast of town.
Right. Thank you.
Okay, any other members of the public have questions? Okay, seeing none and hearing none, we will go to questions from board members. Do any board members have questions of Mr. Peters? Yes, Ms. Davis.
Thank you, and thank you, Mr. Peters, for testifying today. I just have a few questions. The first one was, when you're running models, I think I understood this from an earlier, from somebody testifying earlier, that the company actually runs their model and then you use that model to put the permit together. So I'm curious, how do you QC the data from the model that they run and you ultimately use the permit?
Okay, yeah. So in this case, I look at the application form after the permit writer verifies the emission rates, and I make sure that the emission rates in the model are the same as the values that are in the model. And then I knew this facility was in a pretty busy area, so I wanted to make sure that it was really done well. I did a lot of extra work to look into the surrounding sources and make sure that those nearby sources were represented correctly. I then had the applicant has an opportunity to update the model, and so he and I did additional research on those nearby facilities where I thought it might predict violations of air quality standards. And we looked at those, found out what the actual emission rates were and what the fence lines were, and then remodeled and to demonstrate compliance. I also verify the inputs, all the model settings, and I'm not sure how much more detail to go into.
No, that's okay. Thank you for that. I was just curious, just kind of about the process there. So thank you for answering that for me. And part of that, do you check the numbers and just kind of verify that portion of it?
I verify the emission rates and I look at the outputs. So yeah, I do verify the input numbers and I look at the outputs to make sure they're reasonable.
Okay, and kind of moving on to another topic here. Does about the emission standards and thresholds when you're modeling, I'm curious if the department has any internal guidance when an applicant's emission standard is near the threshold. So if it's at 97 or 99%, if they if that has any internal guidance to like trigger some additional calculations or anything like that?
Well, so before the applicant submits the modeling, they're going to make sure that they show they're below the air quality standards. Now, if I see that a number is close to the standard, I will look at it more closely in the review to double check things more than if they're much farther from the standard. But there's no guidance. If they're 100% or lower, then they can get the permit. There's no requirement for them to do any refinement of the model, which they probably could do to show that they were much farther from, or at least farther from the standards.
Okay, thank you. And my last question is about the AP 42 standard. I know we've talked a lot about that. I was just curious, is there a different standard available outside of AP 42 that could possibly be used or is used in certain scenarios?
I'm not sure if I'm the best person to answer that question, but there are limited limited choices of factors to use for calculating emissions, particularly if part of the facility is reconfiguring. And I'm not sure about the details of that.
Mr. Hearing Officer, this is Chris Vigil, and I'm sorry to interrupt the member, but we are willing to offer our witnesses as a panel to the board members as well if they have questions. So we want to make sure that every question gets answered. I just wanted to make sure that the board members knew that.
Thank you, Mr. Vigil. And I appreciate that sometimes our questions are maybe not directed at the correct witness and that we get to come back to whoever is best to answer that question. But that wraps up my questions for Mr. Peters. So thank you for your time. I have no more.
Okay, thank you, Ms. Davis. Ms. Garcia.
So much, Mr. Hearing Officer, and Member Trujillo Davis and I seem to be on the same wavelength. She asked a couple of questions exactly that I had, so I appreciate her line of questioning. I have just a couple of more, and one is that one of the witnesses yesterday might have been Dr. Sahu, suggested that regarding the EPA AP42 guideline, that it expressly indicated that AP42 emission factors should not be used to calculate PTE emissions, and that is exactly what the department did. So could Mr. Peters address that point?
I'm probably not the best person to answer that, as I after the emissions have been checked, I put them in the model.
Okay. All right. Well, let me go on to my next question then. And one of the witnesses yesterday, and I think it was Mr. Clark. Let's see. Now, I understand what you're saying is that the department tries to use the worst case scenario, and I can appreciate that. That makes complete sense. It sounds like good policy. Use the worst case scenario so that you have the most conservative situation, possible situation. Yes. Now, I think it was Mr. Clark that said that the data they used, if they were updating the Met data, used the airport monitor instead of the Runnels building and used a finer grid, that they actually came up with an exceedance. I think and I'm not sure whether this is annual or 24-hour or what it is, but they came up with 36.08 when the limit is 35. So that seems to me to be worst case scenario, more conservative. So I'm not sure if I'm comparing apples and oranges here. I may be completely wrong how I'm interpreting this. So feel free to correct me on how I'm looking at this.
But yeah, so I mean, a lot of things were said yesterday, and I'm going to go into detail on rebuttal on so many of them. So, but yeah, there were lots of things that I did not agree with that I heard yesterday, and I'm not sure. I'm not sure where to start.
So what you're saying then is they used different meteorological data. They used the airport monitor instead of the Runnels building. They used a finer grid. And so that seems very conservative to me, and even more worst case than what you did. Am I not looking at this right? Am I mixing apples and oranges here?
Yes. So I think I think I understand your question now, and so the goal is to produce the worst case, not the worst case. So the starting point is to find out what the worst case situation could be. Then you're allowed to be less overly conservative and get more realistic values. Your people are allowed to refine the model to get as realistic values as they want, as long as they're still not going to be exceeded. So if a lot of changes were made to the model, adding meteorological data that was from after when the modeling was submitted, using receptor spacing that's contrary to our guidelines, all of those things will increase concentrations, but that doesn't mean they're more accurate. And being higher isn't better, it's just higher. It's allowed for applicants to get as close to reality as they want to spend time and effort to refine the model. Does that make sense?
Yes, and I did hear you earlier say modeling is not designed to be accurate. It's designed to give the worst case, and that stuck in my brain. It's not designed to be accurate. It's designed to give worst case. So, yes. I think what you're saying, I think what I'm hearing you say is that yes, you want worst case, but within a realistic parameter. So they may have come up with worst case. But you're saying you wouldn't go that route because it's just beyond, not only beyond the requirements, but beyond, it's just too far out of being realistic.
Yeah. So ideally, applicants would refine their modeling enough so it doesn't look like they're at 99% of the air quality standard, because that scares everybody. Everyone thinks, oh, any tiny little thing and all of our health is going to be damaged. Whereas in reality, that's just when they stop refining the model, and because they're not required to get in as detailed as they need to make everyone feel safe.
Okay. Okay. Thank you very much. That's all my questions.
Ms. Sweeney.
Thank you, Mr. Hearing Officer, and thank you to the fellow board members for raising a lot of the questions I've been trying to process as well. And to go along with what Member Garcia was mentioning, I'm trying to get my head around as well, to use her metaphor, apples and oranges, if I'm comparing apples to oranges. But that said is, how can you explain more, Mr. Peters, on your perspective of how you said so it wouldn't with more detailed, it wouldn't necessarily mean that the model is more accurate. Can you elaborate that a little bit? Because in all my work, and I just, again, just to put this out there, when I'm modeling something, I'm able to refine a model more if I do have more data, so I can reduce the uncertainty of assumptions and inputs. So that's where I'm trying to get my head around. So if you could elaborate, that would be wonderful.
Yeah. So basically, the model was developed evidently using a 50-meter grid. And so if you refine the model to lower than what it was developed at, we don't know if it will certainly produce higher concentrations, but we don't know if those are reflected in reality. And
okay. And are you saying because that's a constraint of the model itself?
it's, well, basically there's certain milestones or certain data was used to develop the model, and certain intervals were used to compare those readings with the monitors that were used in development of the data. So if you use the same monitors and use tighter spacing than was used in the data, you would have to reduce the overall probability density function so it wouldn't produce such a high concentration. So if the grid spacing that was compared with the monitors, the monitor data, they put monitors surrounding a facility and compared the concentrations at each of those monitors based on wind speed or in general. So if when you develop the model, you use 50-meter spacing, if you instead used 10-meter spacing when you develop the model, you would get a different distribution of pollution to enter into the model. So we don't know that, so no evidence have I seen that you get more accurate concentrations by using tighter spacing because of the way that the model was, because of the database that the model was initially developed using.
Okay. So sorry to try to get my head around. So the basis of the model is assuming the 50 interval. And then since that's the basis of the model, to adjust that basis means maybe perhaps what you're saying is an inaccurate output if you adjust the interval without adjusting the model itself. Is that
Yeah,
correct?
yeah, that's what I'm trying to say.
Okay.
That yeah, you want to, if you base all your calculations on a certain amount of spacing, then you have to stick with that spacing, or your calculations will be inaccurate.
Okay. And just again, so I can form it in my head. So the analysis that you spoke about today and that NMED has done, and or the AAM is based on the model, the 50 interval model. And so are you saying because that model was that basis, what Mr. Sah or Dr. Sahu presented, it is comparing apples to oranges, to use my fellow board member's analogy?
Dr. Clark was the one that was using the smaller, the 10-meter receptor spacing.
I'm sorry, yeah.
And yeah, I'm saying it's comparing apples to oranges because, and is putting an additional requirement on people to use this different spacing that is not expressed anywhere in guidance or anything, and contrary to the development of the model.
Okay, well, thank you, Mr. Peters. I think get my head around that, and I may have one more question, but I'll let the other board members ask their questions.
Ms. Davis? I'm sorry, Ms. Davis? Okay,
I'll let Mr. Member Honker go first.
okay.
Okay, thank you. Yeah, I had a follow-up on Chair Sweeney's questioning. And that is, my understanding of modeling is they're either calibrated or verified for the way they're set up, which I assume would be the spacing of that you've been talking about. So my question, just to make sure I'm clear, so is it a matter that the model was not calibrated or verified to use this different spacing of data? Is that basically what you're saying?
I'm saying I don't have any evidence that it's been used for that spacing, and that I would want to see evidence before requiring people to do that.
Okay. But I guess what I'm asking, how critical was the spacing to the way that model was developed and calibrated? Not knowing of all the inputs that go into the model. I mean, how big a contribution does spacing make to the results you get?
I don't know the answer to that. I mean, yeah, think about, you've got an air pollution source, and then you've got a monitor, and you have to figure out, and you have to make equations to find out what the concentration will be. It's going to be hard to get a really refined sense of that because you're talking about pretty large distances. Your monitor isn't going to be 10 meters or 20 meters away from the source itself. It's got to travel a distance, so it's hard to say. And I don't know all the details of how this was done and the different, they use different equations for different meteorological conditions, but there's a lot of uncertainty in the model itself. They're already trying to produce the maximum possible prediction. So when you add additional requirements on top of that, such as refining the receptor spacing beyond what has historically been done, that's an additional requirement on applicants that we haven't seen any evidence to go forward with.
Okay, that's helpful. Thank you. Thank you, Mr. Peters.
Okay, and yes, Ms. Davis.
Yes, thank you for circling back to me. I had a couple more questions on the EPA guidance document. And I believe you mentioned that it was not legitimate guidance. Did I understand that correctly?
So yeah, so an EPA checklist was entered into evidence, and at the top of that guidance, it says this does not present new EPA guidance. It only refers to other guidance. So then when you go to the part that they highlighted, there was a parenthetical expression there, and that section says refer to the guideline for details on how this section in the checklist should read. So when you go and check the references, you'll find that there's no numbers there.
And was this the document, and I apologize for not having it right up in front of me, but the one that was issued because the EPA was concerned that AP 42 is not being used correctly?
No, this is a EPA checklist that
Okay.
is supposedly there to determine how to set up models.
Okay, great, good, because my questions are actually on that that document that EPA had sent out as a warning. So my question was just, when you receive any sort of document like that from the EPA that says, hey, we don't think this is being used correctly, is there any process you have that you look at as the NMED, that you look at the models coming in and say, you know, is this a concern here? Are we heeding this warning?
I don't know the answer to that. That sounds more like a permit. Well, the that goes back to the calculation of AP 42. I mean, that specific document, and I just use the results of the permit writer's assessment of the concentrations to put into the model. But in general, when we get guidance, we will evaluate it. And I mean, in our modeling guidelines, we try to be very transparent and update all the requirements whenever we can, so that everyone, if someone finds a new way to do modeling, we make that available so everyone has access to that information. But I can really only talk about the modeling part.
Okay, thank you, Mr. Peters. Then my next question is actually probably for Mr. V. Hill. I was curious, Mr. V. Hill, See there? Oh, there you are. So earlier we heard from Miss Prim, I believe was her name, and she does the processes the permits, and Mr. Peters does the modeling. So I'm curious, is there another witness coming up, or who can answer questions about the actual numbers in AP 42 and some of those questions?
Yeah, thank you, Member Davis. What I had proposed was that, and it's subject to the hearing officer's discretion and, the positions of the party, but from the department's perspective, we have one more witness that's going to address what I understand to be the brief opacity issue that was raised yesterday. And then if everyone is in agreement, and we certainly are okay with doing that, then all three of the witnesses can sit, or both of our witnesses could sit, because earlier I said the other witness wouldn't sit for substantive cross-examination. It's a long answer, but when we're done with our other witness, we are happy to have Mr. Peters and Ms. Prim sit as a panel to answer. That way you can ask whatever questions you want, and I personally think it's perfectly appropriate since you are the decision makers ultimately.
Well, I believe we've asked a couple of questions about AP 42 specifically. One being available standards, another just that I had just asked, and Mr. Peters said he wasn't the correct person to answer those questions. So is your third witness the correct person to answer those questions?
No, the correct witness would be Ms. Prim.
Okay. All right. We'll come back to that, but thank you. I don't have any more questions.
Ms. Garcia.
Thank you. One more question for clarification. The petitioners, one of the things that they brought up was that the airport monitor, which is closer to this proposed plant site, would be more appropriate to use. I don't know if I would say more accurate, but would be more appropriate to use. So I want to ask Mr. Peters, why was the Runnels building monitor data used rather than the airport monitor?
Yes, so there's a two-part answer. The second part is that it's not necessarily more appropriate because EPA guidelines say that monitors should not include both the explicitly modeled sources and the background. So in other words, if a monitor is very close to the facility, it's picking up, and those facilities exist, then it's picking up concentrations that you're explicitly putting in the model. So that doesn't mean that because airport is closer to the facility, that doesn't mean it's better. So that's part two. And part one is a mistake was made, and that I was not aware at the time that the airport actually had data that satisfied EPA's requirements. So I didn't even know that it existed at the time. I thought that the airport had a different type of monitor than EPA allowed. So yeah, I did not know that it existed, and so I never considered it.
Okay, so now that you know it existed and could be used, have you run it with that data to see what the difference is?
Dr. Clark did, and I will analyze that in rebuttal.
Okay, all right. Thank you very much. That's all.
Ms. Sweeney.
Thank you, Mr. Hearing Officer. Thank you again, Mr. Peterson. And you might address this in rebuttal, just to follow up to Member Garcia's question. On your comment to her question that using the monitor by the airport was not more appropriate, because it is close to the facility and it might be picking up, you know, air quality from the facility. Do you know if there's any guidance, whether from EPA or if NMED has guidance as to what air monitors should be used, and in relation to your statement that you just shared with us?
I think the EPA guidance is pretty general. It just says that don't double count your emissions in your model sources and your monitoring. And so then EPA leaves a lot of stuff up to local agencies to make decisions on how to address situations where you have limited data, or where sources are close to the monitor. But the purpose of a monitor is a background concentration, which that basically our monitors, most of the monitors that the department operates are population monitors. So they, I mean, the Santa Fe monitors are population monitors. They're not background monitors. So they're probably picking up some things that might not be considered as background in any of these monitors, where the model explicitly models all of the sources in the area, and then the background is supposed to be representative of background conditions.
Yeah,
Answer feels like it's not making sense because I keep saying the word background and to define background.
yeah, I mean, I think also, just again, to get my head around this. So are you, with your answer, are you saying that the monitor isn't a background monitor? It wouldn't be appropriate to use that monitor as a background monitor in general?
I mean, yeah, it depends on, so the airport monitor certainly picks up emissions from the facility that's been explicitly modeled. And the Runnels building monitor would pick up less of those emissions, but it still might be picking up some emissions. It's hard to say. We obviously have to use the limited monitoring equipment that's available. So we use what we can, and then find ways to adjust the model if there's some inappropriate combination.
Thank you for that, Mr. Peters. And I guess my follow-up question is, does, you mentioned there was the EPA guidance of don't double count. So does NMED have guidance or criteria, you said at the local level, that might be applicable in this situation, where you could say, okay, we determined that is there a process that NMED or guidance that NMED is following?
Yes. So I don't know if it's written guidance or not, but historically what we've done is, if a monitor is close to a source, you model the sources, you put one receptor at the monitor and then run the sources that exist, and the concentration at the monitor, that's the amount that you subtract from the monitored, the total monitored concentration before you add it back into the model.
Thank you, Mr. Peters. I I think that's all the questions I have for now, maybe at the panel. So it'll be more efficient that way. Thank you again, and thank you, Mr. Hearing Officer.
Thank you.
Are there any further questions from board members? Mr. Cates?
Yeah, so to pull it back out of the weeds a little bit here, Mr. Peters, so there's a monitor at the airport, right? Where's this other monitor?
Are you familiar with the Reynolds building?
I guess not.
Okay, it's basically near downtown Santa Fe.
Oh, way over there.
It's near Trader
so-
Joe's, across the street from Trader Joe's.
Okay, and that picks up a reading off of this plant?
Well, I don't know. The airport monitor does. And I haven't.
Okay, so I was asking earlier which way the wind blows out there. It's mostly westerly and southerly, right? Is that do you know?
So my job is to evaluate all wind directions and find out what the worst concentration is, no matter what direction it is.
Okay.
So I saw some extra sorry, the echoing is confusing.
Well, I asked because we're talking about, as I understand, we're talking about whether the permit was issued properly along emissions guidelines. It's not about citing it specifically, but that is the subcontext. The lawyers for the environmental organization, they purport to represent the surrounding community, which is mostly to the south. That the wind blows primarily to the north and to the east. Then it's that would seem that factors into my thinking. So that's why I'm asking about it. That's all.
Yeah, I saw extra winds from the north, extra winds from the southeast, and extra winds from the southwest, compared to just a general average wind. But like I said, I evaluated all of the wind directions in the modeling.
Yeah. Okay. All right. Thank you. Thank you very much. Thanks for answering the questions there. Appreciate it.
Thank you.
Ms. Sweeney?
Apologize, hearing officer. I have follow-up question to Mr. Cates' line of questioning, and sorry about that, Mr. Peters. I don't want to forget this since you just mentioned it. So you're saying that you evaluated all wind patterns. Is that in the model or in the evaluation and determination of not to use the data? Maybe of not to recommend the use of and reliance on the data from the airport monitor?
So for the meteorological data, we used the airport data, and that data includes 8,760 hours per year of wind directions. So every hour of the year has a wind direction and associated speeds and other conditions. And so we model every condition that happens all year and then predict the worst concentration from all combinations of those directions. Now the background concentration is separate from the meteorology in that basically that's just you select one monitor and you add that background concentration to the modeled concentrations. Did that answer the question?
Well, all I was wondering, and maybe I asked a very long question. So, did a wind analysis, like, did the directions of the wind go into your determination of whether, and we may hear this in rebuttal, so I apologize, in not reliance on the air monitoring data from the airport?
The decision to use a monitor in general would be independent of wind direction, but it is possible to make refined background concentrations based on what direction the wind is blowing. Nobody did that in this permitting action, but you can correlate wind direction with monitored concentrations. So if the wind is blowing from Santa Fe toward the facility, it would have higher concentrations than if it was blowing in the opposite direction.
Okay. Well, thank you so much, Mr. Peters, and that's all I have for now, Mr.
Yeah.
Hearing Officer.
Thank you.
Are there any other questions from board members? Okay, hearing and seeing none. Mr. Vigil, it's we turned over to you for redirect.
I have no redirect. Thank you.
Okay, there being no redirect, was it your intention to call your additional witness at this point, Mr. Feather?
Yes, I'll call Mr. Feather.
Okay.
Mr. Feather's up on the screen now.
Let me see.
Yes, I'm here, sir.
Okay. Mr. Feather, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Could you please state your name for the record?
David Feather.
Could you spell your last name, David?
F as in Frank, E-A-T-H-E-R.
Thank you. And where are you currently employed?
I'm employed by the New Mexico Environment Department Air Quality Bureau.
And what is your job title?
I'm the permitting section chief of the permitting section.
And how long have you worked in the permitting section?
I just started here in February this month. Previously worked in compliance enforcement section of the NMED Air Quality Bureau as both a compliance inspector for 2 years and compliance reporting manager for a year and a half.
And could you briefly describe your educational background?
I have a bachelor's of science and a master's of science.
And what other qualifications do you have with regard to the subject of your testimony today?
I've attended and been certified in EPA Reference Method 9, which also includes a classroom portion that educates one on the requirements of Reference Method 22. They're both visual emissions inspections. I worked in the oil and gas segment for over 10 years, implementing and conducting inspections at gas plants, compressor stations, and tank batteries for both Reference Method 22 inspections of flares and OVA inspections of tanks, flares, closed vent systems, and associated piping.
And you submitted a resume, and that is NMED Exhibit 28, is that correct?
Yes.
Okay, thank you so much. Mr. Hearing Officer, Madam Chair, members of the board, I offer Mr. Feather as a witness limited to Member Davis's questions, and I also offer Exhibit 28 for inclusion into the record.
I believe I already admitted Exhibit 28.
Okay.
So it's already admitted to evidence. And is there any objection to Mr. Feather testifying on the subjects he is proposing to address? Hearing no objection, he'll be allowed to proceed.
Oh, thank you. Mr. Feather, what is an EPA reference method 22 inspection?
EPA reference method 22 is a method for determining the frequency of fugitive emissions from stationary sources. The method is also applicable for determining the frequency of visible smoke emissions from flares. The method determines the amount of time visible emissions occur over the observation period. The method does not determine the opacity of the emissions. No observer certification is required to perform the inspection, but the observer must be knowledgeable with respect to general procedures for determining the presence of visible emissions.
And what is an OVA inspection? I just want to say that's O as in Oliver, V as in Victory, A as in Athena. What is an OVA inspection?
It's an olfactory, which is smelling, visual, which is seeing, and auditory is hearing inspection for defects that could result in air emissions. These inspections are used to detect defects, cracks, holes, gaps in covers, defective or damaged seals or gaskets, missing or broken hatches, access covers, caps, and other mechanical integrity issues with piping, tanks, and closed vent systems. This inspection method is generally used in oil and gas segments to comply with NSPS Quad O and NSPS Quad OA for potential VOC fugitive emissions.
Okay, thank you, Mr. Feather. I have no further questions, and Mr. Feather can sit for questions from the board for cross-examination from the parties and the public.
Okay, does the petitioner have any cross-examination for Mr. Feather?
Yes, Mr. Hearing Officer, I have a couple of quick questions. So Mr. Feather, nice to meet you. My name is Eric Jantz. I'm a senior staff attorney at the New Mexico Environmental Law Center here representing community folks. Did I hear you right and say that method 22 doesn't require opacity evaluation?
That's correct. It's just a simple determination of whether there's a visible emission or not.
Oh, okay. But method 9 does allow for opacity evaluation.
Correct. It judges the opacity, and that requires a certification.
Okay. And in your experience, does under method 9, the opacity, making an opacity determination, is there a way to translate that into micrograms per meter squared, or is it just 20%, 10%, 5%?
It's just the percentage, sir. It has, based on that visible emission, you cannot quantify.
Okay, thank you. That's all I have.
Are there questions from members of the public? Okay, hearing none and seeing none, we will go to questions of Mr. Feather from board members. Ms. Davis.
Thank you. And I want to thank the NMED for answering our questions so thoroughly, and also for having Mr. Feather show up today and take time out of his day to come answer some of these extra questions we had. So I just, first of all, thank you for clearing that up. I want to make sure I understand. So AVOs only tied to Quad O, oil field alone, and method 22 similar in nature as far as a visual, but not considered an AVO?
The visual part of the AVO inspection is looking for staining for liquids, etc., around the piping or whatever vessel it may be. It's totally different from method 22. Method 22 is looking at an actual visual emission. Gases typically are not easily seen with the naked eye.
Okay, great. Thank you. I really appreciate you answering that for me. I don't believe I have any more on that.
Any other board members have questions? Mr. Vigil, any redirect?
I have no redirect. Mr. Hearing Officer, now maybe this is the appropriate time to offer Kathy Prim for further questioning by members of the board, if that's appropriate. There seemed to have been, I mean, we can always wait, but I just want to be sure that they get their questions answered.
Do the petitioners have a position on that?
Mr. Hearing Officer, I don't believe we have any objection to that if they want to sit together to answer questions within the scope of what we're talking about right now.
Okay, Mr. Veal, I didn't hear you mention Mr. Peters. Were you intending that Mr. Peters and Ms. Prim will sit together?
Yeah, they can sit together. I'm sorry. Yeah, and maybe we can go back to Ms. Locke again to see if there's any objections for Mr. Peters joining her.
Ms. Locke, any objection?
No objection. I thought Mr. Vigil had presented it as if they would sit as a panel, so I just thought that
Yeah,
was what was.
that was my understanding. So we'll allow Ms. Prim and Mr. Peters to testify as a panel for the purpose of answering questions from board members.
And sorry to interrupt, Mr. Hearing Officer, but just to clarify, this is all within the scope of their original direct testimony, right?
These are in the nature of clarify, as I understand it, and I'm going to limit this unless the board members, present a reason for expanding it, for purposes of clarifying their previous testimony.
Okay.
All questions on questions that were previously asked. And they've both been sworn, so we can do. You know what I think we're going to do? Let's just do a break right now. Let's do a 15-minute break, and we'll start with the questions from board members at 3:15. I see that we have Mr. Peters. Do we have Ms. Prim also?
Yes, Mr. Hearing Officer, I'm here.
Okay. Okay, and I see we have Mr. Peters. So we're going to turn to questions from the board members of the NMED witnesses for purposes of clarification of answers to prior questions and following up on questions that the witnesses felt should have been directed to one of the other witnesses. So we have a board member. I see Ms. Garcia has questions, so we'll start with her.
Thank you, Mr. Hearing Officer. And thank you, Ms. Prim, for being here to answer hopefully answer this question. I did ask this of Mr. Peters, and he said he was not the right person, so let me try you. One of the things the petitioners brought up, and I think this was particularly Dr. Sahu, but they made a point of bringing up that the EPA expressly indicated that AP 42 emission factors, and I think this was an enforcement alert, that the AP 42 emission factors should not be used to calculate PTE emissions, but that is exactly what the department did. So have I got that wrong? Can you address that, please?
Sure, I'll speak to this in my rebuttal as well. But potential to emit is the maximum. Let me pull up so I get the correct citation definition for you. Let's see. Okay, so PTE stands for potential to emit, and it means the maximum capacity of a stationary source to emit any air pollutant under its physical and operational design. So as I said in my direct testimony, the general equation for calculating emissions, or the PTE, is the activity rate or the capacity of the equipment multiplied by the emission factor. So using an emission factor that's approved, department approved, and multiplying it by the maximum throughput allowed for that piece of equipment gives you the PTE. And that's what we did with this application, with the emissions calculations.
But what about the point that the EPA enforcement alert said not to use AP 42 emission factors for the calculation of PTE, potential to emit?
So I hear what the board is seeking, and I've been looking online throughout the day while the hearing is proceeding, and I have found evidence of an emission assessment report for hot mix asphalt emission factors that was done by the EPA. It's dated in 2000. And I can read from that if you would like me to, just to give a more detailed understanding of the extent of evaluation that goes into these factors.
Mr. Hearing Officer, petitioners would object to this. We don't have any context of what Ms. Prim is looking at. It hasn't been offered beforehand for our inspection. If Ms. Prim wants to testify about that, petitioners ought to have the opportunity to at least review the document.
The department really doesn't have a position on the objection. I would suggest that maybe Ms. Prim could put it up on the screen. Maybe that would satisfy Mr. Jance's objection. But other than that, we don't have a position on the objection. You're muted, Mr. Jance.
Thank you.
Sorry.
So I was just about to say, Mr. Hearing Officer, that I don't think that would assuage our concerns because we don't have the ability to run it by our experts if it's just shared on the screen. And give them the opportunity to take a look at it and review it.
Okay. Mr. Jans, could you please state more specifically, or as best you can, what the objection is? I'm sorry, I didn't hear the specific basis for it. You're muted. I can't.
Yeah, my apologies,
Yeah.
Mr. Hearing Officer and members of the board. It's late in the day. In any event, our objection is basically a due process objection in the sense that we don't know what Ms. Prim, we don't know what the document Ms. Prim is referring to is. Our experts haven't had the opportunity to review it. The Environment Department didn't provide it to us beforehand. So the ability for us to respond in any way or critique Ms. Prim's testimony on it is deprived.
Okay, I'm going to let her testify on this and respond to the question. And subject to, or taking into consideration your objection, Mr. Jantz, and those factors will be considered by me and by the board in terms of deciding how much weight to give the testimony. But I think for purposes of trying to get as much information in the record as we can in response to board members' questions, it's going to be let in. You can proceed, Ms. Prim.
Okay, thank you, Mr. Hearing Officer, Madam Chair, members of the board. First of all, I want to circle back, Member Garcia. This point about PTE was raised by Dr. Sahu. He does express his concerns about AP42 factors being expressly unsuitable for calculating PTE in his report, but I'm not confident that that's actually in the alert itself. So I want to preface it with that. I'm not sure that that's actually, if he cited that in the report. I think that's a statement from him. But aside from that, AP42 is essentially the only available factors for asphalt plants and is used universally by air agencies. And the alert from EPA provides no guidance on how emission factors for asphalt plants or crushers should be adjusted. So I'm going to go to this report now that I told you about, the final EPA emissions assessment report. It's dated December 2000 for hot mix asphalt plants. This report presents an assessment of emissions from hot mix asphalt manufacturing facilities. Included in this report is a description of the manufacturing process and the emissions associated with HMA production, the procedures for developing emissions factors and emission inventories for the HMA industry, and estimated annual emissions for typical HMA facilities. This report was proposed as part of a project to evaluate air emissions from HMA plants. This project included the analysis of over 300 emissions tests collected from state and local air pollution control agency files to improve the AP42 emissions factors. In addition, the study included 4 EPA-funded emissions tests to characterize kiln stack emissions or fugitive emissions from silo filling or transport truck loading. A number of stakeholders provided input to this study, including national and state legislators, state and local health agencies, state and local air pollution control agencies, citizen groups, and industry associations. These stakeholders suggested new emission estimation methodologies, provided input on the selection of facilities for emissions testing, commented on the draft test reports, and provided suggestions for analysis of the data to develop emission factors. The EA report and the AP 42 section development were reviewed by stakeholders. Comments on the EA report body, Appendix A and Appendix B, were considered in preparing the final EA report, the AP 42 section and background report. So it goes on. I guess the point that I'm trying to make is that these emission factors are not just willy-nilly made up factors. There's a lot of data that goes into them, a lot of review, a lot of input. They're provided by the EPA. And until we have further guidance about how to adjust the factors, or until we are provided with new emission factors that are more reliable, this is what we have to use. And even in the alert itself, as I pointed out earlier with Mr. Jantz, at the bottom of page 3 and under the bullet for emission factors, it says when source specific emissions or other more reliable approaches are unavailable, AP 42 emission factors may be the only way to estimate emissions.
Very much, Ms. Prem. I appreciate that answer. I guess I'm left with, I hear what you're saying, that it's your understanding that those are the only factors that you're able to use at this point. However, I do have in my notes, and I know that Dr. Sahu put up the enforcement alert on the screen, and I remember them pointing to the place that said not to use emission factors, or cautioning not to use emission factors to calculate PTE. So I'm left confused about this point. And so I would appreciate either the petitioners to have an opportunity to correct me if I'm wrong about this. I think that was their point. And if I have it wrong, maybe somebody can correct me, but I would like to understand, did the department go against the EPA enforcement alert?
I'm sorry, Member Garcia, it sounded like you were addressing petitioners, but I'm not sure if you're.
Yeah, I'm sorry. I'm not, yeah, I guess I'm Mr. Hearing Officer, I'm not sure who can answer this question, but do you understand what I'm trying to get at?
Yes, I do. I'm going to ask Mr. Jantz if this is something the petitioners can address in their rebuttal testimony.
Actually, two things, Mr. Hearing Officer. One, I'd appreciate it if the department would share the document Ms. Prim is referring to with us, so that we know exactly what she's talking about. Second thing is I think that Dr. Sahu is the best person to address the issue of the misuse of AP 42 standards when other data, for example, actual stack emissions that could have been gathered weren't. But he won't be available until tomorrow morning. So, I don't have a sense of how long we'll go. It sounds like we may go into tomorrow. And if that's the case, we'd like to allow Dr. Sahu to address that question in more detail.
Okay, I have a feeling we are going to need to go into tomorrow, but I was going to leave that up to the board members in terms of, and we can address that now since it's come up, how late you would like to go this evening in order to try and wrap up the hearing. It's looking like that's not practical at this point, and particularly in light of this last question that's come up. And then we'll need to go tomorrow anyway. Can the board members give me a sense of your thinking on that approach at this point? Do you want to try and go late tonight and cover as much as we can, or just get through what we can and cut off, come back tomorrow and finish up on the rebuttal testimony, including Dr. Sanu. Ms. Garcia?
Yes, thank you, Mr. Hearing Officer. And I certainly don't want to drag this on any further just because of my question. Certainly not. I think that my question could probably be answered in post-hearing submittals. Perhaps maybe the petitioner could address it in that manner. I'm perfectly satisfied with it getting answered in another way. My feeling is if we could finish today, that would be wonderful. So I don't want my question to cause us to go into tomorrow at all. So thank you.
Okay. Ms. Swaina?
Thank
Ms.
you, Mr. Hearing Officer, and thank you for your response, Member Garcia. I know, you know, we had it, this hearing potentially to go into tomorrow. And I understand that, you know, a couple of days is hard at everybody's schedule. That said, personally, I would really like to hear what Mr. or Dr. Sahus and the petitioner's response and some of the rebuttals, given some of the questions that are floating around in my head. And that's just my 2 cents on and I'm willing to, I know it's hard on all our schedules, but I'm willing to be here tomorrow as well. Just wanted to share that.
Are there any other? Yes, Ms. Davis.
I want to second some of Chair Sweena's sentiments there. I think that this is an important point that Member Garcia brought up, and I have a few additional follow-up questions to it as well. And if she doesn't get to them in her own line of questioning there, but I would also like to see where this goes, as we have the people gathered right now, and we did set aside the time.
Okay, any other comments at this point from board members? Okay, let's proceed. It looks to me like we're going to need to come back tomorrow for Dr. Sanu's testimony on this one point that's been requested. Let's just keep going today and get as far as we can, get a sense of where we are after we hear public comment at 5, and make a decision at that point in time as to how late to go tonight, as opposed to whether we should just stop this evening and come back and finish up tomorrow, regardless of where we are after the public comment. So let's proceed with, for now, let's proceed with board members' comments. Ms. Garcia, did you have more questions?
Oh, sir, that's all I had. Thank you.
Okay. Ms. Sweena?
Thank you, Mr. Hearing Officer, and thank you, Ms. Prim and Mr. Peters again for sharing with us your expertise and insight. So just to some follow-up questions, I think this would be for Ms. Prim. So I just want to be clear in my notes, and the alert happened in 2020. So am I clear or accurate in saying that since 2020, when the alert came out, the permitting process and application and that what you go through for the department has not been adjusted to address some of the issues brought up in the alert? Is that accurate?
Right. So the alert is not, it's an enforcement alert. It's not guidance. It's almost geared more toward the permittee, saying if you if your emissions calculations are based on averages, then you could be out of compliance, and that's a danger to you. Repetitively, it mentions being subject to enforcement and subject to penalties, and that's correct. If it turns out that the calculations that they've done based on AP42 factors are not accurate, and if reports show that they are out of compliance, then it would be an enforcement issue. And we do have an enforcement section that would work on penalties and violations for violating the emission standards, the emission rates that are in their permit.
Thank you, Ms. Prim. So with that explanation, just so I can clarify in my head, so you're saying it would be after the permit process and all of what goes through the approval of a permit, and it would be on the follow-up on enforcement, that this would be something that comes up to the permittee, letting the permittee know, like, hey, you might be out of compliance, and to your statement earlier, it's more like an alert to the permittee. Is that accurate?
So these AP42 emission factors, specifically for hot mix asphalt and for crushers, these are the best available tool that we have to calculate emissions. So that's what the applicant has done, and that's what we have verified. We verified that they did the calculations correctly using the best available emission factors, which are from AP42 and which are allowed. This alert is not a mandate. It's not a regulation saying you cannot use these factors. In fact, it says when other more reliable approaches are unavailable, these may be the only way to estimate emissions. So that's what we've done. And then the calculations are used to set up emission limits in the permit. And then there are monitoring, record keeping, testing, reporting requirements within the permit that enable the permittee to demonstrate compliance with the standards and with the emission rates in their permit. So if it turns out that the tests and reports that they have to do per the requirements of the permit indicate that they are out of compliance, then it becomes an enforcement issue.
Thank you for that. And I just want to clarify, because as I read the beginning sentence in the alert, it says the purpose of this enforcement alert is to remind permitting agencies, consultants, and regulated entities. And so I guess, I just want to get my head around too, if this is alerting us in 2020, is there a mechanism, is there a process that NMED has where they can, if it is only AP42 that the current permitting process is dependent upon, is there a way to adjust that and to ensure and take this into consideration? Or can you explain to me, is there another process that needs to happen in order for the permitting process to address the alert?
Yeah, those are good questions. I think that the alert in itself, it's an enforcement alert. It is something that we need to be aware of, and permittees need to be aware of it. But without other information or other reliable approaches for estimating their initial calculations, this is what we have. And there's this on page 3 of the alert, there's the breakdown of the the order of accuracy that Mr. Jantz went through with me. If an applicant provided layers of information, I would use the most accurate on that list that is available, that they provided, that they have, that exists. In this case, the only thing that I had to go on was the emission factors from AP 42. That's all that was provided, and their department approved emission factors. So within an individual permitting action, this is sort of a broader scope that, you know, it speaks more to policies or perhaps even regulations, perhaps even considering new rules that incorporate new information. But within a single permitting action, and by the way, this is in my rebuttal, but I'll bring it up a little bit right now. So this alert is dated November 2020. This application was received by the department on November 26, 2019. So that's another thing to consider. This public hearing that was held in March of 2021 was initially slated to be held in May of 2020, prior to the date on this alert. So that's another thing to consider. It's complex. We certainly do try to take in all the information that we can, and assess calculations, assess emissions, assess modeling to the best of our ability with the best information that we have available at that time.
And thank you for that, Ms. Prim, and it helps to understand the timeline as well that you just explained regarding the alert coming out when the permits were considered and processed, and the whole timing. And I know COVID is probably part of the delay in addressing this issue as well. So I appreciate that. For right now, I'll let the other board members ask their questions if they have any. Thank you for now.
Thank you, Madam Chair.
Mr. Honker.
Yes, and I apologize that I missed part of the session yesterday, but could someone tell me where I can find this enforcement alert in the documents and the record? I haven't been able to find it.
It is one of the petitioner's exhibits, so I'll let the petitioners speak to that.
That's right. I think Mr. Jantz or Ms. Locke can give us that. Sorry to put you on the spot.
Yeah, it might take me a minute to find it, but I'll let you know here in a second if that's okay.
If I recall correctly, it was rebuttal exhibit 2 at the hearing below, the first hearing.
I believe that is correct.
Probably why member Honker can't find it, because it was an exhibit from the lower hearing, and I don't think it ever got formally admitted as an exhibit in this hearing.
It did, Mr. Hearing Officer, when we admitted the entire hearing record from below.
Okay, so which one was it then? Oh, it was part of the record. Yeah, I meant admitted separately. It was admitted as part of the record below, but it was not separately introduced and admitted at this hearing.
And I'm sorry, Mr. Hearing Officer, it was Community Rebuttal Exhibit 1 from the hearing below.
Would it be appropriate and helpful for this document to be put up on the screen?
I don't know if we have more questions on it at this point or not. Mr. Honker, did you want to?
Well, I'm still not sure where to look for it. Is it in the? I'm looking at the Docketed Matters website, and you know, the items, the menu there, and I'm trying to figure out, is it in the administrative record dated 9/24/2021, or is it elsewhere in this list?
Mr. Hearing Officer and Member Honker, how I was able to locate it is it was a reference in Dr. Sahu's report
Okay.
that is in it's labeled final Sahu report, and it's on page 7. There's a link in there, and also in Dr. Sahu's report there's excerpts of the alert.
Okay, I'll look for it there. I would say go on and I'll let everybody know if I can't find it.
Okay, thank you. Other questions from board members of either panelists?
Just a quick point, Mr. Hearing Officer, I would love for Mr. Honker to take a look at that. I was so hoping he was here yesterday because his background is EPA, and I think it would be important for him to be able to take a look at that and opine on this particular issue. So I appreciate that he's here to do that today.
Okay, well, Mr. Honker, be sure to let us know if you can't find it. We'll figure out a way to get it to you. I have no doubt it's going to come up in the rebuttal phase. Ms. Sweeney.
Yes, if none of the other board members have any questions, maybe I can ask a few more. I was just hoping to spread the wealth of the questions, but while Mr. Honker is looking for that reference. So this would be again, either Ms. Prim or Mr. Peters. So if we're based, is there any, Ms. Prim, you've testified that there's AP 42 is the only process that the department leans on to evaluate for the permitting process of these types of facilities. Is that correct?
Yes, thank you, Madam Chair. For hot mix asphalt plants and crushers, these are the factors that we use. This is what's available.
Okay, and then and maybe this is for Mr. Peters, is because of the emissions and some of the data into the models are modeled, and you provided testimony on there. Is there any other, from a technical standpoint, is there any way to adjust or account for additional data within the models that NMED uses and that potential permittees use?
Yeah, that's a interesting question. The model would, it's possible to scale modeling results in some certain limited situations, but in general, no, you would not adjust the model to, basically the emission rate is a basic input into the model. And so you rely on other things to verify the emission rate, such as testing.
And so the current models, maybe I'll ask a different, and maybe you've answered this before, in the current models and framework that NMED uses, is there a mechanism to include and look at more current data and information?
The model can always be, you can always change the input parameters and rerun the model, and you can always add new data and rerun the model in the regular permitting process. Some of that happens during the application review phase. For example, in this permit, I found some potential exceedances within nearby properties that I drew to the attention of the of the consultant. And he addressed those and then resubmitted the new modeling and new evidence to show that he's in compliance with standards. So we did some of that, but the practice would not be to take data that did not exist until after the permit application was submitted and rerun everything, because then when does that end? When do you have enough data to issue the permit? Basically, we assume that the information that exists at the time of the permit application delivery is the information that can be used for evaluating the compliance with air quality standards.
Thank you, Mr. Peters. And so I guess my next question probably goes back to Ms. Prim is in your written testimony, it said you stated if emission limits based on initial calculations using AP 42 emission factors are inaccurate, a permit revision may be required. What would that process be in regards to this particular situation if that was determined?
Right. Thank you, Madam Chair. That's a great question. As I was saying earlier, if the limits that are set in the permit are not complied with by the permittee, then it would become an enforcement violation. It would become an enforcement action that would be handled by our enforcement section.
Thank you for that answer. And so my follow-up question would be, will we then still be, what does that enforcement action entail? Would it entail more modeling as, you know, to maybe adjust the limits, or, and if it indeed does have more modeling, would we be back in the position here we are today, relying on AP 42?
Yeah, you have excellent questions, Madam Chair. So yeah, if there was a violation, there could be an enforcement action, and part of that action could be a requirement to revise the permit to reflect more accurate data, more accurate emissions evaluations. So at that point, if it was a significant revision that was required by an enforcement action, then they would have to do modeling again to demonstrate compliance with the standards. If any standards had been updated, those would be part of the new model analysis. So it would be an entire new process of reviewing an entire new application.
But, and maybe a follow-up, so in the meantime, though, the facility would still be operating?
That's a good question for compliance and enforcement. I think it depends. I think I'm not in the compliance and enforcement section, but I think that ceasing operations could potentially be part of the penalty for a violation.
Thank you for that, Ms. Prim and Mr. Peters. And I'm sure additional questions will come up during your rebuttal testimony as well, but I appreciate that.
Thank you, Madam Chair.
Ms. Davis.
Thank you. And I just want to build on some of Chair Sweena's questions there. I'm curious, you've mentioned that a facility could end up in enforcement actions if it hasn't been modeled properly, and that kind of goes back to that enforcement alert. So what I'm curious about is how does a facility get to the place where they're in enforcement actions? And particularly what I'm talking about is there was a accusation made yesterday that the permit did not include any regular submissions of the method 22, that it was only required at the startup of the permit, and that no inspections were required once the facility was commissioned. So I'm curious, was that accurate?
No, that's not accurate. There are initial compliance tests that are required in the permit. But there are also ongoing requirements for visible emissions checks, opacity checks, method 9, as well as federal regulation requirements through 40 CFR 60 subpart I for the asphalt equipment and 40 CFR 60 subpart, it's called triple O, so OOO for the crusher equipment. So there are ongoing requirements. It's not simply the initial compliance tests and that's it. There are also data loggers that are continuously, that are required to continuously operate to record data. There are requirements for temperature recording that's ongoing. Temperature is really important with asphalt because the temperature has a lot to do with how many fumes are released. So I don't agree with that assessment that it's just a couple of initial compliance tests and then that's it. The permit has a lot of requirements in it for testing, monitoring, record keeping, reporting that are ongoing. And Vice Chair Davis, while I have you, if this is an appropriate time, earlier I told you I would get back to you with the citation for that comparison of the different throughputs, the old permits compared to the new permit. So just to get it into the record, that table is available in the statement of basis, like I said, which is in the administrative record index 2 at Bates 000324, in case you'd like to look at that table more closely.
Thank you. And I did catch all of that. So thank you very much. I don't have any more questions.
I know moms can multitask. I know.
Yeah, she bumped her head and the whole thing fell apart here. Thank you.
Thank you, Vice Chair.
Mr. Honker.
Yes, and thanks to Chair Sweeney and others. I have found the enforcement alert and have read that. And I note that that comes out of EPA's Office of Enforcement and Compliance Assurance, which does not set permitting policy for the agency. My experience, when the enforcement office raises an issue like this, the permitting office usually takes that under advisement and makes any necessary changes or appropriate changes to permitting rules and guidance. So, Ms. Prim, are you aware of any new rules or guidance that have come out of EPA's air permitting office as a result of this enforcement alert at this point?
No, I haven't seen any changes. Like I was saying earlier, it's not mandated. I haven't seen any changes to the regulations based on this alert.
Okay, thank you.
Thank you, Member Honker.
Do you have any additional questions from board members to the panel? Okay, hearing no further questions, that puts us to the rebuttal phase of testimony. Mr. Vigil, are you ready to present the department's rebuttal?
Yes, of course. So give me a second. I for some reason I thought that the permittees were going. I'm sorry, the petitioners were going to go, but I can be ready in about 30 seconds.
Okay.
Our first rebuttal witness will be Ms. Prim. Okay. So the first page of the community statement of intent, or SOI, I'll be calling it SOI, for today's hearing refers to the department's failure to adequately address community comments and concerns related to the permitting of the facility. Could you respond to this concern?
Yes, 20.1.4.400.A1 NMAC states, the division has the burden of proof for a challenged condition of a permit or license which the department has proposed. During the March 2021 hearing, the Bureau provided extensive testimony for every challenged condition of draft permit 8585 and made improvements to some draft permit 8585 conditions based on input provided by citizens expert witnesses in the community's statement of intent for that hearing. Pages 3 to 7 of Ted Schooley's pre-filed written rebuttal testimony, which was NMED amended Exhibit 9, outlined the improvements made to the March 22nd, 2021 version of draft permit 8585, which was filed by the department as Exhibit 12 on March 22nd, 2021. That March 22nd version of the draft permit was the final version of the permit that was signed and issued by the Bureau as permit 8585.
What version of the permit does Mr. Schneider refer to in his report submitted with the petitioner's statement of intent as Community EIB Exhibit 10 for the hearing we're in now?
Page 19 of Mr. Schneider's report refers to the February 4th, 2021 version of the permit when he states, the permit is incomplete and fails to address our concerns. His proposed edits beginning on page 22 of his report also appear to be based on an outdated version of the draft permit rather than the final issued permit 8585. For example, on page 22 of his report, he states the permit should be amended to include an hourly allowable asphalt fumes limit. Though there are hourly allowable asphalt fumes limits in condition 106A106B of permit 8585. Another example from page 23 of his report states condition A110B should define what constitutes commercial pipeline natural gas as the fuel sulfur content. Though condition A110B of permit 8585 does specify pipeline natural gas fuel containing no more than 0.5 grains of total sulfur per 100 standard cubic feet.
Page 10 of the petitioner's SOI states that, quote, Mr. Snyder will offer the opinion that various permit conditions should be strengthened. What's your response to that statement?
As I explained, some of Mr. Schneider's proposed edits in Community EIB Exhibit 10 are outdated and irrelevant as they refer to an old draft permit rather than the final issued permit 8585. Some of Mr. Schneider's proposed edits were already addressed in previous testimony for the March 2021 hearing. The remainder of his suggestions were not proposed leading up to the March 2021 public hearing. However, I will address them later in my testimony today.
Page 11 of the community's SOI states that the department should commit to performing surprise inspections on the facility's operations. Can you respond to this?
Yes, this hearing is about a permitting action, and I'm testifying as an expert witness from the permitting section of the Bureau. I can say that 3 units comprise the compliance enforcement section at the Bureau: compliance inspection, compliance reporting, and enforcement. The compliance inspection unit implements appropriate inspections and investigations. The compliance reporting unit reviews various reports submitted to the department as required by permits and federal regulations. The enforcement unit uses the findings of these 2 compliance units to initiate and pursue various actions to bring alleged violators into compliance and to assess appropriate civil penalties for those violations. Actions may include a field citation, a notice of corrective action, or a notice of violation. Notices of violation typically include a required corrective action and a penalty assessed in accordance with the Bureau's civil penalty policy. For some serious violations, the department may issue an administrative compliance order or file a civil complaint in a state district court.
As a general matter, are changes to policies and regulations typically addressed in an individual permitting action like this one?
No. As far as regulations, 20.1.1.300.A NMAC is the citation that says any person may file a petition with the board to adopt, amend, or repeal any regulation within the jurisdiction of the board. That would be the avenue to propose a rule to the board that would require the use of newer technology, for example, as Mr. Schneider suggested yesterday. Requests for changes to Bureau policies or permit template language are typically addressed outside of an individual permitting action. On the Bureau's permitting section homepage, there's a link for permitting procedures and guidance. That link goes to the permitting procedures and guidance page, where the Bureau's permit templates and monitoring protocols are posted. There's also a description of the document change request procedure. It states, AQB welcomes collaboration from all stakeholders. If you would like to comment on permit template language or a monitoring protocol, please submit a tracked changes version with your requested changes to the permit programs manager. Add sufficient comments to ensure your point of view is well documented and your arguments are well presented.
Did the Bureau adhere to all the regulatory requirements for issuing permit 8585?
Yes.
Are the hours of operation and throughputs authorized by Associated Asphalt's previous permits the same as those authorized by permit 8585?
No.
I now refer you to Dr. Sahu's report submitted with the petitioner's statement of intent as Community EIB Exhibit 1. On page 2 of his report, Dr. Sahu states, quote, the AAM facility is already in existence, meaning the actual emissions of the facility as it operates in real time are readily available. Is this correct?
HMA number 5 has had an air quality permit to operate at 86 Paseo de River since 1997. But the entire facility, known as Santa Fe facility, authorized in permit 8585, is a unique facility that was not in existence at this location prior to issuance of permit 8585. Not all equipment in permit 8585 configured in the manner shown in the process flow diagrams in section 4 of application 8585 at the administrative record index 1 Bates 000034 through 37 was at 86 Paseo de River, operating in the same manner for the same hours of operation and with the same throughputs prior to issuance of permit 8585. Any changes to equipment, materials, parameters, and throughput at the Santa Fe facility authorized by permit 8585 make it unique from AAM's already existing separate facilities authorized by the old permits. Any testing results from the existing separately permitted facilities would not directly correlate to the new configuration of consolidated equipment and new operations authorized for the Santa Fe facility under Permit 8585.
Is actual source specific and real-time emissions data coming from the facility or from the facility's already existing operations? Is that a regulatory requirement?
No.
On pages 7 through 8 of his report, Dr. Sahu refers to an enforcement alert from the EPA. I guess we'll just go through this for the record. And what's the date on that document?
November 2020.
When was the first public hearing for application 8585, the administrative hearing that we have below?
It was scheduled to take place originally in May of 2020. The Bureau originally worked on arrangements for that public hearing to be held in May of 2020. Because of COVID, the hearing was postponed until October 15th of 2020. These original public hearing dates in May and October of 2020 were prior to November 2020, which is the date on the enforcement alert. The hearing was postponed 2 more times at the request of the Communities Council.
Does the enforcement alert from the EPA state there is no reason to rely on these factors, meaning AP42 emission factors?
No, it doesn't. Page 3 of the enforcement alert states, when source-specific emissions or other more reliable approaches are unavailable, AP42 emission factors may be the only way to estimate emissions. As I explained in my written direct testimony, AP42 emission factors have been developed by EPA and compiled from source test data, material balance studies, and engineering estimates. The department has provided evidence of several other agencies' acceptance of initial emissions calculations based on AP42 emission factors. Testing, monitoring, record keeping, and reporting requirements in Permit 8585 ensure and verify compliance with the emission limits in the permit. If AAM violates a permit condition or regulation, AQB can follow up with enforcement action. If emission limits based on initial calculations using AP42 emission factors are inaccurate, a permit revision may be required.
Page 5 of the community's SOI states, quote, AP42 factors are expressly unsuitable for calculating PTE emissions because they represent average emissions rather than maximums as required to calculate PTE, end quote. First, can you tell us what PTE is?
Yes, and I would like to reiterate, I said it when I was speaking to board members earlier. Again, this is a quote from Dr. Sahu, and I don't see in a search of the alert itself, I don't see this citation in the alert. But going back to the question, PTE stands for potential to emit, and it means the maximum capacity of a stationary source to emit any air pollutant under its physical and operational design.
And how is PTE calculated?
As I said in my direct testimony, the general equation for calculating emissions, or the PTE, is the activity rate or capacity multiplied by the emission factor. When the maximum capacity of the equipment is used in the AP42 equations, along with an approved emission factor, that's the representation of the maximum emission rate that would be expected for that type of equipment. None of the permitted capacities in Table 104A of Permit 8585 on pages 5 through 7 of NMED EIB Exhibit 16 are lower than the manufacturer's rated capacities in Table 2A of the application at Administrative Record 136, Bates 001419 through 1422.
Page 6 of Dr. Sahu's report states, quote, the record simply does not consider or even mention the rating of any of the AP42 factors used in the emission calculations, end quote. Are the ratings of any of the AP42 emission factors used in the emission calculations included in the emission, are the ratings of any of the AP42 emission factors used in the emission calculations included in the administrative record?
Yes, the ratings of all AP42 emission factors used in emission calculations are included in the administrative record. First, Section 7 of AAM's application includes a list of all the AP42 chapters with emission factors used to determine emissions. This list is at Administrative Record 1, Bates 000119. Printouts of each of those chapters are in Section 7 and include the tables with emission factors and emission factor ratings. Ratings of emission factors are included at Administrative Record 1, Bates 124 through 126, 132 through 134, 136, 141 through 145, 158 through 183, 187 through 196, 198, 202 through 203, 209 through 210, and 212. Second, my calculation checks include AP42 tables with emission factor ratings. Ratings of emission factors are at Administrative Record 5, Bates 350, 352, 364, 372, 374, 379 through 383, 402 through 405, 422 through 424, 426, and 428.
Page 10 of Dr. Sahu's report notes that there are no factors at all for primary and secondary crushing in AP42, table 11.19.2-2. Is this correct?
Yes, this is correct. Dr. Sahu's excerpt of the table on page 11 of his report does not include the footnotes for the table. Footnote N, as in Nancy, of table 11.19.2-2 states, quote, no data available, but emission factors for PM10 for tertiary crushers can be used as an upper limit for primary or secondary crushing, end quote. This footnote is circled and words underlined in my calculation checks at Administrative Record 5, Bates 000351. I also added a note about footnote N in my calculation checks at Bates 000355. Tertiary crusher data regarding release of particulate matter emissions is actually more conservative than primary or secondary crusher data would be, because tertiary crushing involves smaller sized aggregate that emits more fugitive dust when crushed. Unit CH is a horizontal shaft impact crusher and the only crusher at the Santa Fe facility.
On pages 22 through 23 of his report, Dr. Sahu notes, quote, the entire set of emission calculations are completely unreliable, end quote. And he describes AP42 emission factors as, quote, useless factors, end quote. Can you respond to that?
AP42 emission factors are not useless. New Mexico and other states do not have the resources to conduct the extensive scientific reviews and testing that EPA conducts. EPA's AP42 emission factors have been published since 1972. Since then, EPA has published supplements and updates to the 15 AP42 chapters. For 50 years, regulatory agencies across the country have been heavily relying on AP42 when source-specific emissions or other more reliable approaches are unavailable. In these cases, AP42 emission factors may be the only way to estimate emissions.
Page 23 of Dr. Sahu's report indicates, quote, all of the calculations for hazardous pollutants, or HAPs, contained in the record for this permit are grossly inaccurate, end quote. Do you agree with that statement?
No, I don't agree. Again, AP 42 emission factors were used to calculate these emissions. When source-specific emissions or other more reliable approaches are unavailable, AP 42 emission factors may be the only way to estimate emissions.
Okay, I want to go back to Mr. Schneider. On page 21 of Mr. Schneider's report, it states, quote, the permit allows up to 24 hours a day of exposure to this state toxic air pollutant. And in a parenthetical, it says asphalt fumes, end parenthetical, and other pollutants regulated by the Clean Air Act, end quote. Does permit 8585 allow up to 24 hours a day of operation?
It's a bit misleading the way he phrases it. The only equipment in permit 8585 allowed to operate continuously or 8760 hours per year is the asphalt cement storage tanks. Their operating hours are specified in condition A108B on page 12 of permit 8585. Allowable hours of operation for the crushing screening plant and scalping screen plant are limited to 7 a.m. to 5 p.m. daily per condition A302A on page 19 of permit 8585. Each generator and engine is allowed to operate only 3,650 hours per year per condition A304B on page 22 of permit 8585. Condition A401A on pages 25 through 26 of permit 8585 limits the asphalt plant's operation to 6 a.m. to 6 p.m. from December through February. This condition allows asphalt plant's operation any time of day from March through November, but the production limits in condition A401B on page 26 of permit 8585 put a cap on daily production rates. So if HMA number 2 is running at its maximum capacity of 150 tons per hour, and HMA number 5 is running at its maximum capacity of 300 tons per hour, they can each only run for 12 hours per day. The time of day of operations is flexible for the asphalt plants from March through November, but their daily production limits keep them from operating 24 hours per day at the maximum hourly throughputs.
On page 21 of his report, Mr. Schneider states, quote, I propose a permit condition that includes ongoing monitoring of the emissions coming from the facility in order to ensure community health is protected, end quote. Could you respond to his proposition?
I'll start by reiterating that primary national ambient air quality standards are health-based standards set by EPA to protect public health. The Santa Fe facility's operations, as represented in the application, do not cause nor significantly contribute to any exceedances of applicable air quality standards. Data loggers are required to continuously record sources are required in conditions A401C and A402A on pages 27 through 29 of permit 8585.
Okay, now I want to walk you through the proposed edits to permit 8585 suggested by Mr. Schneider. On page 22 of his report, Mr. Schneider states, quote, permit condition A101-A is unnecessary and potentially creates a conflict with the general condition B113, B113 A through C. How do you respond to his proposition?
Condition A101A on page 3 of permit 8585 is template language in all of the Bureau's NSR permits. It simply states that the permit is permanent unless withdrawn or canceled by the department. It does not conflict with conditions B113A through C. Conditions B113A through C on page 49 of permit 8585 specify when and how the department may cancel the permit.
On page 22 of his report, Mr. Schneider states, quote, "The permit should be amended to include an hourly allowable asphalt fumes limit for P2 HMASTK and P5 HMASTK along with an initial compliance test," end quote. Does permit 8585 include these requirements?
Yes, the final signed permit 8585 includes these requirements. The hourly asphalt fumes limit is one of the examples I discussed earlier, where it appears Mr. Schneider is looking at an older version of the draft permit rather than the final issued permit 8585. Condition A106B on page 11 of permit 8585 includes hourly allowable asphalt fumes limits for P2 HMASTK and P5 HMASTK. Also, condition A402B on page 29 of permit 8585 includes an initial compliance test for units P2 HMASTK and P5 HMASTK.
On page 22 of his report, Mr. Snyder states, quote, "I respectfully suggest they consult with the US EPA to determine the appropriate stack testing method for verifying."
Mr. Hearing Officer, I have to object to this because Mr. Schneider wasn't able to present any of this testimony yesterday. Mr. V. Hill said it was outside of the scope of the petition. So he hasn't been able to present any of this. He could present it as a rebuttal witness, but I think it's inappropriate that Ms. Prim respond to it before it's been presented.
Mr. V. Hill, you have a response?
Well, it's a fair point, but he was able to respond to quite a bit. I actually, if I remember right, I tried to stop him from testifying, and the ruling, if I recall correctly, was that he could go ahead and proceed, but just not on the grounds of modeling.
He wasn't able to specifically speak to any of his proposed permit condition changes. That didn't happen.
Yeah, Mr. V. Hill, I think we've gone beyond the scope of what Mr. Schneider was allowed to testify to. So
Okay.
the action will be sustained.
Okay, we'll move forward. We're just trying to find an appropriate place to jump back into this. I apologize for the delay, but we will be back in the game here in just a second.
Okay, take your time.
Mr. V. Hill, if I may, and Mr. Hearing Officer, Madam Chair, members of the board, I think the remainder of my rebuttal testimony is just responding to Mr. Schneider's proposed edits to the permit.
Yeah, I agree with that, Ms. Prim. And Ms. Prim, I have no further questions, and I'll pass Ms. Prim as a witness.
Okay, do we have cross-examination from the petitioners on Ms. Prim's rebuttal?
Yes, Mr. Hearing Officer. So let's see. You mentioned, Ms. Prim, that permit 8585. Well, let me ask it this way. If I heard you right, you said that AP 42 emissions factors were the only available data to estimate emissions from the associated asphalt operation. Is that correct?
Yes.
But that's not true, is it? There are existing stacks that could have been tested for emissions. Isn't that so?
I have not seen data from any testing on those stacks.
But you could have asked for it.
I'm not required to ask for it. They are not required to submit that.
So is it your position then, Ms. Prim, that the NMED accepts whatever garbage the applicant submits to you?
Objection, argumentative. It's an abuse of the witness. I think he needs to rephrase the question and just, I'd like to suggest getting rid of the word garbage.
Yeah.
Sure, absolutely.
Objection?
Yes.
Okay, please rephrase.
Yeah, is it your position that NMED accepts whatever information the applicant submits to you, irrespective of how inaccurate it might be?
It's my position that the department accepts AP 42 emission factors, and that's what the applicant used in their calculations.
Okay, so let's go to the enforcement alert. And I would like to share this one more time if I can. Can you see this, Ms. Prim?
Yes, I can, Mr. Jantz.
Okay. So you made a lot of hay out of the fact that this came out in November 2020. But this enforcement alert isn't anything new, is it?
I don't know. The first time that I saw it was when you brought it up at the March 2021 hearing.
Well, let's take a look at some of the operative language. As such, the permit limit using AP emissions 42 would result in half the sources being in non-compliance. That comes from AP 42, 5th edition compilation of air pollutant emission factors. And that's not new, is it?
No.
In fact, it's been around for some time, hasn't it?
Objection. If Ms. Prim gave some rebuttal testimony on AP 42, I think AP 42, gave testimony on this enforcement document, and I think using the enforcement document is fair game. But to start going into the sources of the enforcement document, my opinion is that it's outside of the scope of her rebuttal testimony.
And it's certainly not, because the assertion was that this was, or the implication was that this is new information. This is establishing that it's not.
She said she had never seen it before you brought it up at the March 2021 hearing. So I think she's responded that she doesn't have any knowledge of when it actually may have been under consideration. So I'm going to sustain the objection.
Okay. You made a lot of, you mentioned a lot about the enforcement, compliance and monitoring conditions in the permit, which is NMED Exhibit 16. Could you point me to where in that permit the NMED is requiring periodic stack testing?
I'm getting the permit. Please bear with me.
Sure. Take your time, Ms. Prim.
Okay, so you're asking for periodic
stack testing?
Stack testing. So let's see here. There is an initial compliance test for unit CH_E, which is an engine. There are also requirements, that's on page 823 of the permit, 585. There's also a reference.
Excuse me, Ms. Prim, can I interrupt for a second? That's the initial compliance test though, right? That's a one-time deal.
That's an initial compliance test. So just below that is a condition that points to subpart III. So it's 40 CFR subpart quad I. That also has requirements for the engine.
Okay, and Ms. Prim, can you tell us what those requirements are? Are there periodic actual emissions testing requirements in Quad I?
I would have to get back to you on the specifics of that, Mr. Jantz. I don't have Quad I in my hand at the moment. It does require that they do all of the applicable monitoring and record keeping and reporting per Quad I.
But that doesn't include actual emissions testing, does it?
As I said, I don't have Quad I in my hand, so I'd have to get back to you on that.
Okay.
Condition A305A on page 24 of the permit is the condition for the equipment that's subject to 40 CFR 60 subpart 000 that has an initial compliance test as well as periodic compliance tests.
And do those periodic compliance tests include actual emissions monitoring, like a stack test or SEMS?
Those require opacity tests. I'm sure that SEMS is not required.
Okay. And again, opacity test is just whether it's cloudy or not.
Right. It's a quantification of particulate matter.
But that
requires, I'm sorry?
Yeah, that's only under method 9, right?
Let's see.
I mean, you heard Mr. Feather testify earlier this afternoon that method 22 only monitored the presence of opacity.
I did hear Mr. Feather. I'm looking at the condition and it points to the procedures in 40 CFR 60.11 and reference method 9.
And where was this again, Ms. Prim?
This is in the 000 condition, which is A305A on page 24 to 25 of the permit.
Okay, and 000 requires method 9 is what you said?
I said it requires, it says compliance with this condition shall be determined by opacity test observations conducted in accordance with the procedures in 40 CFR 60.11 and reference method 9.
Okay.
Continue. There's also the initial compliance test for the drum dryers and mixers.
And again, that's an initial compliance test. It's not ongoing.
That's
objection. Mr. Hearing Officer, Ms. Prim did not testify to this in her rebuttal. This is outside the scope of her rebuttal.
She most certainly testified to the conditions that allegedly prevent NAAQS violations. So I ought to be able to cross-examine her on those conditions.
Well, I think the burden is on you to demonstrate that. I'm saying no, she didn't testify to it.
Well, we can play back the tape if we like.
I think I believe it generally falls within the scope of what she testified about. So let's proceed.
Thank you, Mr. Hearing Officer. So please continue, Ms. Prim. Aside from that aside from that initial compliance test, are there any other ongoing periodic tests, monitoring conditions that would require actual stat data or SEMS data or anything other than opacity and baghouse pressures?
Method 5, which is referred to in subpart I, does determine particulate matter concentration, sampling time and sample volume. It gives a 60-minute duration for the test run. So subpart I requirements are part of this permit.
And I'm sorry, Ms. Prim, can you show me in the permit where subpart I is required on a regular basis, other than just the
Sure.
Go ahead, please.
So A402C on page 30 of the permit is the subpart I requirement for the drum dryer mixer equipment, and A403C on page 32 to 33 of the permit is the subpart I requirement for the mineral filler silos.
Okay. And is there anything in this? So subpart I doesn't contain any provisions that require periodic testing at all. It just outlines the process. Can you point me to a place in this permit where? And by the way, I just want to draw your attention to the fact that, well, never mind. Can you point me to the place where NMED requires that it requires periodic testing using subpart I?
I just gave you the conditions for the subpart I requirements. Would you like me to?
Sure. No, my question was subpart I. Well, let's look at subpart I. And give me just a second.
Okay.
Okay, I'm going to share subpart I. And would you take a minute to read this? It's very short. It's only 4 sections.
So under 60, so you'd like me to read starting at 60.90?
Well, yeah, yes, let's do that.
Okay. Applicability and designation of affected facility. The affected facility to which the provisions of this subpart apply is each hot mix asphalt facility. For the purposes of this subpart, a hot mix asphalt facility is comprised only of any combination of the following: dryers, systems for screening, handling, storing, and weighing hot aggregate. Oh,
sorry about that.
That's all right. Systems for loading, transferring, and storing mineral filler. Systems for mixing hot mix asphalt, and the loading, transfer, and storage systems associated with emission control systems. Part B, any facility under paragraph A of this section that commences construction or modification after June 11th, 1973 is subject to the requirements of this subpart.
All right, and let's just skip the definitions. We know what a hot mix asphalt facility is. Okay, let's take a look at 60.92.
Okay, standard for particulate matter. On and after the date on which the performance test required to be conducted by 60.8 is completed, no owner or operator subject to the provisions of this subpart shall discharge or cause the discharge into the atmosphere from any affected facility any gases which, 1, contain particulate matter in excess of 90 milligrams per dry standard cubic meter, or 0.04 grains per dry standard cubic feet, or 2, exhibit 20% opacity or greater.
Okay, so looking at this, the performance test required to be conducted, where in the permit, aside from the initial compliance test, is a performance test to be conducted? Where is this in the permit? Which condition is this?
So the two conditions I cited in the permit that refer to subpart I point to the requirements in this subpart I that we're looking at right now.
Okay, and so is it your position then that this condition means that Associated Asphalt is required to continuously monitor its stack emissions from the drum dryer mixers using method 5?
It's required to follow the test methods and procedures that you're scrolling through right here at 60.93. Including method 5.
Okay.
Says method 5 shall be used to determine the particulate matter concentration. Sampling time and sample volume for each run shall be at least 60 minutes, and 0.90 dry standard cubic meters, 31.8 dry standard cubic feet.
Yeah, and what I'm trying to get at, Ms. Prem, and maybe we can just see if you can answer this, is I want to know the frequency of those of using method 5, which is a stack test.
Then we should look at method 5.
Okay, let's take a look at method 5. I'm going to stop sharing and this and start sharing method 5. Okay, here we have method 5. And it's not short.
No, it's not, which is why it's not in the permit. The permit points to the federal requirement, which includes the method reference test.
So do you have a sense of where schedule of sampling is in method 5?
I don't have that at my fingertips, no.
Okay. Well, I'm scrolling through here, Ms. Prim. Maybe we can go through this together and you can stop me when you think we've got to the point, that point. We have section 1, scope of application. You see it there?
No.
Summary of method. That's clearly a method, right?
Yeah, that's important there. That's explaining how the method is carried out.
Sure, of course.
So that specifies.
This specifies equipment and supplies used to do the test.
You just scrolled past the specifics I was trying to read out, but
sorry, go ahead.
So that 2.0 is the summary of the method. Particulate matter is withdrawn isokinetically from the source and collected on a glass fiber filter, maintained at a temperature of 120 plus or minus degrees Celsius. I can go on, but these are the specifics that are in the method. that is
Right.
part of Part I, which is part of the permit.
Right, of course. And so that's essentially telling the operator or whoever's doing the testing a summary of the test. What's isokinetically?
I'm not a chemist. I don't know the answer to that off the top of my head.
Okay. All right, safety. It's not there. So this talks about equipment and supplies, what you need for sample collection under method 5, right?
Right.
Sampling train. Does it say when? Does it?
So I think nothing in the method specifies the actual requirements for when it's used other than specifics to the method. So 60.92 that we were looking at in subpart I states on and after the date the source must comply with the 2 listed criteria. So yeah, we're back to
when it happens, when these stack tests, and method 5 is a stack test, and is that right?
if you scroll back up to, was it 2.0? There's a
2.0.
description of the method. So it's withdrawn isokinetically from the source and collected on a glass fiber filter.
That implies that you're collecting the actual particulates from something, right?
Right. So yeah, you're collecting. So 60.92 is about the standard for particulate matter. So it's like I read to you earlier, on or after the date on which the performance test required to be conducted by 60.8 is completed, no owner or operator subject to the provisions of this subpart shall discharge or cause the discharge into the atmosphere from any affected facility any gases which contain particulate matter in excess of 90 milligrams per dry standard cubic meter.
And what I'm getting at, Ms. Prim, is how do we know that in the day-to-day operations of the associated asphalt plant if there are no continuous monitoring requirements? Or even periodic monitoring requirements of actual emissions.
So let me look here. The permittee, so in the condition in the permit on page A30, it says the permittee shall comply with the reporting requirements of 40 CFR 60 subpart A and subpart I.
Okay.
So subpart I is a federal regulation that they're subject to, and they have to report on their testing requirements in that federal regulation. So that's also part of this permit. We pull in the federal requirements into the permit.
Right.
So that's part of the reports that go to our compliance and enforcement section.
Right. Sure, but the requirements of method 5, which are incorporated in subsection I, don't talk about the timing of these stack tests, these actual collection of particulate matter, do they?
I'm not sure. As you're seeing here, method 5 is mean, this is a 40-page document. So the operators are required to follow the requirements of this regulation, and it's referenced in the permit as a requirement that the operator must abide by.
Okay, so you can't point to anything in method 5 right now that requires that the permittee follow the process outlined in method 5 on any regular schedule or continuously. Is that what you're saying?
I don't, without more time to look at method 5 specifically right now, I don't have those numbers in front of me, but I think the answer, so you're bringing up periodic testing as if it's the only way to demonstrate compliance, but really the answer is related to all the other continuous monitoring requirements throughout the permit as well, including for the bag houses, the engines, the temperature of the asphalt material, the asphalt cement tanks, the throughput monitoring, and the method 22 and method 9 requirements. All of that, everything in the permit is built to have the permittee demonstrate compliance. Periodic testing on its own is not the only way to show compliance with the emission limits in the permit.
But it's the only way to get actual emissions data, isn't it?
Well, the initial compliance tests give data. The data loggers give data.
Excuse me, Mr. What do the data loggers give data about? Not emissions data, is it?
They give data about how well the control equipment is operating, which is really important because if you look at uncontrolled emissions in table 2D of the permit compared to controlled emissions because of these bag houses, the bag houses are critical in demonstrating compliance with their emission limits.
Okay. Okay, are there any other emissions compliance or monitoring requirements that in here that are there any that require actual emissions data? Aside from the initial compliance test.
Well, there are visible emissions tests. There's for the engines, there's the quad I requirements. There's the quad Z requirements.
And what do those require actual emissions testing from these engines?
Objection. This question's been asked and answered. I understand that he's looking for a specific answer, but Ms. Prim has given her answer. I think it's time to move on.
Well, Mr. Hearing Officer, if Ms. Prim doesn't know, Ms. Prim can say she doesn't know. Mr. V. Hill doesn't get to say when I get to move on. That's your prerogative, Mr. Hearing Officer.
I think that Ms. Prim has stated she doesn't know off the top of her head. And
okay.
She would need to look to get that information. So I'm going to sustain the objection, and let's move on. I note that it is 5 o'clock. It's time for public comment. Mr. Jantz, do you have, how much more questioning do you have?
One more question.
Okay, let's do that, and then we'll go to public comment.
So going back to your testimony about AP 42 emission factors and their ratings, you listed a bunch of ratings in tables that are referred to in the permits, right?
In the application.
In the application, okay. And you testified earlier today that you didn't know off the top whether any of those were A or B rated. Is that right? Am I recalling that correctly?
They're all in the tables, and I look at the tables as the references. So while I'm checking the calculations, my calculation checks are clearly in the record. I don't have those memorized.
Okay.
So don't, like if you ask me a specific emission factor from chapter 11, I don't have it memorized what the rating is.
Okay, and in the application, there wasn't any information about the data behind those emission factors. It's just the tables. Is that right?
No, the chapters are provided in the application, the full chapters from AP.
Oh, is that right?
Yeah.
And you reviewed those?
Yes, so in this specific permitting action, my job was to check the factors and check the calculations, and I did that. The background data is available for anybody to look at. It's in those chapters. I don't read the entire hundreds of pages of background information every time I process a single permitting action, but that information is there, and I do look at the specific factors every time that I process a permitting action.
Okay, but you didn't look under the hood, so to speak, by checking the data behind them.
Well, I checked the emission factors and the data is there. Dr. Sahu, for example, referenced some information but left out a footnote. So even when you're looking through these factors, you're not looking at every single word of the entire chapter while you're assessing the emission factors every single time you do a permitting action.
Okay. All right. Thank you, Mr. Hearing Officer. Thank you, Ms. Prim. That's all I have.
Thank you, Mr. Jantz.
The department has no rebuttal, redirect.
Okay, thank you, Mr. Vigil. We still have questions from the public and the board members, but on her rebuttal. So we're gonna turn at this point to public comment. We'll take that if there is any, and we'll come back for questions on Ms. Prim's rebuttal. And I'm going to ask the host if we have any persons signed up to give public testimony during this session.
Mr. Hearing Officer, no one has reached out in the chat or through email to make general public comment.
Okay, thank you for that. In that case, we will go into.
Excuse me?
Yes, Ms. Marianella.
I am so sorry. Please forgive me for interrupting you. I know that there's someone here who wishes to make a comment because they contacted me earlier today. His name is Michael McCoy, and I think he just didn't understand that he needed to let Ms. Jones know that he would like to make a comment.
Well, can you ask him to contact Ms. Jones right away? And we'll work him in here in a few minutes.
Yes, thank you very much. So Mike, if you just go into the chat, you can just say that you would like to make a public comment, and then Ms. Jones will arrange that for you with Hearing Officer Virtue.
Ms. Jones, will you please let us know when you hear from Mr. McCoy? We'll just
Yes, sir.
here, see if we can get this done right now.
Mr. Hearing Officer, I also see someone's hand up. I'm not sure if that's intended for public comment or not. It's a screen with the name Rhea.
Oh, okay, I don't see.
She just chatted that she would like to speak, and I was just asking what her last name was for the record. But I see her online, and she does have her hand up.
Okay, I don't see her. She must be on the next page. Let me see. Her name is Rhea.
Yes.
Did you let her in?
She is on the screen and she has her hand up.
Well, oh, okay, I see her. Okay, thank you. Okay, Rhea, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Please give us your comments.
I'm part of the call today in support of the appeal for the reversal of the New Mexico Environment Department's decision and reconsideration of the air quality permit. I would like to make 3 points. First of all, allowing the asphalt plant to be located next to a residential area will be detrimental to that community's health, welfare, and safety. And as it's been mentioned by other commenters, the emissions from the asphalt plant will exacerbate already pre-existing health conditions in that community. And finally, approving the asphalt plant seems to me to be contrary to the governor's 2019 climate initiative. And in that climate initiative, it talked about the reduction of harmful pollution for communities. And there's also, initiatives from other departments in the state of New Mexico focused on diversity, equity, inclusion, and justice, such as the New Mexico Economic Development Department. So just based on the, the climate initiative to reduce and to reduce harmful pollutants in the air and to improve air quality for all New Mexicans, and also to, other initiatives that have been part of our state government to increase, equity. Based on those two policy considerations, I am, as I said before, in support of the appeal for the reversal of the NMED decision and the reconsideration of the air quality permit. Thank you.
Okay, thank you, Rhea. Are there any questions for Rhea? Okay, hearing and seeing none. Ms. Jones, are there others? It looks like there may be others who wish to testify.
Yes, we have Michael McCoy. He is now on screen, and if he would unmute, he'll be able to make his comment.
Well, I'm not seeing Michael McCoy on my screen.
He's present.
Mr. McCoy needs to unmute himself, I think.
Yes.
Well, I'm not. Oh, Mr. McCoy. Okay, Mr. McCoy, I see you. I see you. I found you. Okay, Mr. McCoy, are you unmuted?
I am.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. Please proceed.
Okay. Rather than duplicate Rhea's comments, I would just simply say that I agree with them and I support that position. I am not a resident of the South Side. I'm a resident of the Northeast Side. And I think it's important that the city come together with this argument and attempt very strongly to stop the pollution in the South Side. It's important for our citizens that we not have a polluting company in our residential areas. So with that, I just simply want to again reiterate my support of the commentary from Rhea and from the people here that are attempting to stop this pollution.
Okay, thank you, Mr. McCoy. Are there any questions of Mr. McCoy? Okay. Seeing and hearing none. Ms. Jones, do we have anyone else who wishes to testify?
Yes, Mr. Hector Avildano would like to speak, and he is on screen. If he would unmute.
Yes, can you hear me?
Yes.
Yeah, I can. Mr. Alvedano, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, proceed.
Hello, everyone. My name is Hector Avildano. I'm a case manager for Fathers New Mexico. I work in the Santa Fe area. I grew up in Espanola and now live in Albuquerque, but for the past 15, 20 years, I've worked in Santa Fe. And for the past few years, I've worked with nonprofits and organizations that advocate for families, mostly immigrant, low-income families, mostly on this part of town, on the south side. So I would like to also agree with the comments that just went before me in support of the appeal of this permit. Because I work here every day in this area with families from this area, and I don't feel like there was enough outreach to the families and to the community here. I didn't hear anything on this issue like on the radio, or I didn't hear any announcements for public comment. And I don't feel like it was, I mean, even for me, it was hard to get onto this meeting now. It took me a couple minutes, so I can only imagine like people that live on this side of town, like single moms or working dads that don't have access to this technology or are working at this time still. So that's why I support the appeal of this permit, and also all the environment risks that there is and health issues. So that's my comment, and thank you for allowing me here tonight.
Thank you, Mr. Alvedano. Are there any questions for Mr. Alvedano? Okay, hearing none. Yes, Ms. Marianello.
Yes, hi, Mr. Avedano. I just was wondering, how did you find out about the hearing? And how did you manage to get in contact so that you were able to provide this comment today, since so many other people appear to be having difficulty doing so?
Yeah, I heard about this through, I work with several different organizations here in Santa Fe. One of them is EarthCare. So they sent out the announcement and the information for this meeting.
Okay, any other questions for Mr. Alvedano? Okay, we will go back to additional questions of Ms. Prim on her rebuttal from the public and board members. Let's do that. I want to do that, and then at that point, we'll discuss whether we want to adjourn for the day, come back tomorrow, or keep going tonight. So, Ms. Prim, are you there? Yes, you are.
I'm here, Mr. Hearing Officer.
Oh, okay, thank you. Are there any questions from members of the public of Ms. Prim regarding her rebuttal testimony? Okay, hearing none and seeing none. Do the board members have questions of Ms. Prim regarding her rebuttal testimony? Ms. Davis.
Thank you. Ms. Prim, I believe I asked a question along the lines of if the facility had periodic testing, or if it was just the initial test. And after the, and I admit there was times when it was difficult to follow Mr. Jantz's cross examination there. It sounded like there was a mechanism to have inspections, but there wasn't a schedule for inspection, for periodic inspections.
So this facility is a synthetic minor 80 source. So that's one of the categories. There's major source, there's minor source, there's synthetic minor source, and there's synthetic minor 80 source. So being flagged as an SM80 source has implications as far as the frequency of testing from our inspections team. They're required to be inspected at least once every 5 years. Just in general, the entire facility as an inspection. Within the permit itself, the There are inspections required throughout the permit in the conditions. A lot of them are visible emissions or opacity inspections. Some of them are inspections of the proper operation of the wet dust suppression system, or the looking at the integrity of the control equipment, the bag houses, for example. So there are inspections throughout the permit. So specifying period, I think that what Mr. Jans was getting at was stack testing and specifically. And like we were saying, I was saying earlier, I think I said it yesterday, the fugitive emissions make up the bulk of the emissions at this facility, and fugitive emissions are not from stacks. So a lot of the requirements in this permit are for visible or visual inspections. And there are a lot. This permit has been available since March of 2021 for the citizens and for any interested parties to look at. It's a long permit and there's a lot to it, so it's hard to put it in a nutshell. It's got a lot of pieces, and initial compliance tests are part of it. Ongoing data through data loggers that are recording the pressure gauge, which implies how well the bag house is operating, or data loggers that are recording the temperatures of the asphalt material. Those are both ongoing and continuous. So there are a lot of different ways for the permit to show demonstration of compliance with the limits in the permit. As far as stacks, that's harder to do with hot mix asphalt or construction industry, because most of their emissions are fugitives.
Okay, in the interest of time, let me rephrase that question. I understand there's multiple types of inspections going on. What's the frequency that any inspection would be going on at a time?
Well, some requirements are daily, some are weekly, some are monthly. They're specified in the permit. Yeah, for water sprays, for example, if there are visible emissions, or if it's clear that fugitives are not being controlled, then they need to act immediately. So it depends on the condition, it depends on the type of equipment, it depends on the pollutants, the frequency of inspection. Some of it is continuous.
How long would it take for NMED to become aware of being out of compliance, or the facility being out of compliance? I mean, you mentioned 5 years, which I assume is the long interval, but how long would it take for you to become aware of a non-compliance issue?
That's a good question. We do have a reports section in our compliance and enforcement unit. Reports are required as well throughout this permit, and the frequency of those also varies. We also we take complaint calls. We have someone available by phone to take complaint calls if people see that there are visible emissions and a facility is clearly not complying with the operations as they laid out in their application and as their permit requires them to operate under. People can call and complain, and an inspector can go out and see the site when appropriate. Violations are potential. We have, within the state, sometimes that can take a while if it's a remote location, but we're right here in Santa Fe. We have inspectors here in Santa Fe. So we can go to the site if there are complaint calls as well.
Okay, thank you for answering those questions for me. I don't have any more at this time.
Thank you, Vice Chair Davis.
Mr. Honker.
Yes, just one question, Ms. Prim. We've been talking a lot about AP 42 emission factors. How common is it to use AP 42 emission factors in a permitting decision?
Thank you, Member Hunker. That's a good question. It depends on the type of facility. For asphalt facilities and for crusher facilities or construction facilities, AP 42 emission factors are used in every construction application, construction industry application that I've seen. AP 42 emission factors are used. There are some oil and gas facilities that may not use AP 42 emission factors. They might have engines that have manufacturer specification sheets that give emission factors within the manufacturer specifications. So in that case, they would use that data, which oftentimes for engines it's more accurate because it's actually lower typically than what AP 42 factors for engines would give you in a calculation. So it depends on the facility, but bringing it back around to this facility, for asphalt and for crusher equipment, AP 42 factors have been in every application I've seen.
Okay, thank you.
Thank you, Member Honker.
Hey, it is Chair Sweeney appears to have her hand up. Sweeney.
Yes.
Okay.
Yes, Mr. Hearing Officer, thank you. And thank you again, Ms. Prim, for your rebuttal testimony. So I want to swing back around to these fugitive emissions that you spoke about a few minutes ago. So are fugitive emissions, is there a way to measure those? By definition, right? They're fugitive.
Right, they are fugitives. So there's not a stack test for those. So yeah, that's why AP 42 factors are what we use to do the emissions calculations on those types of emissions.
Thank you for that, and that was going to be one of my follow-up questions. So it's only AP 42 that does account in the modeling for those fugitive emissions. Is that correct?
In the modeling for this facility?
Yes. I apologize. Yes.
Yes. Thank you, Madam Chair. The calculations done for this Santa Fe facility were all done using AP 42 emission factors, and the calculations resulted in the emission rates, the pound per hour and the ton per year values that are the emission limits in the permit. And those emission rates were also one piece of the inputs that were put into the modeling for this facility.
Thank you, Ms. Prim. So I'm trying to get my head around if there's monitoring requirements that you shared with us a few minutes ago within the permit, but those are related to equipment or stacks. How are we, and as you stated a few minutes ago, if the fugitive emissions are probably those ones that are going to cause some of the air quality issues, how does the state determine compliance if those are not easily measurable to ensure compliance? after the permit is approved.
Okay, thank you, Madam Chair. So the permit itself has monitoring, record keeping, reporting, testing requirements to demonstrate that they are operating properly, that they're operating the way that they described in their application. And that's what those emission factors and those emission rates are based on, is proper operation. So the monitoring requirements, the record keeping requirements, reporting requirements, if those are being violated, if the pressure gauge is not in the range that it's supposed to be, or if the water sprays are not being used the way they're supposed to be, which are laid out and described, the requirements for operation are in those conditions, then not operating in accordance with those requirements is failing to demonstrate that they're complying with the limits and with the modeling that's based on those limits.
Thank you for that. And maybe a follow-up question is there any mechanism in the permit or permit process or renewal mechanism that if additional processes or procedures in the future were developed to address some of the concerns brought up in the alert from EPA, is there ability for, I don't know, is there that mechanism? Maybe that's my question. Is there a mechanism? Is there a permit, just so I can get my head around, is there a permit review process where maybe in 5 years, 10 years, that they would come back and say, oh, we're going to review whatever AP 42 adjusted process to account for these, or to assess or further analyze the potential fugitive emissions?
Right. So if the permittee modified their operations and had to come in to get a significant revision to their permit, then that permitting process would be would pull in the guidance and the regulatory requirements at that time in the future. So if there were policies or guidance or regulations that came to fruition from this alert in the future, and the permittee was modifying their permit, they would be held to those requirements at that time. Now, if they didn't come in for a significant revision, in other words, if they just kept operating under this permit and did not modify anything as far as their equipment or emission rates or requested throughputs, then if there was an enforcement case on this facility, for this facility, then again, I'm not a compliance enforcement specialist, but there are penalties and violations and consent decrees, things like that, that are pursued through the enforcement section. And perhaps that would be an avenue to pull in requirements if there were changes to policies or guidance or regulations between now and that time in the future.
Thank you for that, Ms. Prim. Appreciate your responses, and Mr. Hearing Officer, that's all I have for now.
Okay. Ms. Garcia.
Mr. Hearing Officer, I just have one quick question, Ms. Prim. Could you tell me just generally how many hot asphalt plants are in Santa Fe County? How many have been permitted generally? You have a ballpark?
I don't know. I would guess 5, but I really don't know. There aren't that many. A lot of hot mix asphalt plants are GCPs. They come in under a general construction permit. This may be the only one. It's the only one I'm aware of in Santa Fe that is not a GCP that's operating. But that's just ballpark.
Great. And thank you so much. And I must say, you've done a great job. You've been on the hot seat a long time today, and you've done a great job answering questions. Thank you very much.
Thank you, Member Garcia. I'm happy that you all are asking the good questions. And again, our goal is to be transparent and give you as much information as we possibly can for you to make your decision. So thank you for all your questions.
Any additional questions from board members? Seeing none, Ms. Prim, you are excused with respect to your rebuttal testimony.
Excuse me, Mr. Virtue, would you entertain a question from a member of the public?
Yeah, we're not on that point of the hearing process, but if someone has a point they'd like to make briefly, we will certainly allow. Is that Mr. McCoy with his hand up?
It is.
Okay, Mr. McCoy.
My apologies for understanding or having understanding problems with the permit, but one of the comments I saw on the screen was that they would be interested in collecting the condensates, particulate condensates, above a certain temperature. And does that interpretation mean they're not interested in collecting condensates below that temperature? Because in reality, things don't condense at a higher temperature, they condense at a lower temperature.
Can you answer that?
I'm not sure which thing you're referring to. Was this in Mr. Jantz's cross-examination?
I came on board and there was a shared screen in which they were talking about particulate matter and the filter system. And it was part of the text. And it simply said you'd be interested in collecting condensate above a certain temperature. Does that mean that you're not interested in collecting condensate below a certain temperature? Because that's where all the particulate is.
Okay, thank you, Mr. McCoy. So I think that you're referring to, we went down kind of a path. The permit has a condition that refers to a federal regulation called Subpart I. And Subpart I refers to a reference test method from EPA, Method 5. And I think that within Method 5 is what you're referring to. So that's a federal requirement, a federal regulation. I can say that with asphalt, the temperature is important because if you get too high, more fumes are released. So there are limits to the temperature within the permit that are limits based on what was represented in their emissions calculations. So perhaps that's why Method 5 speaks to a higher, an upper limit for the temperature. Again, that's a federal regulation, so that's not something that I wrote that I can specifically answer, but that's the information that I have as far as the relevance of temperature at a hot mix asphalt plant.
My point is simply that condensation occurs below a temperature, not above it. So if you have a temperature above which you are only monitoring condensate, does that mean that you are not monitoring condensate below that temperature?
The operator would need to follow the guidelines and the specific steps that are outlined in that method 5. So if method 5 says monitoring at a specific range, then that's what the operator would be required to do.
Thank you.
Thank you, Mr. McCoy. And thank you for participating. Thank you for being here.
Okay, Ms. Prim, I think you are excused with respect to your rebuttal testimony. At this point, I'd like to have a discussion about where we proceed from here. What we have remaining is the remainder of the rebuttal from the department, which is basically Mr. Peters' rebuttal testimony. And then we have the petitioner's rebuttal testimony, which, as I understand, is Dr. Sehu and 2 other persons, which whose names I don't think I've been given, but we have 3 witnesses. So the options, as I see it, basically we could continue, take a short break here and continue this evening and accomplish as much as we can and come back tomorrow to finish up. Or we could adjourn now and just come back and finish up tomorrow. We'll have to come back tomorrow anyway for Mr. Sahu, Dr. Sahu's testimony. And I'd like to leave that decision up to the board. I think in my mind, it depends on the board's, what's more convenient for the board in terms of its availability and fatigue factor. Does anyone from the board want to initiate the conversation? Ms. Davis.
I would just like to say, at least for myself at this point in the evening, I think it would be best that we adjourn and come back tomorrow. We've had a pretty full day here, so we have to come back tomorrow anyways.
Mr. Hearing Officer, this is Chair Sweeney. I was all maybe I wanted to have a question of how long. I know we've had a lot of questions, but how long does the petitioner and NMED feel like the testimony will be of their witnesses tomorrow, or the remaining witnesses?
Well, I'll ask counsel for those 2 parties to answer that question. Mr. V. Hill, you have 1 rebuttal witness left. That's Mr. Peters. Do you have an estimate you can give us the amount of time?
Yeah, I think we have about a half an hour of rebuttal left, and then we're done. Then of course, there'll be cross-examination after that.
Yeah, half an hour rebuttal. Okay, petitioners, can you give us an estimate of your rebuttal?
I would bet each witness would be about 30 minutes or less in their direct rebuttal, Mr.
Okay.
Mr. Hill. Oh, sorry.
Go
Thank
ahead.
you, Mr. Hearing Officer. Yeah, with that, I think I support Vice Chair's recommendation. If there's not super long testimony, I think we can get everything done tomorrow. But
Okay.
I also would love to. I'd also love to hear from the other board members.
Any comments from the other board members?
Yeah, I concur with the chair and the co-chair.
Okay. And then we got Ms. Garcia.
Yes, it sounds like it would not be a full day tomorrow, so I think we can probably get through all this tomorrow morning. So I vote to go ahead and adjourn tonight.
Okay, I'm seeing Mr. Honker nodding yes. Mr. Bitzer's giving a thumbs up. So I think
thumbs up.
and Mr. Cates is giving a thumbs up. So I think we have a unanimous decision from the board here. We will adjourn for the evening and reconvene at 9 o'clock in the morning. Thank you.